Thank you so much. Again, apologies for being late. I really had this scheduled, but some unforeseen circumstance came up and I wasn't able to make it on time. But with that being said, I'm here. I really want to send greetings from the Construction Industry Council. We believe that dispute resolution is a very important topic, especially as it relates to the pandemic that we are facing. And so I know for our members, we are looking forward to everything that will be discussed at this time. So thank you all for having us. Thank you for inviting us. And we are very excited about this session.
Thank you very much, Mr. Taylor. Colleagues, the whole notion of ensuring that, especially in light of catastrophic events, business continues is something that the Caribbean in particular and other SIDS understand all too well. Our training, of course, comes from the background of hurricanes and to a lesser extent earthquakes. But that type of disruption, fundamental, pervasive, sometimes heartbreaking, as in last year and the year before, has put us in a unique position, I think, to understand the implications of deep-seated disruptions in business and supply chains. And what I would like to do now in the question and answer session is to explore with you in greater detail, using perhaps the presentation of Dr. Deans as the initial background, how it is that we address these twin realities. Business continuity, making sure that despite disruption, business continues and the economy continues. And the restoration of supply chains, which have been savaged. In this section, I'm going to ask that you continue to mute yourselves when you're not speaking, and that when you do speak, you give us your name and your organization for the purposes of identification and record keeping. If you happen to be having any issues with your microphone, remember that you can use the chat to send in questions or comments, and I will try to be alert and faithful to those messages. So colleagues, the floor, so to speak, is now open. And if you just indicate to me, I will recognize you and we can commence the Q&A. I don't see any hands up. Jose, at the risk of being accused of laying hands on you suddenly, we missed from this panel the multilateral perspective that we were hoping that Therese would have brought, given her incumbency at the IDB and her prior experience at the International Monetary Fund. But from the sort of UNCITRAL perspective, is there anything that you might want to bring to our attention in relation to the challenge of business continuity and maintaining supply chains during events like COVID? Okay, I'm not hearing Jose. I see his name still on the list, but perhaps he's not hearing me. I'm going to ask the Secretariat to just liaise with the Minister. He's attempting to get on, but is not having much success. Alexandra Johnson has her hand up. Could you unmute her and allow her to ask her question, please? Go ahead, Alexandra. Alexandra, I'm not hearing you. Perhaps you can indicate in the chat what your question is, and I'll repeat it to our panelists. I've seen a question from Alexandra, and I think Gashua Mola also from Ethiopia wanted to ask a question. Let's see if we can pick them up. But while we're trying to sort that out, in the meantime, Dr. Dean, the whole issue of maintaining supply chains, of course, operates at two levels. If not more. You're talking about maintaining the international supply chains that moves goods and services between countries. But there would have also been disruptions in local supply chains, which we saw affecting particularly our farmers. Would you care to give us your insight in that regard?
Yes, thank you, Milton. So there were disruptions that occurred both on the international level and domestically. And I'll give you an example of some of the things that happened in the SEZ space, which we did from a business continuity perspective. And maybe the participants in this conference can look at where conflicts can arise in some of these instances, not just as it relates to suppliers and consumers, but also to the workers involved in carrying out those activities. So we had a situation where the government imposed certain curfews and quarantines. In one case for an entire parish of St. Catherine, and prevented the movement of people during daylight and nighttime hours. As a result, businesses in the special economic zones, in order to continue their operations, were required to implement what was known as work from home initiatives. What that meant was workers were allowed to perform their activities from home just as if they were in the office. For that to happen, you needed to ensure that they had their proper equipment, they had the appropriate internet services at home, and the appropriate security measures were in place to prevent access by illegal operators to the information that was being transferred. So in that situation, from a SEZ perspective, there had to be mechanisms put in place to allow, for example, companies in the BPO space to move equipment which came in duty-free, to leave the special economic zones and go to their workers' homes, there had to be mechanisms put in place to protect the information of the customers. We also saw that the activities taking place in the zones had tremendous impacts. Oh, I'm getting feedback.
Yeah, there's a feedback.
Yeah, somebody has their mic on.
Panelists and participants, whoever is not speaking, please mute your mic. Continue, Dr. Lee.
Yeah. No, the feedback is terrible. Hello, Milton, can you
Mr.
mute all
Taylor,
your voice?
Mr. Taylor, can you mute your mic? Let me see if that one, that is one of the mics that's open. Could you mute, please? I'm really sorry about this, Eric. I'm not sure what is causing the feedback. But I think you had best continue, and we'll just have to do the best we can to hear you.
Okay, let me try. So, in terms of business continuity, boy, this is difficult.
Milton, maybe Christopher Malcolm can try to mute everyone as the host. Chris, if you mute everyone and then have Eric unmute himself.
Yeah. Chris, as host, could you mute everybody, please? Nordia, if you are there and able to do so, could you mute everybody, please? And you can unmute Dr. Dean so you can continue.
Hello?
Okay, go ahead.
Hello, can you hear me now? Hello?
We hear you.
Okay.
Go ahead, Eric.
So what I was saying was that the operations within the SEZs had to continue under a work from home initiative approved by the government. As such, that allowed financial institutions, that allowed companies that were providing essential services, both to domestic companies and international companies, to continue. The risks that were faced, particularly by the workers, was in any instance where they would have resulted in any loss or damage to the equipment that they carried home, or if there were any information breaches that occurred that would affect the client's relationships of the companies practicing the work from home operations. But in terms of business continuity, we saw that by implementing the work from home strategy, which is a digital strategy, it enabled certain operations to continue. But however, we have to bear in mind that everything is not just services. Goods still had to move. So mechanisms had to be put in place to ensure that the goods that were required to move were still allowed to move.
As you talk about that, Dr. Dean, one of the questions from Yannick Russell is, are there any plans for Jamaica to ratify the CISG? I don't know if from where you sit, you could speak to that. Perhaps that is a question that would have been directed to Delroy. But are you aware?
No, I'm not aware what steps are being placed, but it's something that we would support. I think the minister would be in better position to respond to that.
Mm-hmm. Well, if Minister Green is able to come on, then I will direct that question to him. Perhaps he might be better able to give us an answer. I'm just scrolling through the chat now to see. Okay, I think that Minister Green has now joined us. Minister Green, are you hearing me? Hello, Minister Green. Okay, I'm not hearing. Judith, you had made a point in the chat. Could you unmute and make that point so that we have it open for discussion?
Yes, good morning, everyone. I could with pleasure. The only issue is that I'm not sure that I understood the question correctly because the line is very bad. So I only understood half. So if I did understand correctly, and that's the point I wanted to make, CSG is having in principle a long-term perspective. And this was the view of having an international contract. If you want to, so the contract is kept as a contract as long as possible because it's so difficult to unwind in international contracts, to send it back. You have transport costs again, you have to go through customs again. So you have all these elements. And that's why the CSG is providing different solutions than normally national contracts would.
Okay. Thank you very much for that intervention, Judith. I have a question from Crystal Maharaj from Trinidad and Tobago. She's the legal officer in the Office of Procurement Regulation. Her question is, to avoid any unnecessary litigation or disruption and incurring monetary losses regarding agreements and contracts with suppliers and contractors, should the buyer ask the supplier if there is a pandemic preparedness contingency plan in place, or if he or she has dedicated resources for responding to disruptions generally and COVID-19 specifically? Eric or any other panelists, your thoughts?
Well, I think in the new normal, these are things that will have to be examined, and we would have to look at, well, entities will have to look at how they incorporate such provisions in their contracts and operations. This pandemic and the disruptions that have occurred have
You've lost your audio, Eric.
are you hearing me now?
Yes.
Yes, I was saying that the pandemic and the supply chain disruptions we have experienced has brought to light the need for a closer look at the provisions that we put in supply contracts. And I think the suggestion made in the question are things that would need to be examined and implemented in future contracts going forward.
Okay. Minister Green, I'm going to make another attempt. I just sent you a message. You say you're on, but I'm not seeing you on screen, nor am I hearing you. Could you try to make your presentation at this point in time, please? All right, still not hearing the minister. One of the points that had been alluded to by Chairperson Justice Mangatal in her opening remarks was the whole question of force majeure and how that has been looked at given the crisis of COVID-19. Of course, that's one of the clauses that lawyers wrestle with from time to time in commercial contracts. Again, while I may be accused of laying hands on people suddenly, I notice that we have in our midst Dancia Penn, an outstanding attorney at law from the BVI and former attorney general, in fact, from the BVI. I don't know if Dancia would wish to give us a perspective so that I don't monopolize the conversation. Dancia? Okay, not hearing.
Good morning, Milton. Good morning to you.
Hi, Dancia. Sorry to lay hands on you suddenly. I was going to.
And to the distinguished panel, you're rightly accused, Milton, of laying hands on people. And you certainly lay in that regard. But thank you very much. And I'm delighted to participate in today's conference. And I compliment my friend, Dr. Chris Malcolm, and everyone who's been involved in the organizing of this very important virtual conference. I think the topic that is under discussion is one that is of fundamental importance. And I think particularly for the Caribbean, not just Jamaica, but the whole Caribbean region, we at the world, it's a global experience. We have all been very much impacted by the disruptions in the supply chain. And I agree with the comment that Judith, who I haven't met before, I agree very much with the comment that Judith made. And I think the others spoken before have also touched on some of the very key issues that now exist, issues that are going to continue to evolve in this new world. So I think this discussion and the discussions that are to come in the course of the day are extremely timely, and it is important that all of us, and it is really a tremendous thing that we have such a wide range of participants from all over the world. I think it is important that we have these kinds of encounters and conversations and discussions, that we identify the issues, and that together we continue to work, improve on them, and to face them. That's a very general comment, Milton. I plan to say more when I have the honor of being on the panel with Mr. Stoppy, who I can see, and others later in the course of this program. Thank you very much.
Okay, thank you very much, Dancia. I think that one of the things, of course, just from the narrow legal perspective, is that force majeure clauses are now likely to be wider and more detailed. If Derek McCoy has been listening, I would be interested to get his perspective on it. Derek? Okay, I haven't picked up from Derek. Minister sent yet another message saying that he is trying to connect. He's not sure what the challenge is, but I think we'll have to give up on that effort. We are now 8 minutes shy of our deadline. If there are any other questions, I see a hand up. Let me just see who that is. And it is in fact the minister. Minister, if you're hearing me, what I'm going to suggest that you would do is join by phone. And let us see if we can pick you up. Remain on screen, but join by phone and let us see if we can pick you up. Colleagues, one of the things in relation to business continuity that I know has given some of the companies with which I am associated a problem is a really robust technological response. Part of that consideration underpinned the presentation made by Dr. Dean. I don't know if there is anyone who would care to comment on that. I also have a question from Reza Roca. Her moral comment says, I believe we need to make specific agreements, not only in the private sector, but also public. Elaborate economy policies that are accurate in our local economy. Also, we can work in the 2030 agenda. So panelists can consider that comment in their remarks. And Chris, if you want to say a word about financing, please come in right after.
Yes, thanks, Milton. Now, one of the things I'm sure that Therese would have looked at was the area of business supply and the importance of financing in the supply chain arrangement. And one of the things we sometimes fail to understand is the extent to which finance is itself a supply chain logistics issue. And what is happening more and more now, we have seen instances of the banks, for example, we saw recently enough where one of the big banks in the US went and they had instances of calling a significant number of mortgages, and other instances where, of course, the banks which finance being critical to the supply chain are coming under more and more stress. Persons not being able to work, persons not being able to have their contracts honored, and so on. And the question is, how is financing to be dealt with there? And what special arrangements, if any, must the multilaterals, banking at local level and so on, put in place, recognizing that if financing is not flowing, then businesses will ultimately have no option but to fail. And that is an area I think we're going to have to, with legislative intervention perhaps as well, look seriously at, to ensure that as we seek to spur the economy and as we seek to get businesses up and running again, that we take such measures. Some of them may be temporary, others may have to be of a more permanent nature, put in place to make sure that people have available money. Because at the end of the day, business typically runs around money. And if it is not flowing, it's not available, then as night follows day, you're going to end up with insolvencies and end up with businesses going under, which is the last thing we want to happen in the environment we're in. So I would certainly wish to, and Eric, I'm sure could speak to it from his perspective in the logistics chain, what he is seeing in terms of monies going into the supply chain that he's intimately involved in, and the extent to which persons are keeping out of financing supply chain at the time, okay. Logistics.
Before Eric comes in, isn't one of the necessary implications from what you have said, Chris, the need to look or to re-look at catastrophic insurance?
It is, and that perhaps is one of the solutions that we're going to have to look at. And I know in the context of the Caribbean, we have for many years been trying to develop effective policies and arrangements to deal particularly with our hurricane situation. But we now have crises of another, or crisis of another nature, and I'm sure there will be others, which now causes us to do exactly what you're saying, to ensure that we have much more effective general catastrophic insurance arrangements in place that can deal with us and help us through these periods, particularly for small and more vulnerable businesses.
Yeah. And that in fact would be part of the arrangement and regime, I think, that Reza was referring to in her comments about the policies that are, the word she used, accurate in our local economy. Because especially in this neck of the woods, in the Caribbean, that is something that happens with fair frequency, unfortunately. But Eric, you were going to respond to a comment.
Yes, so just to close the loop on a comment that you had made about force majeure.
Yes.
I think that is an issue that is going to gain more importance going forward. And tying it back into, as you say, catastrophic insurance is going to also play a part. But one of the impacts that will have is that it's going to be more and more costly to do business because of the costs associated with those provisions, those force majeure provisions, and the insurance that is required to protect. But one of the things that we're also seeing coming out of this COVID-19 is that certain businesses, certain investment companies, houses and banks are stalling, providing financing on planned projects. That also has a disruptive effect going forward. And that has broad impacts on a range of stakeholders, which also need to be factored in.
Okay. Thank you. Now, well, we're almost at 11. So unfortunately, I will have to bring this session to an end. Sorry about the technical difficulties. It's one of the things that, having been participating in a number of international webinars, everybody is wrestling with. Minister Green indicated to me that he has been listening, wasn't able to connect audio. So I'm going to ask him to give a response in the chat to the question as to whether Jamaica has plans to deal with the CISG. And I just need to thank Dr. Deans. He ended up batting alone, a very difficult thing to do in a game of cricket.
Yes.
But we thank you for your presentation. Thank Dancer and Judith for jumping in and helping to flesh out some of the points that were made. The next session will explore, in fact, one of the points that we raised, which is force majeure, but specifically in the context of the CISG. And for that session, our moderator will be Mr. John Rooney. And although at the risk of making him laugh, and hopefully not wince, because I am sure he has heard it before, this is not John Rooney, the footballer, but John Rooney, who unfortunately, like a lot of us, and as penance for his many sins, is but a lawyer. Mr. Rooney.
Thank you very much. If it is okay, we can, first, to be sure everyone can hear me.
Yep.
Yes.
No problem.
We're a little bit early, but with Christopher's indulgence, we can start the panel now, if you like. I'll take that as a yes. As was mentioned, the title of this session is Force Majeure under the CISG. I begin by saying that those who are familiar with the CISG know that the term does not appear in the instrument. So what we are doing is dealing with the general concept of force majeure in the context of the CISG. We're also going to look at UNIDROIT. We're going to look at recent developments with respect to changes in the law of obligations in France, dealing specifically with the subject. To deal with the subject, Christopher has put together a really talented panel. What I'm going to do is briefly introduce the panel members now. Then each will proceed to their presentations, after which we have reserved some time for questions. We're going to try, or rather I'm going to try, at the appropriate time to integrate PowerPoint slides. It's my first time trying it. It looked like it will work. We will see. If it doesn't, I just ask for feedback. Our three panelists are Dr. Eduardo Munoz, Sandra Friedrich, and Rose Rameau. A truly talented and diverse panel. Dr. Munoz is a member of the law faculty at the Panamericana University in Guadalajara, Mexico. He frequently, in that context, contributes in specialized publications and discussions forums. He received his Bachelor of Law degree from the Universidad Iberoamericana in Mexico, master's degrees from the University of Liverpool in the United Kingdom, and the University of California at Berkeley. He holds a doctoral degree from the University of Basel in Switzerland. Besides his academic commitments, he practices in the area of international contracting and arbitration, sits as an arbitrator in international forums, and represents clients in commercial and sport proceedings. Sandra Friedrich, our second presenter, is a lecturer in law and director of the International Arbitration Institute and the White and Case International Arbitration LLM graduate program at the University of Miami School of Law. Prior, she practiced law at Latham & Watkins in New York, focusing on complex commercial and investment arbitration proceedings as well as litigation. She teaches courses on drafting complex arbitration clauses as well as transnational litigation and international arbitration with a European nexus at Miami Law, oversees the International LLM Practical Program at the university as well. In the past, she has also taught courses on international business transactions, European Union law, and German law at the University of Miami, co-author of several publications on international commercial and investment arbitration. She is admitted to the New York Bar. Before she had obtained her JD from the University of Miami, she received a Master in Law from the University of Paris, Panthéon-Sorbonne, and an LLM degree with a specialization in international economic law from the University of Cologne and the University of Paris as well. Rose Rameau is a fellow of the Chartered Institute of Arbitrators. She is a partner at the Rameau law firm based in Washington, D.C. She is a former Fulbright Scholar visiting professor in international arbitration at the University of Ghana Faculty of Law. She is an international arbitrator, mediator, and dispute resolution counsel. Focuses her practice on investor-state disputes and commercial arbitration, counsels governments and investors on concession agreements leading to international disputes in the oil and gas industry, including investment treaties before courts and tribunals. She has been appointed sole arbitrator in commercial contracts between African nationals and foreign investors, as well as a co-arbitrator in investor-state disputes. She's a member of the International Arbitration Institute in Paris, also an arbitrator on rosters of the British Virgin Islands International Arbitration Center, the Cairo Center, and other arbitration centers as well. She is an ICC court member representing Haiti, and a member of the ICC Commission on Arbitration and its task force addressing issues of corruption in international arbitration. She is also on the advisory board of the Jamaica International Arbitration Center and a board member of Arbitral Women. With that, I will pass the microphone to Professor Munoz, who will begin his discussion, which is going to focus on Article 79 of the CISG. Professor?
Thank you, John Ronnie. It's a pleasure to be here with you. Thank you so much, Christopher Malcolm, for putting together this wonderful conference. seeing some colleagues from the Caribbean area, but also from all over the world. As John mentioned, my duty here is to explain this provision in this what we have called a very successful international private law treaty, which is the CISG. Today has more than 90 member states. Within those member states, there are the major jurisdictions. Big missings are still England, Jamaica, of course, and India. But I think this is a good forum to talk a bit about of the provisions and how they work perfectly well in today's world. We have a PowerPoint presentation, but if that is not possible to present, I'm gonna just go without it. As you know, yes.
If I could interrupt for just a second.
Yes.
When I try to do the screen share, it says that the host is disabled screen share. So if the host could enable that for me, I think I can get the PowerPoint going. In the meanwhile, if you want to start.
Yes, I will.
Otherwise, we'll proceed with.
So I will start then. As you know, different circumstances surround today's international trade that obviously were not expected by many of us at the end of last year or even at the beginning of this year. The COVID has brought or has forced some cellulose manufacturers to shut down factories. We have seen breakdowns in supply chains, increased cost in performing contracts, and also some markets for buyers have even disappeared. So how can we, from a legal perspective, address this change in situations? Well, you have been talking about doctrines as force majeure, hardship before this panel. But one of the instruments and the provisions that would be relevant in today's international trade sale of goods would be Article 79. Article 79 does not include provisions, concept of force majeure or hardship. It talks about impediments. Someone in the chat have already pointed that out. But actually the CISG would be only the supplement to what the parties have agreed in their contracts. So the starting point to see what would be the solution to handle this change in circumstances, these difficulties, impediments, or hardship to perform contracts would be the contract itself and any hardship or force majeure clause that is inserted in it. We know that the ICC has provided two models for these situations, one in 2003 and a recent one this year, very timely, by the way, and some contracts have similar clauses, and that would be basically the starting point. Now, these situations start becoming relevant depending on which of the parties have not performed his obligations. As you know, the risk price and the time of delivery is particularly important in this regard. If the seller has not delivered the goods on time and at the place agreed because he's been affected by changes in circumstances after the conclusion of the contract, well, he will have to bear that risk unless he is exempted from performing the contract, and we will see what to be exempted means. So Article 79 CISG states the following: a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it. So you have three requirements. It must be about different circumstances, an impediment that is beyond control of the parties. it should also be an impediment that was not foreseeable. The parties could not have reasonably, and that's an important adjective, reasonably expect to have taken into account. The term reasonably is also included in the new ICC clauses, mirroring what the convention already said. And even when the impediment is already there, couldn't have been foreseen, in order to be exempted under these provisions, the party affected by the situation cannot or should not be able to avoid it or overcome it. So, for example, in the typical case where the seller of commodities cannot deliver because he lost them in the way to the point of delivery, usually that would be because whatever reason you want, act of prince or natural disasters, it is most likely that he would meet the first two requirements. It was an impediment before his control. He could not have expected it, but as he is selling something that is generic, he is able to overcome that impediment by outsourcing the same generic goods from a different supplier and then deliver perhaps a bit late. The question now is whether the current situations that we are facing due to the COVID constitute an impediment under Article 79. Article 79 does not, as I said before, distinguish between force majeure and hardship. Hardship is covered by the type of impediments that are dealt with in Article 79. That is basically the general understanding in case law and scholarly writings. The question most relevant for hardship under this provision is the standard required to consider that hardship has become an impediment, right? So if we go back to the examples I gave at the beginning, shutdown of a factory due to special government laws prohibiting the gathering of a given number of people in certain place, or an export prohibition, for example, of masks, or failures in the supply chain because different carriers have stopped activities, increased costs for performing because basically some of the inputs for the merchandise would need to be brought from a different place. All these things have happened already now, and some of the contracts that were concluded before the beginning of this year have been affected by those type of circumstances, those changes. So I am not giving an answer here on whether each of those examples constitutes an impediment or only an increased cost that may be considered hardship because it's excessively onerous or has made the obligation excessively onerous to perform. But that is what the adjudicator in today's world will need to look at. And so I think that the provision in Article 79 is well designed to handle these cases. In case there is a real increase in the market price for the goods or on the obligation of the goods and the seller cannot perform, there would be arguments to exempt him from performing. However, we need to take into account that several case law has already stated, CISG case law has already stated that an increase in 200% in the market price could not be enough to exempt a party from its obligation to perform in particular situations. For example, when the type of market is a speculative one and the seller is assumed to have assumed the risk of this price increase or or taking the risk of the price increase. Now, what are the remedies for general force majeure under the CISG for those type of impediments that does not increase the cost, but that prevent a party from performing? I'm talking about, for example, export bans, closure or prohibition of selling goods or producing goods that we are seeing now, or that we saw at least in some countries for some time. Well, the remedies are the exemption from damages according to Article 79. A party who is affected by the type of impediment stated in that provision is not liable for damages. Although this provision does not state so, the party affected by the change of circumstances cannot be forced to perform. This means that the remedy of a specific performance is also barred. It's also not available, at least during the time the impediment exists. What the other party can exercise as remedy is, for example, the right of avoidance. If he has no longer an interest in the contract because he will not receive the goods on time, he can simply, what do you call it in common law countries, repudiate the contract and cancel the contract. And also he is the remedy of suspension, withholding performance would be, of course, there for that party. In cases of hardship, the remedies available under 79 would be the same. Sandra, who will follow this presentation, will explain that there is a big difference between the remedy of exemption for damages, which is what the CISG provides for, and the remedies stipulated in the UNIDROIT principle. So in conclusion, as I don't have much time, and I'm ready to answer any questions you have, COVID-19 has changed the circumstances under which many contracts were concluded. And in order to see whether a party would be exempted from performing, we need to have a look at the contract clauses that may be in the relevant relationship. Otherwise, whenever the CISG is applicable, that is in many times applicable, unless the parties have excluded their application, the remedy provides a suitable rule with 3 requirements, clear requirements that have or lead to specific remedies that would be suitable for today's world. Thank you. I think you are mute, John. You are mute. You should unmute.
Okay, that should do it. I'm sorry. Thank you very much. Our next presenter will be Sandra Friedrich. It doesn't look like the PowerPoint insertion is going to work, so we'll just go with the verbal presentation. If you have any questions, please, what I would recommend is that you present them in chat, and we will also have a time afterwards to deal with them as well. Okay, thank you very much.
Thank you, John. As John said, I'm going to focus on the solutions for force majeure and hardship situations under the UNIDROIT principles. Generally, as many of you, I'm sure, oh, there we have, I see a PowerPoint now. As many of you will know, I'm sure, the UNIDROIT principles of international commercial contracts, the most recent version dates back to 2016, so fairly recent. They're generally considered a non-binding codification or a restatement, if you want, of the general part of international contracts law. However, they can be selected by the parties to govern their contracts, so they can be binding in that sense. And they can also apply as general principles of law. So anywhere where the parties have subjected their contract to lex mercatoria or general principles of law that govern international commercial contracts, the court or tribunal might very well look to the UNIDROIT principles. They're also used at times to interpret other instruments of law, like the CISG, like Edgardo mentioned, and also domestic law. The 2 provisions that I want to focus on, and John, if you could advance one more slide, actually one more, sorry. Yes, perfect. The two provisions that I want to focus on are the force majeure provisions, which are found in Article 717 of the UNITRA principles, and this excuses non-performance. And on the other hand, the hardship provision in Article 622 and 623 of the UNITRA principles, which triggers renegotiation obligations. It's important to note that the current COVID-19 pandemic, contracts might well trigger both of these provisions. And so it's really for the party invoking the provision to decide which remedy to pursue. And next slide. I put on the next slide for you the language of the force majeure provision. If we could advance the slide deck one by one slide. Which you'll see if you've been looking at Article 79 of the CISG, as Edgardo was talking, you'll see that this provision in Article 717 is actually very, very similar to Article 79, with the important distinction that this actually mentions specifically the term force majeure, which Article 79 does not. This was deliberate because the UNITRA principles are not meant to be a rival in any way to the CISG, but rather an ally when it comes to international commercial transactions. Now, the force majeure principle here, the force majeure term was chosen specifically because it's a very familiar term in international contracts, because there are a lot of force majeure or hardship clauses that are included in contracts as a matter of business. Force majeure here is actually found in Chapter 7. As you can see, the first number, Article 7, is Chapter 7, which is the chapter on non-performance, because force majeure basically means performance is impossible. So whether or not it will eventually be excused, it is an issue of non-performance that either will be excused or will give rise to damages. I don't want to go over the elements specifically again, because like I said, it is very similar to Article 79 of the CISG, and Edgardo has already given us a very nice overview. So I just want to make a few comments here with regards to certain points. I believe that the foreseeability analysis with regards to force majeure events will be very important when it comes to determining whether the force majeure provision is triggered here with regards to COVID. And I just want to remind everybody of the timeline that we have, because I think it'll be very important to place the contract in question on the timeline to see how to best present your arguments. What we know so far is that, so back in December of 2019, the first cases surfaced in China into January of 2020. Now, we now know, according to the latest reports, that there might well have been cases in France, even Seattle, as early as December, but it doesn't really matter for the foreseeability analysis what we know today. There's no, hindsight's always 20/20. So for the foreseeability analysis, it matters what the parties could have and should have foreseen at the time of the conclusion of the contract. So we have to put ourselves in the shoes of the parties when they concluded the contract. It's also important to note that on January 30th of 2020, the WHO declared a public health emergency of international concern. So in other words, on January 30th, the world started to realize that things are getting serious. This is only the 6th time in the history of the WHO that such a public health emergency was declared. And then by mid to late February of 2020, I think it would be difficult to argue that, generally speaking, the COVID-19 pandemic was unforeseeable at that time, because it started to spread into Europe, it started to spread throughout Asia, and also into the Americas. However, that does not mean that your force majeure claim is necessarily precluded, because there still remains an argument that the exact measures that governments adopted in order to respond to the public health crisis were unforeseeable. So the way that courts and tribunals will define the specific trigger event is really going to be very important when it comes to the analysis of foreseeability. Are we speaking about a pandemic in general? I think we would all agree that even before December of 2019, a pandemic generally was within the realm of possibilities. Even just in the last 20 years, we had the swine flu, we had MERS, we had SARS, we had Ebola, and none of them obviously had the same global proportions that COVID-19 has, but under a broad definition of a trigger event, just as pandemic, it's very easy to argue that this was in fact foreseeable. Now, on the other hand, if we define the trigger event very narrowly, like was it foreseeable that a novel type of coronavirus was going to spread around the world and wreak havoc the way that it has, I think that that very much was unforeseeable. I think outside of the medical community, we can all agree that before January of this year, we had never heard of coronavirus. So it's most likely that courts and tribunals are going to adopt somewhat of a middle ground with regards to defining the trigger event. So probably something along the lines of, was it foreseeable that there would be a rapidly developing pandemic with seriously disruptive effects during the lifetime of the contract? And that's also going to be important. It's obviously going to be more reasonable to foresee a certain pandemic event in a contract that maybe lasts for 20 years versus a contract that is supposed to be concluded within the next few months. So all those considerations will be important when it comes to the foreseeability analysis under the force majeure provision. Of course, there also has to be a causation link. So just because there's a pandemic, it doesn't mean that performance is necessarily excused. It has to be because of the specific trigger event. So in parties, I think would be well advised to specifically plead and outline the specific government measures, for example, that led to an inability to perform, like airport closures or travel bans or social distancing measures, industry shutdowns, things like that. I think that the more specifically those arguments will be presented, the more likely will be the success. Now, one important difference, and we didn't see the provision of Article 79 of the CISG, but I just want to point out that the CISG actually specifically addresses the force majeure impediments along a supply chain, including third parties that are not under the control of the seller, for instance. Now, the UNIDROIT principles do not specifically address that situation, but it's generally accepted that force majeure would have to exclude not just the obligation of the immediate supplier, but also of any other supplier in the upward chain for the party to be able to claim force majeure. Now, also similar to the CISG, there is a specific provision on a temporary impediment, and that's not much different from the CISG, so I'm not going to specifically address that, and instead I'm going to go ahead and jump to the next slide, where we're going to see that the party claiming force majeure is also required to give notice. This again is very similar to the solution adopted in the CISG, so I won't specifically go into it. Now, one of the differences that Edgardo already mentioned is that the CISG does not specifically spell out the actions that might remain available to the other party. However, the UNIDROIT principles do so. So the UNIDROIT principles are very clear that force majeure will excuse performance, so also specific performance will no longer be available. But on the other hand, the other party is still free to exercise certain rights, including to terminate the contract if it's a fundamental non-performance, including withholding its own performance, and including requesting interest on any money that is due. So the UNIDROIT principles here are a little bit more specific in that regard. I also wanted to mention that in cases of temporary impediments, usually the result is an extension of the time to perform, but the length of the impediment is not necessarily going to be the same as the length of the extension. So for example, in construction projects, you could see that in certain areas of the world, construction is only possible during certain times of the year, for example, not in winter. So if a 1 month delay on construction now pushes the contract into the season where construction is not possible, the extension to perform would usually not be just the 1 month, because that's going to be pointless, but could well be up to 6 months, giving the party time to perform in the new season. And with that, I want to jump to the hardship provision of the UNITRA principles, which is on the next slide. And this is really the most important distinction because, as Edgardo mentioned, there is no explicit hardship provision included in the CISG. Now, with regards to the UNITRA principles, the hardship provision is found in Chapter 6 rather than Chapter 7. Chapter 6 deals with performance issues. So hardship basically means that while performance is technically possible, it is overly burdensome and therefore should be dealt with under the chapter of performance. Now, it is disputed whether or not the UNITRA principles can be brought into the CISG under Article 7 as general principles of law to provide the hardship standard. So, that's a very much a disputed issue. Now, with regards to the hardship provision in the UNITRA principles, of course, if the party specifically selected the UNITRA principles to govern their contract, this is very much of mandatory application. And you see here that hardship is defined as an occurrence of events that fundamentally alter the equilibrium of the contract. This is a legal concept that's not unfamiliar to many of you, I'm sure. So it's very much known in other legal systems, and I'm just gonna quickly go over this because I know that we're nearly out of time and we have to stick to a strict schedule here. I want to just kind of highlight some of the points here. For example, fundamentally altering the equilibrium. There is no specific threshold. So for example, if it's become 50% more expensive to perform the contract, that in and of itself is not necessarily guarantee a hardship claim. Case law on that is all over the place. So that is not in and of itself enough. And if we go to the next slide to finish up, I want to point out that the remedies for hardship are very different from the CISG because hardship, first and foremost, entitles the disadvantaged party to request renegotiations of the contract so that the contract can be adapted in order to eliminate the hardship. And if such renegotiations fail, either because one of the parties is unwilling to participate or the parties both participate in good faith but come to no conclusion, then it is a matter for the court to decide how to proceed, and courts may then terminate the contracts or may adapt the contract in order to redistribute the risk of the hardship to both parties. Courts can also order parties to go back to negotiations, or courts can also confirm the contract terms as they are and order the parties to proceed. And to conclude, on the next slide, and I know Edgardo had also addressed this, these statutory provisions under the UNITRA principles, of course, only come into play if the parties have not specifically agreed otherwise in their contract, and many commercial contracts do include specific force majeure and hardship provisions, including the ICC clauses, which actually specifically include the term epidemic under presumed force majeure events. So there is a very good chance that COVID-19 being a pandemic, so an epidemic of global proportions, will fall under many contractual hardship provisions. And I think with that, we'll hand it back to John.
Sandra, thank you very much. Now we have looked at the issue from the point of view of the CISG and Lex Mercatoria. Rose is now going to address the treatment of force majeure in a national system, in particular focusing on the recent changes to the French Book of Obligations, which I believe went into effect in 2016. So I won't take up any more time, Rose, so if you want to proceed, I will move to your slide and you can begin your presentation.
Good morning. Thank you, John. The beauty, I guess I would say the disadvantage of going last is dealing with everybody saying everything that's you're supposed to say. So I will try my very, very best not to repeat what Sandra and Edgardo had already mentioned, but I have to say it's very difficult because the French force majeure clause, I would say under the civil law is, I would say it's a combination of what both Edgardo and Sandra has articulated for us this morning. Just to mention, we all know that force majeure deals with the supervening unforeseen events that make performance impossible. And force majeure has been defined as being superior force, act of God. It can cover things such as flood, fire, droughts, earthquake, civil riots, terrorist attack, and now 2020 would say maybe pandemic. So the thing about force majeure in France, for many years, it was never defined. And we're gonna see this under the article you have here. That's the old article 1148 in the French Civil Code. And I have to make a disclosure that these are not perfect translation, because Légifrance actually has a disclosure saying it's not intended to give legal advice, but just for knowledge sharing. So whatever translation I've provided now, you know, it's not something you can rely on. If you have a case in French court, it would be highly advisable to get your translator to give you the perfect translation. So let's look at Article 1148. It says basically damages are not due when, because of a force majeure or a fortuitous event, the obligor or the debtor either was prevented from giving or doing what he was obligated to give, or did what he was forbidden to do. So as a practitioner, you read this, you start laughing, because you're like, what the heck is this force majeure? There is no definition. For many years, we see that courts and tribunal, they had to develop the term, and that's how they come up with different definition of force majeure. And you can see that through the cases that were decided. But in 2016, like you've said, John, droit des obligations, the French legislature has decided enough is enough. We're going to now clarify what is force majeure. So what they did, they inserted article, if you can move to the next slide.
Yes.
And my only slide. Article 1218 of the Civil Code, they inserted this new article to finally define force majeure. So my presentation will be first on the first paragraph of the translation here, which you should not rely on, is just for purpose of this presentation. And it defines force majeure, and it also gives you those tests, I would say perfect tests that both Edgardo and Sandra has mentioned to you, to all of you this morning. And the second part is the remedy, which Sandra has also covered in terms of whether the impediment is temporary or permanent. So now let's go by the very first one. It says here, there is force majeure in contractual matters when an event beyond the control of the debtor, that's test one, it has to be an event. The event has to be external, and it has to be beyond the debtor's control, and which could not have been reasonably foreseen. There we go now. Second test is the foreseeability factor. And then it has to be the foreseeability, just like Sandra mentioned, at the conclusion of the contract. So you cannot wait when litigation or before the tribunal is when you're gonna argue you did not foresee this. It has to be way when you are signing the contract, and whose effect cannot be avoided by appropriate measure. So basically you can't perform at all. And final test is that it prevents performance of the debtor. So you have to show, one, that it was unforeseeable. You have to show, one, it was beyond your control through an external factor. Then two, that you could not have foreseen it. And three, you can't perform. And four, that there was a causation, and that causation is not a proximate causation, is a direct causation. So when you look at force majeure in France, we can say that clearly it was designed to cover Article 79 of the CISG and also take into consideration the UNIDROIT principle, as Sandra explained earlier. So the externality, I would say, factor, the occurrence of an external event for which the debtor has not assumed the risk. Because if you assume the risk, then you cannot claim force majeure. And also the second test is the unavoidability, or you would say irresistibility. The occurrence of the external event was beyond the person's control or the sphere of your control. You have to prove that as well. And the third one, you have to prove that it was not foreseeable at the time that you signed the contract. The debtor did not foresee the consequences or adverse effect of the impediment, or could not reasonably have been avoided. And then last, the causation is a but-for test, not the proximate causation. It has to be like the debtor's non-performance was as a matter of commercial reality that caused by the external event and not by his own fault. So no assumption of risk, and it has to be a but-for test. So now if you go with the second part of the Article 1218, which is the impediment, it says this: these are the remedies you can get. If the impediment is temporary, performance of the obligation is just suspended, unless the delay, I would say, which result justified termination of the contract. Now, put it in context, in COVID-19, many respondents, I would say, who are claiming no force majeure if they miss delivery, they are going to argue that the impediment was a temporary impediment, because WHO and all the experts says after 18 months, things will get back to normal, we'll get a vaccine. So this is up for discussion. And just like Sandra said earlier, but if you can prove waiting 18 months is going to fundamentally alter the purpose of the contract, and maybe you can still get your force majeure clause to be effective. But the bottom line is, under French laws, they look at the impediment. And especially with regards to, outbreaks, they are very strict as to whether or not is it foreseeable. Shouldn't you foresee there was always going to be a pandemic? We saw one, and we don't know exactly when it was going to happen, but maybe it was always foreseeable. So that's also up for discussion there. And then if, according to Article 1218, if the impediment is actually permanent, and what it does, the contract is terminated by operation of law. So that's the term that we call, you become free from the contract with both seller and buyer or debtor and obligor. They can just shake hands, find someone else to do your contract with, and no problem, no damages. And in putting this in the context of COVID-19, I think it's very, very important to make the difference between force majeure and hardship clauses, because force majeure, it has a greater, you have all these tests you have to prove. Meanwhile, the hardship, if you sign on to a contract in year, I don't know, 2014, and it used to be $10 per barrel or whatever, and then now come in with COVID, it's now 20, it's twice as much. Of course, it's a hardship, because financially you may not be making a profit anymore, but nothing is going to stop you from performing. You can buy it at a higher price. And just like Sandra mentioned, it's always up for renegotiating the contract, but that doesn't mean you can claim force majeure for that. And secondly, putting it in context for COVID-19, we're going to look at governments who have decided which business is essential, which are not essentials. All that is going to affect whether or not you can really claim hardship or force majeure. So if your government decided that your business during COVID-19 was essential, so arguably you did not really lose much because you were kept open, you were kept, you keep on serving and you keep on collecting money. Whereas the other guy who may have been declared deemed non-essential was out of business totally. So I think tribunal will have.
Hello? Rose, I believe you're muted. Okay.
Okay, can you hear me now?
It's okay now, yes.
Okay, I hope you heard my distinctions between hardship and force majeure under French laws, and that will be the end of my presentation. I will be more than happy to answer questions. Voila.
Okay, thank you so much. You know, I'm not sure exactly how much of the end of your presentation was cut off. I would say it was maybe just the last 20 seconds or so.
Okay, so I can repeat what I've said. I've said that going back to the impediment, which is like under Article 1218, the new Article 1218, clearly it shows that if the impediment is temporary, then you can have a suspension. And I said in terms of COVID-19, we can see respondents arguing before tribunal that it was not a permanent impediment, in that WHO and other health organizations, they've said, okay, we'll have a vaccine within 18 months. And covering back what Sandra says, if you can prove that such impediment still will alter the meaning of the contract or make it so difficult for you to perform, maybe you can still go under force majeure, but that needs to be proven. On the other hand, if it's a permanent impediment, clearly you walk away from the contract. It's called effet libératoire.
Okay.
Voilà.
All right, thank you very much. We have a bit of time left, I think maybe 10 minutes, I believe, for questions. I'm not sure what the technology of that is with respect to this, but I think that any of the participants would be able to, in fact, ask the question, or any of the people who are participating by viewing the conference and presentation would be able to ask a question now, I believe. And if for some reason it doesn't work with the microphone, then try with the text. You know?
Yes, John, I think the panelists can ask, and those who are not able to speak can put their questions in the chat room.
Okay, so the panelists can ask questions. The others should make the question in writing. Okay. There is, from one of the participants, let's see. Please repeat essential versus non-essential fine points. Thank you. I'm not sure precisely to whom that is directed.
That would be to me.
Okay.
I think part of my presentation was totally cut off, because
Okay.
I think what I've said to put, after I have explained under French law, there was the old article 1148, which did not define force majeure. And then versus the new article 1248, I believe, which is inserted now, defines force majeure, gives you those two steps. So now with regards to the impediment, I explained that if the impediment is temporary, then the contract will be just suspended. If it's permanent, then you walk away free from any obligation. Now, with respect to the essential, I was putting in context COVID-19, because some governments have decided, okay, your business is now non-essential versus essential.
All right, right.
A restaurant during COVID-19 was shut down, closed. You can't go inside a restaurant. However, then now what we see some of the restaurants had to do, they had to change the
Good.
way that they had to now become like supermarkets, for instance.
Right.
So going back to what Sandra explained, if you have mitigated your loss, all that will be factored in. But if it's totally non-essential, where you could not have opened at all, then I believe both tribunals in court, they will be looking at that, whether it was just a simple hardship, whether it's clearly force majeure.
Perfect. Thank you very much. I'm looking to see, was another question that said it would be good to express the difference between reasonably unforeseeable versus unforeseen as a test for an allowable impediment. I think that question may have been presented during Edgardo's presentation, I believe, but I'm not sure.
I could try to answer. Yes, the last version of the ICC clause included the term reasonably foreseeable, and the CSG also includes reasonably expected. It seems that the inclusion of such a term would lower the standard, but to be honest, even in those, if you put yourself in the position of any adjudicator, judge, arbitral tribunal, even if the word reasonably is missing, most of the time you will see whether the event was unreasonably foreseeable or not, or expected. Sure. Rose just mentioned, well, there were pandemics before, but could we reasonably expect that pandemic was this pandemic COVID was going to really cause all these changes in circumstances? I would say no. And even if the term reasonably is not there, even if only unforeseeable or unexpected is there, most of the adjudicators would say we could not reasonably expect that we will have a new pandemic of this scale. That would be my answer.
Okay.
John, with your permission,
of
just
course.
a question to Rose, Sandra, and Edgardo. The word reasonable is usually there to import some sort of objective standard. But as those of us who grapple with contracts know, when it comes down to the interpretation, there's always some tension between objective factors and subjective factors. And very often the tribunal or the judge says that by looking at each situation in its own circumstance, and that's code for importing something subjective. How do you grapple with that in relation to the provisions that we have just reviewed?
Any one of the panelists, I guess, can say.
I would say
I can say, going back to responding to Edgardo's comment, he believes that a tribunal is likely to see that it was not foreseeable. I think I beg to differ. I think it will be on a case-by-case basis, and it's going to be what kind of business we're looking at. If it's a business that is pharmaceutical, or I don't know, it depends on what's before the tribunal. That's number one. And going back with what Mr. Samunda mentioned regarding the objective factor, and I think that's why in terms of the French Civil Code, we don't look at causation being a foreseeable, and we look at it but for, which is like a direct impediment. Then that's how you can really measure the objective factor under the French Civil Code. Because if we do any other tests for the causation, anybody could fall under it. But if we look for a direct causation, it's going to be much tougher. So
I would also add that with regards to the standard, yes, it's primarily an objective standard of was it reasonably foreseeable, but of course, it will very much depend on the situation that the parties are in. For example, I think parties of China, arguably, it was reasonably foreseeable that COVID-19 would affect the contract earlier then it would have been reasonable to foresee that for parties in Europe or parties in the Americas. So subjective considerations, I think, certainly come in, but at the base, it's an objective standard. I also want to point out something with regards to Rose's presentation. It's very important to note that even though the terms that are used are the same, force majeure, I spoke about force majeure under the UNITRA principles, and Rose spoke about force majeure in France, and it's the same term, but that doesn't necessarily mean that the concepts are the same. For example, Rose explained that under French law, basically, if there is a permanent force majeure event, the contract is immediately terminated. That is not the solution under the UNITRA principles, where merely non-performance is excused and the other party remains free to either terminate the contract or suspend its own performance. So the fine nuances of the specific principle that applies is still very important. So while there are overarching similarities between the CISG, the UNITRA, and the specific domestic solutions, I think it's very important to be specifically looking to the governing law or the contractual provision. And I think also with regards to foreseeability, I think this is very much going to change what's foreseeable in the future. I think future analysis will differ after we've gone through this pandemic.
Excellent. I would also note that in the chat there are two recent questions to all of the panelists, and the questions are a bit long, so I'm not going to read them. But I think the second one is more addressed to Sandra. So maybe if you would want to take that one, and then we could, as a group, consider the one from Giselle Martin second. So it'll be Mr. Isaacs first. Can you see them?
So I have a question. I have a question here from Marguerite that says, "What's the difference between force majeure and hardship?" So I would say, very simply put, force majeure means that performance is impossible, whereas hardship means that performance is still possible, but really overly burdensome. So I think that's like a very, obviously very, very simplistic, but I think that's the major distinction. Force majeure is impossible. With hardship, it's still possible, but very, very difficult or overly burdensome with regards to the economics of the transaction.
Okay, and then I think that there is the, I guess, Mr. Isaacs' question to you as well, which would be a longer question, I guess third from the bottom.
I'm sorry, I don't think I have that.
It's in the chat.
Oh, wait. Oh, I'm sorry. I just realized there's a Q&A and there's a chat.
Yes, they're both. And we have 5 questions in Q&A as well.
Okay, I'm very sorry. Yes, I think that, so the question is, would force majeure, would the COVID-19 pandemic be considered a force majeure event in a commercial lease agreement, which contains a vague, broad force majeure clause that does not specify force majeure events? Yes, so in my opinion, I think there's a very good argument to be made that a pandemic of this global scale and with this kind of rapid development very much would fall even under a general force majeure clause that doesn't specify epidemics or pandemics or global health emergencies specifically. Now, of course, if you have a contractual clause that specifically excludes international calamities or global health emergencies, then that would be different. But a broad clause, even if it doesn't specifically mention epidemics, I think there's a very good argument to be made that disqualifies.
Okay, and then I see that there is in the question and answer, I think it is Ms. Card has a question for Rose, but it might be one that she's already addressed, I believe. Can you see Rose in the question and answer? The last. Oh, it has been answered. I'm sorry. I thought it had been, and it had been answered.
One from Adenike Sinkard?
Yes, it was answered, she says. And I thought that it was. I'm sorry. I don't know, Ms. Rose, if you'd like to look to the question from Giselle Martin. And also Dodo.
I can't see it. Is it the?
It's under chat. It's under chat. There are two. The questions are coming in two ways.
I could very briefly answer. Of course, the starting point to look at whether one party should be exempted from any type of impediment or hardship will be the contract. What I'm not sure or may not agree is with the proposition that the clause should be interpreted subjectively, taking into account the circumstances of the aggregated party. That would depend much on the applicable law we apply to interpret the hardship clause. If it is a CISG, the first standard is subjective, Article 8.1, but under the condition that the other party could not have ignored the intent of the party proposing one interpretation. The second standard of interpretation under the CISG Article 8.2 is of the reasonable man that Mr. Milton Sudama has already mentioned. So we would interpret that clause as a reasonable man would have done it. And the third paragraph of the same provision in the CISG says that every time we should consider the circumstances surrounding the specific contract. So case-by-case basis, as Rose already said.
If I could ask the organizers, I think that technically, according to the schedule, we're probably about out of time. So should we wrap this up now?
Short answer, yes, John.
Okay, so we will do that. I know that there have been some other questions, I think, that have been presented in chat. And there was an observation that for some of those questions, everyone wasn't able to see them. And I would ask maybe if you would put a question in chat to put it into question and answer. And perhaps we could make arrangements after the conference if you put your contact information to address your question. As well as with respect to the deck of slides. I know that Eduardo's never were presented because of technical problems, but we can figure out how to do that with Dropbox as well. I'd like to thank the panel. It was just a great experience for me to listen, to learn. And I think I would probably be speaking for everyone else when I say that. And thanks to for the organizers for giving us the opportunity for this forum. And with that, we'll consider this panel to be closed and you can move on to the next. And thank you very much.
Thank you.
Thank you. Thanks, Chris. Thank you, everyone.
Thank you, everybody.
Bye, Sandra.
Thank
Love
you.
your background.
I think, John, you should have introduced briefly Karen.
I'm sorry?
You should have briefly introduced Karen, who moderates the next session. Karen Goff.
I think that I didn't realize that I need to do that. So
just quickly, just briefly. Well, we don't have to. Karen Goff is the next moderator. She will take over.
Okay. Okay. Sorry about that. Thank you.
Well, good evening, everybody from London. I had a big debate debate about whether I'd put a sort of screen behind me, and it probably would have been a best bet because the sun is just going down in London. First of all, thanks to Christopher Malcolm for arranging the conference. Since the world can't come to Jamaica this evening, he's brought us all online together, which is a lovely experience. So I am Karen Goff. I'm an English barrister. I'm an attorney at law with a license to practice in the islands of Jamaica and also in Trinidad and Tobago. I'm a chartered arbitrator, a past president of the Chartered Institute of Arbitrators, and an accredited adjudicator. It's my privilege to welcome you all to our session, distinguished guests, colleagues, and friends. This session concerns adjudication of construction disputes. So while construction disputes can be adjudicated in many ways, as in determined, the form of dispute resolution we are actually going to discuss in this panel is called adjudication. Adjudication can be statutory or it can be contractual. It can be a right exercisable at any time or as it is prescribed in a contract or even by law. It can be used to adjudicate payment disputes, or as we have it in England, on a much broader basis, for the majority of construction disputes. But I should say with the English Act, while you can adjudicate the majority of construction disputes, you cannot adjudicate them all. And indeed, some contracts are simply not amenable to adjudication. So in this session, references to statutory adjudication by our speakers will refer principally to the Malaysian model. That is the Construction Industry Payments and Adjudication Act of 2012. And when you hear our speakers, you'll understand the reason for that. But the Malaysian Act is an act designed to reduce payment defaults by establishing a cheaper and speedier system of dispute resolution for construction contract disputes. At this moment in history, of course, anything which secures prompt payment of bills is a very useful mechanism to be considered. Generally speaking, an adjudicator's decision is binding only temporarily, but it must be adhered to. It must be paid until the matter is then later decided either by agreement, by arbitration, or by litigation. The English experience is that, in fact, adjudicators' decisions are often accepted by parties as a final resolution of the dispute. So the fact that it's only temporarily binding should not be something that puts governments off from introducing such systems in their countries. So as we all know, the construction industry is a vital part of every economy. In the wake of COVID-19 pandemic, keeping cash moving around the economy is more important than ever. Our speakers are going to explain how this can be achieved through the process of adjudication. Turning to our speakers, I must tell you that I am the least of the apostles in this session. So I have the pleasure to introduce three very distinguished and experienced speakers to you today, all with particular expertise relevant to adjudication. Their full CVs are available from the JIAC, and their slides, and I'm not sure whether you'll be able to see them, produced for this session similarly can be made available. My first speaker is Professor Datuk Sundra Raju. He is perhaps the architect of the Malaysian system of adjudication. He's the former director of the AIAC, which is the Asian International Arbitration Centre, and he is credited with putting that organisation and arbitration and ADR in Malaysia on the world stage. He's now the founder and president of the Asian Institute of ADR. He's an acknowledged expert globally in the fields of arbitration and ADR. He's a good friend to the Caribbean. Apparently not on his CV, you will note, he is widely acknowledged also to be a very keen badminton player. Sundra will speak to you about setting up an adjudication scheme, the training of adjudicators and accreditation. Sundra, over to you.
Thank you, Karen. It's 1 a.m. in the morning here in Malaysia. So I'll try my best to deliver. Let me start off with when we started on the adjudication scheme, there were very few examples around the world. In fact, it is still limited around the world. I think there's only 5 jurisdictions, common law jurisdictions that have adjudication and statutory adjudication as such. So we had to decide which model to choose. So we decided to choose the New Zealand model because we are a small country. New Zealand is a small country. So we had a lot of discussions. In fact, the discussions to set up the adjudication scheme started in the 90s. So it only gelled as an act in 2012 when Parliament passed it. And it came into force in 2014, April. And since then, it has been a phenomenal success. Some features of the adjudication regime. First, it is a statutory regime that is applicable to all construction contracts. And all construction contracts is defined very widely. In fact, I think it's so wide that nothing escapes it. As long as it's fixed to the ground, it's being built. And even there's a discussion, what about if it's a shipbuilding contract and if it's going to be launched, it's being built in a dock? Is it a construction contract? So I think these are the final points. But the most important thing was we decided, unlike the United Kingdom, we decided to have a limited payment arrangement. That means it will be limited to payment claims, interim payment claims. Originally, the definition of a payment claim is payment for work done and services rendered under the express terms of the contract. So it's a limited scope. It is supposed to ease cash flow in the sense that the contractor is able to actually get a and it's all to be done within 100 days. So following that, first we needed the legislation. So what we had is the Construction Payment and Adjudication Bill passed by Parliament, after which we needed to actually have a structure to manage the scheme itself. So we needed an adjudication authority, and it was decided that it will be the KLRCA at that time, and now known as the AIAC, which will be a single adjudication authority. And then we needed people to actually sit as adjudicators to understand the scheme and to administer and dispense the decisions that have to be done in fulfilling that. I have some slides and I'll show you all how it works. Can you all see it? Is it on? Can you all see the slides? Karen? No, huh?
Not yet.
We need to share. We need to press the share button.
Right at the moment, Sundra.
What do I have to press?
Press the share screen.
Share screen.
Share the screen. Okay.
Yeah.
As the host has disabled the participant from screen sharing.
Oh,
can that
not I think perhaps Nordia can help with that.
All right, never mind. Let me just carry on. Let me just say that the first requirement was in the Act itself, in Section 32. And let me explain that the adjudication authority, the arbitration center in Malaysia was made the adjudication authority. And we decided on one authority simply because of the size of the country. And the scheme, we were not sure how extensive it's going to be. So the functions of the adjudication authority is that it should be responsible for the following things under the Act: setting up of competency standard and criteria of the adjudicator, then determination of the standard terms of appointment of the adjudicator and fees for the services of the adjudicator, administrative support for the conduct of the adjudication under this Act, and any other functions that may be required for the efficient conduct of the adjudication under the Act. So you can see that this particular section enables and empowers the arbitration authority, the arbitration center as the adjudication authority to do a range of activities to support adjudication in Malaysia. And following that, what has happened is that then the Act, there is the Act, there is the regulations, there is the rules. There were three parts which become the administrative arrangement and the legislative arrangement. Then what we have is the training program. Let me now go for the responsibility of the adjudication authority. Now, the first responsibility of the authority was to maintain a register of panel of adjudicators. And then we have to put out a code of conduct. This is under the regulations to provide training and accreditation and conducting examinations for the adjudicator, determining what the fees for the services and expenses of the adjudicator, and receiving and holding any fees and expenses deposited by the parties in dispute on behalf of the adjudicator. So this is the actual responsibility of the adjudication authority. And then what is the panel of adjudicators? So we have to maintain a register of panel of adjudicators. We could remove or add in if the adjudicator requests in writing to be removed, or you fail to satisfy the competency standards and criteria as an adjudicator, and then you will have a notification procedure before you're removed. Now, the competency standard is the one that is quite important. That is Regulation 4. The competency standard and criteria of the adjudicator is as, let me see whether I can share the screen now. Still no, I can't do that. Is as follows. The adjudicator must have 7 years experience, working experience in the building and construction industry in Malaysia or any other fields recognized by the adjudication authority. The adjudicator must be a holder of the certificate in adjudication from an institution recognized by the minister, and the adjudicator must not be a discharged bankrupt, and the adjudicator has not been convicted of any criminal offense within or outside of Malaysia. So this is the competency standard. So from this, you find that the adjudication authority actually has a wide responsibility, a wide scope. In fact, it controls the entire process and all the structures, administrative structures that are required to be done for adjudication in Malaysia. From the very fact that we collect money, we keep it as deposits from the parties, we empanel adjudicators, we appoint adjudicators, we train adjudicators, we accredited adjudicators. Now, the real question then came out is that how do we quickly train a group of people to become adjudicators? Of course, you know, we have arbitrators, we have judges, everybody, but adjudication is a different process. It's a summary process. It's an expedited process, not a summary process, an expedited process, rights-based. There is actually a way of delivering the result that is in a form of a decision, and the decision must be clear enough to be enforced. So we decided at that point of time that we needed to train. We looked around, we found no institution that was doing it. We thought of borrowing some training arrangements from, let's say, overseas, but it was not suitable. So we decided to do our own training. So we developed our own syllabus, curriculum, and then we had a course devised. And in Malaysia, there is an accreditation requirement for courses. So if you have a diploma, you have to go to the authority of higher learning for them to accredit your diploma or degree. So we had to bypass that. And so we set up what is called a certificate of adjudication issued by the adjudication authority. That time was AIAC. Now, we had a 5-day training program covering a number of units. So we needed, I think, competency and skill standards and knowledge needed to be first is how does statutory adjudication apply in the construction industry? That is a first unit. The second unit is what is the practice and procedure of adjudication under the Act? Just looking specifically at the Act. And then looking at the CIPA regulations, because what the CIPA regulations have detailed requirements that have to be followed in accordance to competency standards, and more importantly, fees and other things. Then it deals with the construction industry. We had to train people for the fundamentals of construction law, because many lawyers who come and many architects and engineers and quantity surveyors who would come to actually for the course, they may not have the fundamentals of construction law itself, which is a specialty field. And then for particularly lawyers, we had to explain what the construction process is, so they understand that. And finally, the most important subject was writing adjudication decisions. That's the final product, because that's what the adjudicator produces at the end, which will be looked at by the court or the parties. From there, we deliver this certificate course over 5 days, but the last day is actually for exams, and there are 2 exams. One is an exam for 1 hour and 30 minutes, which is a multiple choice quiz with false or true. So the questions are set like that. It's just a 50-50 answer. And then it's followed by a 3 hour, 30 minutes adjudication decision writing assessment. Now, we have trained, I think, from when I left, I mean, the figures that have been given by the center, I asked for the latest figures, they say about 600 something, but if I remember right, we trained about 800 plus. Maybe they have not empaneled, but I suspect that we train a number of people more, quite a lot, because it was very popular at one point. At the beginning, there was a problem because people did not know what adjudication was, although they were all participating in the process. But the take-up for the course itself was actually limited, because until the first adjudications and people started to get income from it, and then a lot of people got interested, and more, I think now we are getting. There is a number of people who have been trained, and the number of disputes that have come out in Malaysia starting from 2014. We started off with 84, I think, the first year, and now we are talking about 700 disputes a year, adjudication disputes. So the numbers are growing, but it will reach a point that it has to stop, because then something is wrong with the system. But at the present moment, we will hit about 1,000 disputes, and that actually also is tied back with the economic condition. Let's say if there's a downturn, there's a cash flow crunch, like what we expect from COVID-19, then what will happen is that the numbers will just go up. The process itself is about 100 days. So if it's 100 days, the adjudicator is given 45 days to make a decision. So it's actually quite a long period. It's one of the longest period in the adjudication regimes between the 5 jurisdictions. But it was because originally it was meant for all disputes, but then we decided to actually reduce it to payment disputes, and therefore it still maintained the time frame. It is working quite well, but there are some quirks, but I think we will deal with it as it goes on. Karen, is that enough? Sorry, I couldn't get my slides on. The parties, the participants can get it from the organizers. Thank you.
Sandra, thank you very much indeed. Yes, that was perfect. That was a really interesting presentation on how an adjudication was actually set up in the recent past, and I thought it would be very interesting for you all to hear that, particularly at this time when you do need to find a way to ensure that the money keeps flowing through the system. So I want to move to my next speaker, who's Ms. Sui Im Tan. Sui is a qualified English barrister and a Malaysian advocate and solicitor. She specializes in construction, energy, and infrastructure projects and disputes. She now practices as an arbitrator and adjudicator of construction disputes in Malaysia and internationally, in fact. She has had, I'm told, a part to play in the development of much of Kuala Lumpur's fascinating skyline. She's also a keen and accomplished sailor. Sui is going to share with us her perspective, both as an adjudicator and as counsel party representative of clients in adjudication, again, substantially by reference to SEPA. Sui, over to you.
Thank you very much, Karen. And hello, everybody. As Dr. Sundra says, it's 1 a.m. here, so do excuse our lapses. Unfortunately, we're not able to share our slides with you because our slide screen share function has been disabled. So we'll do what we can. First of all, Dr. Sundra has already explained to you about the regime and how we set up the system. And Dr. Sundra is very much an architect of that system, which, as he says, is working very well. So I come here from the perspective of a user, both as a counsel, which I was for some 30 years, and then as an adjudicator. Karen has helped me to do this. Indeed. So Karen, could I have the next slide, please? And could we please have it in slide screen, full screen rather? Okay, whilst she's doing that, what I wanted to do with this slide is merely to show you an overview of the adjudication system that we have in Malaysia. Now, what I wanted to say, that apart from what Dr. Sundra is saying, which is that it's 105 working days, more or less, as the overall period from start to finish, but that's working days. So that translates into something like 5 calendar months, which, as I agree with him, is actually quite a long time. The one thing that I will say is that it is limited to payment for work done or services rendered under the construction contract. So that presumes that you have a construction contract, and in this case, it's got to be in writing. And the other thing that is unique about this is the fact that it is premised upon a party issuing a payment claim. So quite unlike jurisdictions such as Australia, for example, where the application for payment within the construction contract is the payment claim in itself, this is almost akin to a letter of demand. Now, we all know that from a construction point of view, that although you're dealing only with payment issues and strictly speaking, not with extension of time issues, nevertheless, because of the nature of where payment claims come from, including loss and expenses under the contract, definitely most adjudicators have to deal with elements of extension of time, so-called through the back door. Another thing that we should also note is the fact that in this regime, you can have a claimant who's making a claim, and you can have a respondent who's not just defending, but making a counterclaim. But suffice to say that in this regime, the respondent can not get a positive a decision in their favor. So in simple terms, at best, you zeroize the amount payable. So you can, the claimant ends up with zero payment. So if I move on now, as to, in terms of the actual sort of practice for adjudication practitioners, I think the most important thing is that one has to be very, very alive to the parameters of SEPA. And because with that comes the issue of jurisdiction. I mean, I'm sorry that sometimes it's very difficult to explain to lay clients as to why certain of their claims are not capable of being adjudicated, being outside of the parameters. But you know, that is the way this statute is set up, and therefore we have to be quite careful about jurisdictional issues and making sure that you come within the statute. I give you, for example, the fact that it's got to be a payment for work done under the contract. So for example, you've got some sort of general damages for wrongful termination, that really would not necessarily fall within the parameters of this statute. The other thing, of course, is that, you know, as with most things, it's horses for courses. So for example, if the cash flow objective of this statute is being blocked by, for example, challenges. And this comes about because within the common law system, basically most people are given their day in court, and challenges can be mounted regardless of the fact that your challenges may actually not be with merit and in fact may well be dismissed. But nevertheless, it takes time and money for those challenges to wend its way through the court system. And frankly speaking, if you have a very, very recalcitrant non-paying party, then it may be that the SEPA regime may not be the most suitable one for you, insofar as that it is it takes 5 months, is an interim, it's interimly binding, and then it may be subject to a whole series of challenges that not just wends its way through the court system, but also to the court's appeal system. So that can take time as well. There's also a question whether your particular dispute is suitable to be adjudicated if, for example, you've got a lot of issues that are outside of this, the parameters of this statute. So for example, I mean, in a construction contract, we all know that payment, of course, is central to it, but there are many, many issues surrounding that and leading to your payment entitlement. So it may be in certain cases that actually you're better off just going straight directly to arbitration. Now, the reason why I point these things out is because, you know, with adjudication, and as Dr. Sundra is saying, that everybody actually looks at it as a quick fix, so to speak, a pay first, argue later regime. Therefore, everybody tends to jump onto the bandwagon. But what I'm doing here is actually advocating that we shouldn't just blindly jump on the bandwagon, but we should actually be looking to see what actually is suitable or not so suitable for your particular situation. I mean, I'll give you an example. Some years back when I was still acting as counsel, I had some matters where I think we all knew, both sets of lawyers knew, that it was going to be a long, hard slog because the non-paying party was always going to be quite recalcitrant. So both sets of lawyers then agreed that going to adjudication under SEPA was going to be actually a time-wasting exercise. And so we decided that we should actually go for something that would be permanently binding. So it was either an ad hoc decision to go to court in spite of the arbitration clause, but we were a little bit concerned about other delays. In the end, we ended up having an ad hoc agreement to adopt fast-track arbitration under the AIAC rules. And I can say that at the end of the day, that worked out very, very well because we managed to arbitrate all the issues that were in hand. And in terms of a timeline, it wasn't terribly different from that of adjudication. So like I said, horses for courses. Moving on from there, a lot of people also will have to think about, is adjudication that we are used to being the contractual adjudication, for example, under the FIDIC form of contract, I mean, do you think that adjudication is adjudication and it's all the same? Well, experience has told us actually over the last couple of years that it's not. Again, I'll draw from the experience of a particular case that we were dealing with and when I was acting as counsel, which is that the claimant, we were acting for the respondent, the claimant in this particular case had launched a claim for something like 183 million ringgit. Now that in simple terms is about 40 million US. And there were lots of different heads of claim and different subheads of claims. And then there was obviously a counterclaim as well. Long and short of it, I mean, you ended up with a dispute of plus or minus probably about 60 million US dollars. There was the whole rigmarole of going through the statutory adjudication. And I have to say that despite all these high numbers and then high numbers of claims and subclaims, parties still actually adhered to the timeframes that were prescribed by the statute, which is basically very short because a claimant has got 10 working days to put in their adjudication claim. And that's throwing in the whole kitchen sink. And the respondent has got 10 working days similarly to rebut all that and also advance their counterclaim. And the claimant has got 5 working days after. So parties, I think, did very well to keep to that time frame, with the adjudicator being given additional time as requested. So after that happened, the adjudication decision was 0 ringgit for the claimant. So the claimant then had to, yes, actually, Dr. Sundra, what happened was that the amounts awarded in the counterclaim were higher than that in the claim. So the claimant ended up with 0 ringgit. Yeah. So thereafter, the claimant had to carry on with their dispute And so they had to resort back to the contract, which had the usual tiered dispute resolution clause, and they had to go through contractual adjudication. In this case, they involved some state enterprises, where it was very difficult to have ad hoc dispensations of certain provisions in the contract. So statutory adjudication having been done and dusted, we are now into contractual adjudication. Same sort of claims, and the arguments were pretty much similar, just a little bit streamlined. But in the end, the parties found, and certainly the lawyers found, that the preparation for the DAB in this case was very, very different, and that it was almost like as if you had to redo everything again, even though your claims and arguments are similar. And that is because you're in a different forum, your jurisdictions are different. In fact, in this case with the DAB, the jurisdiction was a lot wider. So that's all I'm saying, is that actually, adjudication is not the same under a statutory regime versus a contractual regime, because it really depends on what each of them provides for. So back to where I started, which is to say that you really have to focus on what is your objective and how to best deal with those objectives. It's a pity that we don't have the slides, because that would have given some sort of placeholders for what we're talking about. But let me now go on to talk about life as an adjudicator. As Dr. Sundra was saying, I'm a certified adjudicator because I went through those courses. In fact, I was one of the first 2 courses where, because we were already accredited arbitrators, we did not have to go through the 5 days. We went through 2 days and then we were accredited, which was very good, obviously. Now, in light of that, what are the issues that we as adjudicators face? I think the first one is that of a time limit, because regardless of what you say, the 45 working days is still something that you have to adhere to, because 1 day late and it becomes an invalid decision. And 1 day late with an invalid decision means to say that you earn no fees whatsoever, despite all the work that you may have done. And this has actually happened to one particular adjudicator who was literally 1 day late. And for that reason, as a matter of practice, what I would do as an adjudicator is that I tend to get the parties to agree calendar dates for each of the periods that are prescribed by statute. And the reason why I do that also is because we're talking here about working days, and working days means to say excludes public holidays as well as weekends. Here in Malaysia, we do have quite a lot of public holidays, but it relates also to the public holidays in the state where the construction site is located. Given that we've got 13 states and 3 federal territories with different public holidays, and in certain cases, a different weekend. In some cases, it's Saturday and Sunday. In some other cases, it's Friday and Saturday. So it becomes quite important that the actual dates, calendar dates, are actually agreed. Or in another case I had, where it is a linear project, it's a railway project, and it spanned over more than 1 state, with the lawyers being in a different state. So these are sort of the nuances that one has to be alive to in a statutory adjudication scheme, where it is actually very, very prescribed as to what you can or cannot do. So the other thing that always adjudicators are very worried about is the whole concept of natural justice. And the reason for that is because the grounds for setting aside an adjudication decision are very, very narrow. There's very, very few of them. Fraud and bribery, which is almost never heard of. Lack of jurisdiction, obviously that is something that we deal with, but most adjudicators who are experienced will not fall into that trap, so to speak. So the last one really, where a lot of people who are trying to challenge adjudication decisions will do that by way of challenging it under the lack of natural justice route. And we do see that one of the main grounds where natural justice challenges are coming up is with respect to the denial of an oral hearing. And I think the courts basically in Malaysia are being very, very supportive, and that's good, because it means to say that we are not under such scrutiny to the extent that it actually causes a paranoia with the adjudicators. And the courts are basically saying with regards to oral hearings is that it is a denial of natural justice if you deny the oral hearing for no reason, or for example, a reason such as, oh, there wasn't enough time. Because I mean, I think time can be controlled and you can actually create a situation by getting the parties to agree an extension of time as an example. But I mean, just recently as an example, I did deny the parties the oral hearing despite the application on the basis that the claimant who applied for it had stated specifically that they were not going to introduce any new evidence in the oral hearing. So the rationale behind that was, why then? What's the purpose of it? So moving on from there, we also have to think about how you're going to be able to make your decision, not just in a timely manner, but in a well-reasoned manner and in a very logical manner, such that actually the parties understand why the decision came about, where it came about, and why they are in the position, in the situation that they are. So where that is concerned, I often urge the parties to basically help us to help you. You know, in that large case when we were acting as counsel, we went so far as to for the parties to agree. So a decision-making flowchart for the arbitrator, for the adjudicator, just to assist in that whole decision-making process. And you know, I mean, I'm a lawyer, so perhaps what I'm saying is it would not be agreed to by the non-lawyer adjudicators, which is that quite often we find that the technical adjudicators who are not lawyers, they don't actually set up the reasoning well enough, and you have a long recitation of the facts of the case, but when it comes to the actual decision itself, you find that it's not fully reasoned. But enough of that.
I'm sorry, but I'm going to have to cut in just so that we can hear from Anand before the end of the session.
Of course.
But can I just say that we and Sundra have got slides which I commend to you all, and indeed so does Anand. Let me briefly introduce Anand. Anand Jadoo is a chartered quantity surveyor, appearing many times on behalf of parties as an expert or claims consultant in arbitration, litigation, adjudication. He holds himself an LLB and master's degree in law. He is also a chartered arbitrator and adjudicator. His task this afternoon is to share with you his expertise as an expert and explain the role and value of quantum experts in adjudication proceedings. One thing you won't see on his CV is that he is a very successful owner of racehorses in Mauritius. Anand, over to you. Anand, you need to unmute.
Thank you, Karen. Can you hear me? Good. Thanks, Karen, and thank you to the JIAC and Chris Malcolm especially for inviting me on this panel. And I am going to give this presentation on expert evidence, as you would normally see widely, in fact, applicable in adjudication. So what is an expert witness? An expert witness, as opposed to a lay witness, is a person engaged to give opinion based on experience, knowledge, and expertise. And I stress on the word expertise. So for the purpose of the presentation, I shall be referring to the statutory adjudication under the Housing Grants Construction and Regeneration Act of 1996 in the UK. Karen has actually introduced the act already at the start of this panel. So issue of the evidence in adjudication proceedings is very tricky. Unlike litigation, there are no hard and fast rules on what can be presented and how this should occur. As a general rule, there are no strict criteria as to format and type of evidence which must be provided in an adjudication to resolve a construction dispute. Although an adjudication which is normally governed by the scheme for construction contracts may have its own provision for production of evidence. But experts, when giving evidence, however, have to abide by professional rules and conducts of their profession. For example, the RICS guidelines for surveyors acting as expert witness. It is in my experience that expert involvement is commonplace nowadays in adjudication, within the referral and as well as the response. Bear in mind that the Act has a total of 28 days. The adjudicator has a total of 28 days within which to issue his decision. And of course, a further 14 days if both parties agree to extend from the notice of appointment of the adjudicator. So how does the expert contribute to easing the duties of the adjudicator on behalf of the referral party? Let me look at it from the referral party first of all, and then I'll respond on the responding party. So a referral party has, in fact, 7 days in which to have to serve its new claim. The big advantage here is that the referral party has over the responding party is that it has ample time within which to prepare its case before issuing the notice. So in the case of a referral party, experts are normally hired prior to the notice of adjudication. And here the expert will normally, in the case that I've been involved, I will normally be involved initially as an advisory capacity. And then I proceed later on to prepare a report in support of the claim. However, a note of caution here is that if the question of expert evidence arises and the report is disclosed and produced only within the referral notice, this may have an impact on whether or not the dispute has crystallized, and thus whether the dispute can yet be referred to adjudication. So a referring party must ensure the expert evidence is disclosed to the other side before the referrals, if it is to be relied on in the adjudication. This also may help in avoiding jurisdictional challenges. For the responding party, on the other hand, it goes without saying that the referral is served, the responding party should immediately begin to prepare the response, because the responding party has also 7 days within which to serve the notice or the response. Bear in mind that the referral party have had maybe 2 months or 3 months. So the priority of the responding party must avoid any last-minute rush, which may impact on the quality of the response. And it should really look at tackle the issues which have been raised in the referral notice and address each and every one respectively. So in terms of contents of the response, the same rules will apply to responses as well as to referrals. So they should be, first of all, very clear, to the point, and they should follow a logical structure, usually with reference to the point raised in the referral as appropriate. In most adjudication, the only opportunity an expert has to explain their opinion is in the report itself, which is produced for the adjudication. And it takes on a very much more crucial role when the adjudicator decides not to hold a meeting, where, for example, a meeting of experts, where the question arises as to how much weight the adjudication should give to the expert report. So in such event, as I said earlier, it is very crucial that the expert report addresses the issues in a clear and understandable manner. Very simply put to the adjudicator. And each opinion must be reasoned as well as substantiated. And when they're writing, of course, a report, the expert must remember that the adjudicator is also under pressure. So it should clearly and concisely tell the story, set out the clear reasons for its opinion, ensure that any document referred to are attached and clearly cross-referenced in the text. An expert report is essential in the adjudication if written very well. It can assist the adjudicator in deciding the disputes, bearing in mind that if you take out this 14 days for the reference and the referral and the response, there's only 14 days for the decision to be issued. So all report is often produced under pressure. The expert should guard against advocating the instructing party's case. And of course, straying into the territory of a hired gun And I'm sure there's a lot of case law on hired guns. So I don't think an expert should go along that route. So when producing a report quickly, and sometimes with limited access to evidence, the expert should really sift and choose. So in my view, despite being a temptation to be overly confident about a party's case, a report that is objective, and neutral is more likely to be more persuasive. So the key to success in an adjudication is clearly adequate preparation, bearing in mind the difference between the response and the reference and the response, the time that they have. So the time scale are very short, and last minute rush should be avoided if at all possible to ensure the response is of good quality. So now let me turn, for example, between statutory adjudication and contractual adjudication. Statutory adjudication, according to the UK Act, has got 28 days within which to issue a decision from the date of the notice. There should be independence and impartiality of both the adjudicator as well as the expert witness. The role of the witness is very clear and has and should help the court, the adjudication, rather than advocating. On the other hand, the role of an expert in contractual adjudication is quite different. In this case here, I will refer to the FIDIT Reg book. Subclause 20.2 deals with adjudication decisions and so on. So the parties appoint the DAB, which consists of 3 adjudicators, 1 nominated by each party, and then both parties nominate the chairman. So the DAB, the Dispute Adjudication Board, has 84 days to issue a decision from the date of the notice. These adjudicators are normally technical persons. They are expert in their profession. And then, of course, decision run to be issued within 84 days from the date the notice of serve. And in the other, in the contrast to the statutory adjudication, the parties witness can act also as an expert because they are in fact going to be the people on the side. So how you will tell me what the expert can bring to the process, to the adjudication process. Well, I will not dwell too much over it in view of the time element, but I've said already, the expert must provide opinion evidence. Within his expertise, he should provide a very clear and concise report, expert report. The document must be solid and substantiated, and of course, backed up by document, case law, and so on. And finally, before I end, I would like to give some tips, for example, where the expert evidence can be used succinctly in adjudication and quite effectively. First of all, prepare a very succinct report. Don't go into writing a book. The adjudicator has no time to read it within the 28 days or the 14 days left for him to do a decision. Deal with the matters in dispute. Refrain from bringing items not included in the referral or the response. Provide the adjudicator with reasons for all opinions advanced in its report. Provide support to the adjudicator, and this is very essential because you need to help your adjudicator by including a range of opinion based on possible outcomes, which the adjudicator can actually choose, depending on the route that he chooses. Provide a very well presented report, which include document, cross-references, various tabs to ease the task of the adjudicator, as this will save time and cost in sort of prevailing the issue regarding extension of the period. The adjudicator must be non-partisan as much as possible. Provide the expert report to the other party, give the opportunity to the other parties so that there is no ambush. During a hearing, if there is one, the expert should provide a background to the evidence contained in his report and explain his approach so that the adjudicator can clearly understand. And finally, the adjudicator must declare right from the start any conflict. The expert must declare conflict well in advance, because if that comes out during the course of the adjudication, then there's a lot of time and expenses will be wasted. Thank you, Karen. Over to you.
Thank you very much, Anand, not least for keeping very smartly to time. If there's one thing I didn't hear you say about experts, and I would say myself as an adjudicator, the thing I appreciate is brevity. You spoke about adjudicators having 2 weeks to render decisions. In fact, I must say under the English system, which as you all just heard is very short, you're lucky if you get a clear week. Because if there's one thing, particularly lawyers don't do, it's pipe down. They just keep going. Somebody says something, somebody replies. It's a very, very fast system. But for all these things I say, it is incredibly effective. Now, I don't see any questions, but I have some for my panelists. You'll be pleased to hear. And I think what I'll do is I'll start with a question, if I could start with you, Sundra, and if perhaps I could share it amongst the three of you. So Sundra, first of all, for you, as the architect of the Malaysian system, if you were producing a new statutory adjudication system for a country today, are there any things you would do differently?
Yes, I think the first thing is that we will have to decide the extent of disputes that have to be adjudicated. The statute, I think one of the problems is that it has to be clearly written to prevent adjudication decisions being re-litigated in the courts. In fact, I think that's where the real problem is that once the courts get involved in it, the temporary finality is postponed. So I think this is something that if I had to redo the system, I will actually put a short stop. I won't do a long stop, but a short stop, so that adjudication decisions are honored, at least for that moment. The other problem is that, which we never expected, adjudication amounts, disputes, some of them became very, very large, because of the final account. The largest dispute that I handled in the center administered was a billion ringgit, a billion, about I think it's about, if I'm not mistaken, about 800 million US, and the adjudication decision came out to about 200 over million US. And then at the end of it is that, it was all decided in 100 days. It was a complex oil and gas platform of a floating platform. So, in fact, it was, I think, highly unsuitable, the process, to actually come out with the decision. So they went to arbitration and the whole thing got reversed because the cash flow was there, but the decision did not seem to be the correct decision. So I felt that maybe we have to actually look at that. To what extent you want very large decisions to be decided by adjudication? Maybe it's not suitable at all. Karen, you may disagree because in the United Kingdom, you all deal with all disputes, so it doesn't really matter. And because I think that is why I think the courts are struggling with it. They are trying to bring in this notion of natural justice, a right to be heard. They want to allow more things to be put in. And then I think even they have go to such an extent. Originally, when we decided on adjudication, we said there need not be a hearing because it is going to be done on paper and that is going to be a process that is expedited. But now there is a suggestion there must be a hearing. So I think the moment you have a hearing, it just becomes a bit more complex. So I will just do that.
Yeah, let me move to, they're very interesting points, Sundra. And in fact, it's the duty of every adjudicator, as we know, though, if they feel that the case is too big, too complex to be decided within the time available, then they should resign, they should refuse it. But that is seldom the case. So you do end up with problems that you've just outlined. So Anand, in 30 seconds, please, you're in a jurisdiction in Mauritius where you don't yet have adjudication, and it's a long time coming, without wishing to be disparaging. It's been on the blocks a while now, as you know. What are the obstacles? What are the principal obstacles to getting this adjudication, statutory adjudication system into the statute book?
Well, first of all, not to be sort of critical to the politicians, is that they have got, like in French, they would say, "Il y a d'autres chats à fouetter." So they have got other duties to carry out. I mean, the adjudication bill is not really something which is urgent to them. But I have heard that this new government, which came into power about 2 months ago, in November, December, they are looking at introducing the adjudication bill. But in terms of putting a time frame, there might be difficult. But you'll be very happy to hear that in the COVID bill, just before the lifting of before COVID-free Mauritius, in fact, has actually provided for, in the Finance Act, for payments to be made 28 days from the date of claim, which is what is provided under the Act, under the bill. There should be consideration for variation, even if the contract is fixed price. So all those measures are actually helping out the industry. So I hope that things will pan out very soon.
Thank you very much indeed. Swee, very quickly, how important is it to the success of statutory adjudication schemes to have a tailored system of enforcement in the state court system? As quickly as you can, please.
I think it's very important because it's all about enforcement. There's no point having a piece of paper that you can't convert into cash. And this is where the SEPA has got 3 very, very good, very practical ways of doing it. And probably the best one of all is actually the ability, as let's say you're a subcontractor and you've got a decision against a main contractor who's not paid you. That decision can be taken to the employer, one step above the main contractor, and the employer is bound under the statute to pay to you directly. So I think that's very, very effective. The other one is actually that although a lot of contracts may not have the right to suspend work for non-payment, one of the ways of enforcing an adjudication decision is actually to stop work. The problem is, of course, that for a lot of contractors, they are not embarking on statutory adjudication during the course of the works. So they tend to, as Dato says, leave it to the final account, by which time there's no work to be stopped. So, it's a lost opportunity.
Okay, that's great. Thank you very much indeed to all of my 3 panel members. Thank you for your preparation and thank you for your participation. So back to you.
Thank you.
Thank you.
Hello, Sean.
Hi, Chris. Good afternoon, everybody. Okay, I guess we'll proceed with our panel now. Hi, Judith, James. Is everybody here? Can you hear me? Can you see me?
Yes, I can hear you. I can see you.
Okay, great. Okay, we'll begin. This panel is captioned Mediation in Commercial Arrangements. So again, good afternoon to all my colleagues, distinguished guests, and also a sincere thanks to Christopher, Malcolm, and the team for organizing this conference in the circumstances that we're all facing. For those of you who don't know who I am, my name is Sean Henriquez. I'm from Jamaica, in particular, Montego Bay, the rail capital of Jamaica. I am an attorney at law, a fellow of the Chartered Institute of Arbitrators, International Mediation, and really for the purposes of this panel, which I will be moderating, I have been an accredited mediator for the last 18 years plus. I'm very pleased to briefly introduce my colleagues on a panel today who are well recognized internationally as experts in the field of international dispute resolution. Obviously, you will have already received their more detailed bios in the conference materials. First is Dr. Judith Nieper, who is a well-known legal consultant with about 30 years of professional experience with various major institutions and who is currently engaged at the UNCITRAL Secretariat in Vienna, Austria. She's also responsible, as I understand, for UNCITRAL's transparency standards. Judith will be taking us through UNCITRAL's overall mandate, its objectives, and the various aspects of the drafting process for the Singapore Convention and the reasoning behind particular articles. Next is Mr. James Dhingra. He is a chartered arbitrator, adjudicator, mediator, and an ADR consultant, professionally engaged between Singapore and Hong Kong, specializing in offshore oil and gas and the maritime and construction sectors of the industry. James will be embarking on contrasting various issues between the New York and Singapore conventions in the context of resolving shipping-related disputes. Mr. James McPherson is next. James is an international ADR specialist with 25 years of experience, most recently as special counsel establishing Saudi Arabia's first ADR center, the Saudi Center for Commercial Arbitration. James is also the co-founder and inaugural CEO of the Bahrain Commercial Dispute Resolution, Bahrain Center for Dispute Resolution, and the American Arbitration Association joint initiative. And he's also a former International Mediation Institute board member. Currently, he is a board member of the Oman Arbitration Center and also a successful international mediator and facilitator. James will tackle some of the concerns already being discussed regarding the Singapore Convention. All of the above should provide us with some invaluable insight. I'm going to ask that we keep any questions for after all the panelists have finished their presentations. Yeah? Okay, the aim of this panel, as the caption indicates, is to discuss the dispute resolution process known as mediation and its place in commercial arrangements, so that we can have a better understanding as to how mediation is being promoted and supported as an appropriate option for dispute resolution, especially for international commercial transactions, and as a major component in the wider context of dispute management. Dispute management, being the substantive theme of this one-day conference, includes methods of prevention, avoidance, resolution of disputes, including litigation, along with systems, processes, and rules designed to better regulate the various components of dispute management. I believe we are all well aware of the reasons why reasonable people would prefer to avoid disputes altogether, certainly lengthy ones. And we should appreciate the need to enhance general awareness of the existing framework for dispute management, as well as awareness of any concerns and thoughts for improvement going forward. We know generally that mediation involves disputing parties engaging a trusted third-party neutral to join them in discussing potential options for the parties themselves to determine terms for a binding settlement agreement between them. Whereas arbitration involves a said third-party neutral considering the disputants' respective positions and rendering a binding award, effectively private litigation. As indicated, these are currently two main international commercial dispute resolution approaches. The United Nations Commission on International Trade Law, UNCITRAL, has played a significant role in supporting international commerce and establishing systems of dispute management, with a framework comprising a suite of complementary instruments towards more unified laws and the development of international trade, which will be discussed further by the panel. These include the Convention on Contracts for the International Sale of Goods, the CISG, to which Jamaica is not yet a signatory, but which was discussed earlier. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, to which Jamaica is a contracting state, and also the Convention on International Settlement Agreements resulting from mediation, the Singapore Convention, to which Jamaica is proudly one of the first signatories. Jamaica's efforts towards establishing an effective dispute management regime are clearly evident, including the Arbitration Act 2017, which is based on the UNCITRAL model law and which at Part 5 also provides for mediation during the arbitral process. Additionally, Jamaica's Supreme Court Civil Procedure Rules, Part 74, also provide for mediation to be attempted in most civil matters. And as indicated above, Jamaica is also one of the initial signatories to the Singapore Convention, due into force in September 2020. UNCITRAL also has a model law on international commercial mediation and international settlement agreements resulting from mediation, which along with the CISG may be of benefit to Jamaica's dispute management package and its efforts to attract investment going forward. I'm now going to invite Dr. Judith Nieper to take the discussion further. Firstly, I know that all my panelists have slide presentations they would like to mount, and we have been having some challenges, so please bear with us and hopefully we'll be able to sort things out and make the panel presentation of interest nonetheless. Yeah? So Judith.
Hello.
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 Yes, hello. I was hoping to see my slides. I think this is not going.
Okay, I thought I lost you there. Sorry. Good.
Yeah, it's not possible to upload the slides.
No, and I'm still disabled. So, and I've sent them to Chris. So hopefully we'll sort it out. But hopefully we can still have an interesting session. So Judith, you're in command.
Okay, so we need to improvise, which is maybe part of our topic, improvisation. I will still follow my slides because I can see them properly.
Good.
I heard something?
I think somebody's mic is on.
Okay. So what I wanted to talk about, and because we had so many issues when preparing the seminar, that Shaun already did a quick summary of what all of us are going to say. What I would like to insist on is really the way of drafting UNCITRAL instruments, because this is extremely important to understand and to use our instruments. And that's why I would like to come back shortly on what UNCITRAL is. It's an intergovernmental body with limited membership. We have 60 members. And it's the core legal body of the UN system in the field of private international law. And I'm seeing there's a typo in my slides, so it's good that I can't share them. UNCITRAL has been established in 1966, so it's more than 50 years now that UNCITRAL is trying to fulfill its mandate, which consists of modernization and harmonization of international trade law. What is important is that while we have 60 member states that are picked from the different various geographical regions from the world to be able to represent every economic, every legal system, we have always 14 states from Africa, 14 from the Asia-Pacific region, 10 from Latin America and the Caribbean, 8 from Eastern Europe, and 14 from Western Europe and others. So this is the core states that are discussing our instruments. But, and this is the important issue, all observer states, all member states of the United Nations are always invited to all of our sessions. So we do send out for every working group session, for every commission session, we do send out 193 invitations. And every state that would like to participate in any of our 6 working groups is able to do so, and is able to follow the negotiations in the 6 UN languages. So we do discuss, and you find everything on the website in the 6 UN languages. When we were preparing the panel, the 4 of us had long discussions, and one part of the discussions was on what mediation really is. We heard already from the minister how important it is, what are the main features. I just want to repeat them because it cannot be repeated often enough. So mediation is a flexible process that can be tailored freely by the parties to the needs. And that's probably the beauty and the essence of the mediation process. It's a voluntary process throughout the process. So it's not a judicatory process and it's not formal. So you do not need to rely on a complex set of rules and a complex procedure. The aim, if you want to put it shortly, is to reach a shift from the adversarial perspective to a solution-oriented perspective. If you could have seen my slides, you would read there, you should shift from one party against the other to both parties against the problem. And I think this is the essence of mediation. UNCITRAL is engaged in mediation since very long time. So we had the first instrument in that area was already adopted in 1980. And these were the UNCITRAL conciliation rules. You may notice that I was speaking of mediation before. From an UNCITRAL perspective, the terms conciliation, mediation are used interchangeably. We make no difference whatsoever in these two terms, but we decided now to take as the lead term for the new instruments the term of mediation, because obviously, and this is different than in 1980, this is the term that is mainly used. So 1980, we had the conciliation rules, and in 2002, we developed a model law on international commercial conciliation. That was still before the change of terminology. Here you could have seen a photo from the working group. I forgot that you don't see my slides. I hope that that we could make them available later on the website. What we do have now, after the work of the working group, is conciliation rules that are currently in the process of being updated to make them mediation rules and to update them from 1980. So to include the work and the developments that has been done since 50 years, basically, 40 years. Then we have the UNCITRAL model on conciliation, which has been updated to include a session on enforcement. At the time, in 2002, it was said there's possibly no possibility to reach an agreement on enforcement because the different legal systems are just too diverse. Now, in 2018, 2020, we reached an agreement, we reached an instrument in the area of enforcement, and that's why the UNCITRAL model law has also been updated. And then we have, and that has been already mentioned several times, it has been mentioned from the start in the opening by several of the speakers, had been mentioned by Angelo, it had been mentioned by the minister, it had been mentioned by other speakers, the Singapore Convention, called Singapore Convention because it has been open for signature in Singapore on 7th August 2019. And then we are having a last text we are currently working on, and these are draft notes on mediation. This is the try to explain the essence of mediation in a way that it would fit into all legal systems. So it's the basic elements of what UNCITRAL understands as being the main elements of mediation. We have for the Singapore Convention, and this is again something that has already been said, but it cannot be said often enough. We have 52 signatory states already at that point in time. Among them, for instance, the United States, China, India, and, as it has already been said, of course, Jamaica. We have already 4 ratifications, which is why the Singapore Convention will enter into force on 12th September of this year, which is, from our perspective, very quick if we compare with other conventions in the area trade law. So what are the general principles of the convention? The main article with the main general principle is Article 3, which says that state parties to the convention shall enforce a settlement agreement resulting from mediation. And if a dispute is already resolved by a settlement agreement, the disputing party is allowed to invoke it. So this is the core of the Singapore Convention. There are certain issues that are excluded from the scope of the convention. And these are issues that might be very well suited for mediation, but maybe on a national level. What we are talking about is really international mediation. So what has been included is personal, family, inheritance, employment matters. And then we have excluded all settlements that are already enforceable as a judgment or as an arbitral award. And that has been done in order to avoid possible overlap with existing conventions like the New York Convention, like the Convention on Choice of Court Agreements, like the Convention on the Recognition and Enforcement of Foreign Judgment in Civil or Commercial matters. There are a certain number of elements you need to have in order to be able to rely on a settlement agreement. So it's the signatures of the parties on the agreement. You need to present evidence that the settlement agreement resulted from mediation. That could be the mediator's signature on the document. That could be the attestation by the mediation institution. The way it has been drafted is quite broad. Then you need, of course, translations because we are discussing in an international context. There are certain grounds for refusing to grant reliefs, and these are grounds that have been heavily influenced by the grounds of the outlined in the New York Convention. So you will find incapacity of the parties. You will find certain concerns in relation to the settlement agreement. For instance, if the settlement agreement is null and void, inoperative, incapable of being performed, if it's not binding, not final, has been subsequently modified, or if the obligations in the settlement agreements have already been performed, are not clear, are not comprehensible. If granting relief is contrary to the terms of the agreement, if there is some issues with public policies, if the subject matter is not able to be mediated, and there is also the elements of a serious breach by the mediator of standards, but only if without that breach the parties would not have signed the settlement agreement. Oh, do I see my presentation here?
Yes, you do.
Wow, I recognize it. This is a moment of pride. So maybe we can go quickly to slide 6, because this is the photo of the working group.
Yes, I'll manage it. I'll give you a couple of minutes. So go ahead quickly.
So this is the photo of the working group, and you see everyone tired but happy because that has been done just after we negotiated the update of the conciliation law, so the new mediation law and the Singapore Convention. You can continue, go further down, maybe. Can I do it? No, yes. I cannot do it.
Have you no control? Can you share?
Yes, do you want me to go further?
Yes.
I am in control.
Control, yeah.
Yes.
You can tell me, shall I go further?
Yes. So I have really no control over my slides, which is nice. Here you see, here you see we are a good team. One is pushing the button, the other one is speaking. So here you see the complete UNCITRAL mediation framework. I was already talking about that. So you have the conciliation rules that will be updated. You have the model law from 2002 that has been updated, and the guide is currently updated. You have the Singapore Convention, and you have the draft notes on mediation. The draft notes and the draft mediation rules, you already find them on our website, by the way. Could you go down further? Next slide. So this is a slide I wanted to show you because we are proud on it. If you go back, this is the map of all the signatory states, and that's of course very important. So you see everything that is in blue is are signatories to the Singapore Convention, and this is quite impressive for a trade convention. So the New York Convention didn't have such a good start at the beginning. So hopefully that continues. You can continue with the slide, please. Yeah, you can jump some slides because I already did it. Yes, so here, so that was the general principle. Here you have the exclusions from the scope. Here you have the requirements for reliance on the settlement agreement. Here, the next slide is all the grounds for refusing to grant relief. I was just discussing that. So E and F are those grounds that where you need the serious breach must have led to the conclusion of the settlement agreement. So it's not the serious breach alone doesn't constitute a ground for refusing to grant relief. Next slide, please. Yeah, you have two reservations. You have one reservation that states can, so that the convention is the highest degree of harmonization you can find. And this is why states often agree to include certain reservations. And these are the two reservations that have been included in the Singapore Convention. So one is states might wish to exclude or persons acting on behalf of a governmental agency being a party. That will have an influence on mediation in the ISDS context. And then you have the second reservation. And this is that some states were fearing that disputing parties would be surprised by the enforceability of a mediated settlement agreement. And that's why a state is entitled to raise the reservation that disputing parties have to explicitly agree to the application of the convention. From what we see till now, the 52 states that signed up to it, or those who ratified already, did not raise the second declaration. The first reservation, yes, there are some states that already said that they want to exclude mediation in the ISDS context. So it applies, the convention applies to settlement agreements concluded after the convention entered into force. Next slide, please. And this is a very short overview of the model law. So the basis is the model law on the international commercial conciliation. It has just been topped up by the enforcement section, and it's a law that would have that would regulate the procedure from the very beginning till the very end, the enforcement stage. And that's the difference to the Singapore Convention, because the Singapore Convention is only dealing with the enforcement, whereas the model law has a much broader scope. Thank you. Next slide. And I think, yes, this is already my next slide. My last slide. I think we should keep the presentation short to be able to have further possibility to discuss at a later stage. So I hand it back to the team.
Thank you, Judith. Thank you for coming in and rushing through and finally getting your presentation on board, giving us an overview and a foundation for the UNCITRAL's involvement and never-ending efforts towards dispute resolution, in particular mediation. James, I'm going to rush over to you now. So.
Good And thank you, Judith. I believe you can see my slides now.
Yes.
Okay, thank you, Judith, for an excellent presentation, though your slides were halfway. And laying the framework for me, that was quite clear. And now to demonstrate how one would apply, I take the example of offshore and marine industry segments with focus on charter party agreements. First of all, my greetings to all the participants of this conference. I believe we have a number of people with exposure to charter party agreements. In maritime, unlike in shore-based contracts, the parties are not well known to each other. Like, you can see me, I can't see you. The ship, people can see, charters can see, but the ship cannot see who the charters are. So it is not very conducive to have a relationship. It's a more contract, which is called charter party agreement. They're often negotiated through brokers based on standard forms, standard charter party forms. For example, if you have tankers to be chartered, you will use Shell time or BP voyage or BP time. In most other segments, you have BIMCO charter party forms, which are very popular, and they're quite common. And when the dispute arises, the general tendency over the decades has been that if negotiations failed, and there's a limited time available to initiate a legal action within 6 months to maximum 1 year from the date of incident or dispute. So it is common practice to proceed with arbitration or litigation first and negotiate later. So in this context and culture of international arbitration savvy industry, if Singapore Mediation Convention and enforceability of settled agreements is to be introduced, there are a few immediate questions or concepts which must be understood first before a party would agree for mediation first approach. So in the past and in the present, there are multi-tier, multi-fronts. So charter party forms have tiers, but no sequence. Which one first, which one later? Mediation first, negotiation first, or arbitration first, or start all together? And where we are heading in the future? Should be chaotic or should be some organized way of going about it? So if you look at the New York Convention, in maritime industry, everybody is familiar, seat of arbitration, law of arbitration, arbitration rules, etc. So in mediation, the first question will be, is there a place of mediation written in the agreement? No. Is it virtual? Don't know. What's the law applicable to the mediation process? Mediation institution rules? And which country? Country for settlement agreement enforcement? Can the settlement agreement be enforced? And whether the country is a Singapore Mediation Convention country? And as a settlement agreement, can it be registered as a judgment of a court? For example, in Singapore Mediation Act 2017, Section 12 requires if the mediation is held in Singapore and held by under the auspices of a designated institution by recognized and accredited mediators, then only it can be entered as a judgment of the court. So what happens under the context of Singapore Convention? If I go to the standard charter party form, those people who are familiar with this, they know BIMCO mediation clause. Now, if you look at the text of this mediation clause, how this can function properly. When the first part says, either party may at any time and from time to time elect to refer the dispute or part of the dispute mediation by service of the other party written notice, etc. In this case, there is no certainty. If there is some certainty, the mediation can be a game changer. If you look into this one and go further down, We see in this clause 5, either party may advise the tribunal that they have agreed to mediation. There is a presumption that arbitration has already started and then we are going for mediation. Now, arbitration procedures shall continue during the conduct of the mediation. That means a party who is liable to pay is willing to go for mediation, maybe to delay the arbitration process, but not in sincere terms. And the party who is asking for mediation is the party confident that mediation agreement, the settlement agreement will be enforceable. So there is lots of uncertainties here. For mediation to be effective, the commencement of mediation from the date of notice of mediation should be regarded as a legal action has commenced. Because under maritime claims or under maritime disputes, there is a limitation of time within 6 months or 1 year, or maximum 2 years if it is contractual dispute. But normally is 6 months to 1 year. Within that period, if the action is not started, it is considered as time barred and there is no litigation and no arbitration can be commenced. Can mediation notice to mediate to the other party be treated as a legal step, as a commencement of the legal proceeding? Model law on mediation, as well as the mediation convention, is silent. It does not provide. So if I take a critic's view of the pre-printed form of a BIMCO mediation clause and take out some bullet points here. In the existing system, there is no governing law, not stated, so recognition is doubtful. Place of mediation, parties to agree. There is a remote possibility because they don't know each other and they have not been in talk. Negotiation has failed. Institution, not stated. Mediation rules, parties to agree. Party autonomy is full flexi. There are so many flexibilities available in the pre-printed form that very difficult to come to a understanding or an agreement that we should go for mediation. Thanks to the Singapore Mediation Convention, that some order and some sense can be put in place. For example, stage 1 should be negotiations at stakeholders level, at top management level, followed by mediation. In the mediation clause, all this should be stated, like in the arbitration clause. This is the last stage, arbitration or court. So what shall be done? In short, I would say there should be prescribed stages. Yes, we want mediation to be flexi, should be more amicable and between the parties' choice, and there should be not so much of regulation, but there should be some prescription, not regulated, but at the same time, there should be some step-by-step prescription. So first thing, delete the pre-printed clauses and the default provision in the relevant box, which is normally called part 1 of the Charter Party Agreement form. Think of the sequence of steps. For example, negotiate first, mediation clause, then must mention the institution. I just, for example's sake, I put 2 institutions here, or in a state where mediation act or regulation have been enacted. For example, Singapore, Hong Kong, Malaysia, there is a mediation act which provides step-by-step and recognition and everything. Mediator to be appointed by mediation center or institution. Limit the stages when mediation starts and stops. Only if the mediation fails, then the arbitration should start. So what I'm trying to say here, a model clause, which suggests a dispute, if not resolved by negotiation pursuant to article within certain number of days, a party to dispute shall attempt to jointly nominate a neutral mediator. If not, then proceed to the next within number of days. There is some sort of a prescription step-by-step procedure. It gives the party sufficient autonomy, flexibility, choices. At the same time, it lays down the groundwork. Now, with the Singapore Convention, this clause can be inserted. For example, under the Convention Article 8(1)(b), if there are reservations, for example, in the Singapore Mediation Act, there's a reservation. And if other countries have reservation, that in the mediation clause, there should be a statement that settlement agreement shall be governed by the United Nations Convention on International Settlement Agreements resulting from mediation. It makes the clause a game changer and convincing for the parties to really go for mediation. And settlement agreement shall be enforceable as a judgment or as an arbitral award. So if dispute is not resolved, so what happens here? If it is not resolved, then at least there should be an outcome, a specific outcome. That means either the party has abandoned or the party has participated, but it was not helpful. Both parties have, with genuine interest, tried to negotiate. So the cost factor in the arbitration or litigation will depend on the mediation, how it was. If one party has abandoned or not participated, then of course the initiating party will get costs. Second outcome will be that commencement of mediation was actually commencement of a legal action under the contract. So that has to be stated. And the third outcome will be a settlement agreement. And it's very common in maritime, have a settlement agreement. Okay, I will pay you a certain amount, X percentage today, X percentage after you deliver or perform the function. So by the time the ship completes the voyage, delivers the cargo, then the other party backs out. So there is a requirement for enforceability. And enforceability is the most important aspect of Singapore Convention. And that has to be recognized. And that is possible when we understand which countries, which place, and whether reservations are there or not, whether we should put according to this clause as a model clause or modify it further. With that, I thank you for your attention, and I pass to my colleague, Mr. James McPherson. He will share with you some more practical consideration and challenges, if any, for enforcement of settlement agreements. Thank you. That is not my voice, but I think
Hi. Someone's microphone is on, so perhaps we can. I can't hear Sean.
James, to you now.
Okay, very good. Well,
Okay.
my presentation is essentially aimed, and thank you both Judith, Sean, and James, for practitioners, counsel, parties, neutrals, judges, institutions, those who are going to be using or working within and around the actual convention itself. So a lot of the people in this call are going to be mediators or counsel or members of the judiciary or institutional providers. So I'm hoping to just highlight a couple of practical considerations at this time. I think, oh, thank you. Am I in control of this? No.
No, I am in control.
Very good. I always like James though. So
I'm a neutral. I'm a neutral party here.
Alhamdulillah. Okay, so the first I'm going to talk about is the context. The second, I'm going to discuss briefly the role of enforcement and the role of the mediator, grounds for refusal to enforce, and building confidence and the model vis-a-vis and with the model law and outreach. So the first slide there, which I can see here on my screen, I wanted to just highlight a couple of things. It was noted that only 4 countries have actually ratified states so far, but as was pointed out, and I actually put her words in there, as Judith pointed out, this is yet no convention in the area of trade was signed up by so many states in such a short time and entered the force so quickly. So we can anticipate that given the level of sophistications of various jurisdictions, that this is going to continue moving at pace. They had a historic number of signatories. They were already moving at a great pace in terms of ratifications. Now, there are some consequences about this, of course. One of them is jurisprudence. It's going to take several years. That's why at the top of the slide, I wrote 2020, 2022. I think it will be as fast as that, only a couple of years before there will be some jurisprudence rather, because I think a lot of people are going to be exploring this. But I think this will sort itself out quite quickly. In terms of that, the only real question for the judges and for parties trying to navigate this is definitional clarity. Now, and specifically the definitions for conduct and breach, which can be open to interpretation. But as Judith already mentioned, in various ways, let's put it this way, the hurdle is quite high, because not only does it have to be a breach in terms of professional conduct or failure to disclose and so on, but it has to have an impact on actually and have been relied on by the parties themselves. And but for this misinterpretation or breach of conduct, they would not have entered into this agreement the way they did. So it's a pretty high bar. In terms of practice uniformity, obviously the New York Convention is much more ubiquitous because it's been around much longer. So there's been a considerable coalescence and convergence in terms of institutional practice, in terms of soft law, like the IBA guidelines and so on. So I think that we can expect to see practice uniformity within a few years coming about. Again, because I think a lot of people, whoever they are, whether they're judges, mediators, others, they will all be thinking about this in a fairly sophisticated manner and building upon what occurred under the development of the New York Convention. Can you go to the next slide? Right. So in terms of enforcement of the role of the mediator, I think it's really important to bear in mind that the party wishing to enforce it has to supply the competent authority with a signed settlement agreement and have evidence. Now, there are 4 primary sources of proof. Obviously, the mediator's signature in the agreement itself, the settlement agreement, and I'll talk about that in a moment. But second, a document signed by the mediator confirming the mediation was carried out. And if this is an ad hoc mediation, obviously there is no institution in the background as yet, so this is probably the preferred method. Third would be confirmation by the institution administering the mediation. And then the last one would be from the competent, that would be acceptable to the competent authority. Now, there's a few practical matters, and we could even call them cultural issues, that mediators frequently do not, for example, like to be involved in enforcing mediations themselves. And for example, in the United States, Canada, and elsewhere, and I'm sure a lot of the people on this webinar find themselves in this situation as mediators around the world, they don't like to sign the settlement agreements themselves. Now, one of the solutions to this is that they obtain the mediator's attestation on a separate document, as it's referred to above as a document signed by the mediator confirming that it was carried out. So this is just to confirm that a contemporaneous settlement agreement, which they're not signing, is in fact the result of the mediation itself. So I think that can go a long way. If you go to the next slide, I just thought it would be good to touch upon, many of you know CEDAR, based out of London, but with a global footprint. They noted, for example, this is a practical consideration, if mediator signature were to be taken as a form of endorsement, that is of concern to them. And this is despite all of the norms that mediation agreements protect the mediator in terms of them being called as a witness and so forth. But they also think that the mediator should not sign. They've actually stated this in their commentary that came out in February on the convention itself, that they did not think the mediator should sign the agreement. And they themselves have taken a stance saying that they support the attachment of an appendix that contains the proof, if you will. Also, they do suggest in the last line there that this would also apply if the mediation agreement was for multiple days. One of the things that Jayam said was that the arbitration clause in his model clause that he was talking about does not become initiated until the mediation fails. And there's some relevant reasons for that under the Singapore Convention, which we'll talk about shortly. But also a lot of mediations, increasingly, especially international and large, complex, multi-party ones, don't necessarily get resolved as domestic ones do in a single day. And so you'll have to consider the chronology of this thing. If you can just go to this next slide. One tool, again, I mentioned earlier ad hoc versus institutional. A lot of you who are practitioners are aware that increasingly arbitral bodies and institutions are willing to do what they call a la carte or ad hoc services, so that you can have certain services that can be delivered without actually having the entire arbitration administered by that particular institution. So for example, an appointing authority or otherwise. There's a whole list of these, and I'd encourage you to go to the various institutional websites, the Saudi Center, Singapore, Jamaica, and so on. I'm sure they all have a number of services. So one of the services that potentially could be looked into, it's not on offer as yet, would be an a la carte mediation service that includes a certification process of an otherwise ad hoc mediation, so that an institution could actually confirm the agreement itself and that the mediation took place without it being an administered one. And if you can just go to the next slide. So very quickly, grounds for refusal. The ones that stand out, obviously, is that it was subsequently modified. And that has some challenges, which I'll speak to in a moment on the next slide. Breach, a serious breach of standards, and I'll discuss that. Failure to disclose, and of course, and that these circumstances created justifiable doubts. And then lastly, public policy. Public policy is much the same as it is under the New York Convention. It's to do with the circumstances and culture and legal norms of that jurisdiction. And that's a whole separate thing. But the first three, I just want to touch upon briefly. So if we can go to, yeah, there we are. So many of you know Hal Abrams, and Hal Abrams in his intro to the Singapore Convention Handbook noted that Article 5 defenses, their implementation could be dispositive in determining the convention's success. Now, Gibson and Dunn noted in their analysis of the convention that these grounds are similar to those in the New York Convention, which seek to preserve procedural propriety and prevent abuse. And I think that all the mediators in this call and most of the parties who've experienced mediation themselves know that it's quite rare for mediation with an experienced mediator to devolve into something that's of concern in this way. But obviously, when you're trying to promote this internationally and go beyond the usual players and usual suspects, you have to consider these things. And Gibson and Dunn points out that the courts have generally construed the New York Convention grounds for challenging the arbitral award narrowly, and that we can expect that the courts will have a similar approach with their own review with respect to settlement agreements that are subject to scrutiny. I would agree with that, and I would invite the others to speak to that in a moment. But there's the next slide for a moment. Grounds for refusal, modification. Now, what if an essential element is reserved for future agreement of both parties? So for example, it's not uncommon for during the course of a mediation for some sort of information, especially more complex ones and technical disputes, where there is something that is as yet not known. You may have to have something audited, something reviewed, get an independent legal review of something, retain an expert engineer or somebody to provide or evaluate a business or to assess some sort of damage. So what happens if this, during the course of the mediation, you agree that there will be some other information provided? Now, this poses a problem in and of itself, but what if the mediation is based on negotiations with the mediator, but not concluded officially until after it concludes? Again, all the mediators in this call and a lot of the counsel and parties have had situations where the mediator brings the parties very close, but for whatever reason, perhaps they need to consult with another shareholder, another partner, what have you, who for some reason or other was not at the table. What happens then? They will often reach a settlement and not necessarily include the mediator in that subsequent discussion, or they will reach an agreement and not even tell the mediator that they've concluded the matter. Now, obviously, it would be nice for the mediator to know this, but what does that mean in practical terms? And so I think we have to, if you are a party or a lawyer or a mediator, you're going to have to remember to consider this, that in terms of achieving the endorsement of the mediator resulted could be difficult under these circumstances. Now, there are ways around it, and you could bring the mediator back, but the question is, do you actually have to re-engage the mediator? I suspect not, but this is something that, again, CEDAR noted in their analysis. If you go to the next slide, breach. Now this, of course, as Judith mentioned earlier, there are two steps. It has to have affected the decision, and it was relied upon by the party, and somehow that decision was compromised. And that second step obviously makes this a very substantial hurdle. But obviously, to date, there's no explanation or guidance on what a breach is by mediator and that it will be serious enough, nor is there any indication what standards will be applicable. Now, Linklaters notes in their commentary from April of this year that the lack of applicable standards could provide a basis for challenge. And this is the most important line. The process of challenging the enforcement of a settlement on the grounds of serious mediator misconduct or bias is likely to involve examination of the mediation process itself, displacing the fundamental confidentiality of that process. Now, they're painting a dark and stormy night picture, but one would hope that over time, I think that, as I said at the outset, there will be increasingly convergence as to what these things mean. There'll be jurisprudence, there'll be increasingly guidelines, there'll be increasingly more uniform adoption of codes and standards. IMI has been working on it. There was one in the United States years ago with the ABA and all the ADR providers and among others. So hopefully there will be increasingly convergence on this point, but you know, it is to be determined in the final analysis. Now, failure to disclose, again, because this part of the under F where it says, and such failure to disclose had a material impact or undue influence on a party without which failure that party would not have entered into the agreement. That's a pretty high bar. Failure to disclose, I think that there's so much experience of failure to disclose in so many different contexts that I don't think that most people will be, what would be the word, at a loss to determine what a failure to disclose is. I think obviously mediators and the parties have some responsibility in which they need to do that. And we can talk about that in a moment. And then lastly, Judith mentioned the model law. I think it's hugely important in terms of building confidence, especially among uninitiated jurisdictions or otherwise, that they have increasingly clear legislation and increasingly clear guidance on things. So I'm hopeful that just as other model laws and model rules and so forth have got real traction around the world, I would hope that the model law will indeed get considerable uptake in the intervening years so that people will have that much more confidence. In the end, historically, and this is why I know a lot of you are aware of this, one of the reasons people resisted an international convention was they felt that mediation itself does not require this, because settlements reached in mediation typically have an overwhelmingly high implementation and execution rate. I mean, it is very rare, at least in my experience, even on international disputes, for parties to simply not implement a contemporaneous agreement reached with all the right parties, with all the right authority and so forth. So I think a lot of this is moot, but because there was this lingering perception amongst a lot of users, and you can look into this with everything from the Queen Mary study to the work of the working group and others around the world, where a number of corporate entities and councils said that they felt this was an impediment to their using mediation, this ability to enforce it across borders. So I think that the convention goes a long way to addressing that. It'll take a couple of years to come into play. But as I said, I've never really seen mediations fall apart. But as it grows, as you get broader, wider, more diversity in terms of jurisdictions, parties, players, sectors, industries, and complexity and so on, it's inevitable that there will be issues. And particularly under the current health crisis globally and the economic crisis globally, I think that there's a lot of people that are going to be doing deals with an eye that it is better to resolve this now than to await what is an uncertain future for a lot of different businesses down the road.
And James, sorry to interrupt you, but we're just about out of time. So if you want to make a couple of words to wrap up, and then we'll see if we can get one question in from each person before we.
Last one is obviously the proselytizing. obviously awareness and education is invariably going to be important for people as stakeholders. We need to, all the people on this call need to do what they can to indoctrinate, educate, and elucidate all of this for people. And I'm hoping that we can make the case in a very rigorous way with the study of case laws, success stories, and so forth, moving forward.
Okay, thank you very much, James, for highlighting the obvious early stages which we're at with Singapore, and the fact that interpretation and jurisprudence is still to be developed in the coming years, and also the need for certainty in interpreting the wording. Thanks to James for again going through the contrast between the New York and Singapore conventions and proposing at the end his model clause for Charter Party agreements, and also to Judith for laying out basically the whole purpose and involvement of UNCITRAL. I am going to, we have barely a couple of minutes, so I'm going to ask one quick question of each person and see if we can rush through that. Firstly, to Judith, is your opinion that international mediation like arbitration, sorry, that was not the question. In keeping with UNCITRAL's objective of harmonizing international trade, what minimum collection of instruments would you recommend countries to adopt, and why? Briefly. Hello? No, she's not there.
I muted myself. Sorry, that was my own. It's not always techniques, it's also the human factor. Okay. So if you ask me like that, I would of course say all of our instruments. And the point I wanted to make when explaining how UNCITRAL is working is that it's UNCITRAL that is deciding on what topics are to be taken up. It's all the states that are there that are shaping the instruments. So it's extremely important to get the voice of Jamaica so that we are able to draft even better instruments. And we have developed instruments in a broad number of areas, starting from MSMEs, transport law, secure transaction, insolvency, and so on and so forth. Jamaica has ratified the New York Convention, has signed up to the Singapore Convention, and there are a certain number of model laws that they adopted, like the model law on international commercial arbitration, the model law on electronic signature, and on public procurement. So this was the choice Jamaica made. What I would really ask every state is to participate and to make sure that we get more input on what we should draft. And this is also why there are so many questions, as pointed out by James, because you have so many different states in a room, and you try to find an agreement. So of course you have texts that are on the one hand very flexible, they are fit to be used in all legal systems. On the other hand, it's important to not to forget where they come from, to understand them properly. And that's why it's important to participate.
Thank you.
Taking over the instruments and participate. That's the.
Thank you. James, briefly, your opinion on whether you feel that international mediation like arbitration should have some sort of reference to a kind of seat to rely on?
Yes, I think if you look at the history of the shipping industry, forum shopping, the terminology originated from shipping. People like to do forum shopping, and then jurisdictional issues, which country has a jurisdiction, or which laws has a jurisdiction, or which court has a jurisdiction. So these things have been plaguing the industry. And now if we want to have a mediation, we need to be certain. Not every country will recognize the settlement agreement straight away, like Singapore may register as a judgment of the court. It will be very nice, maybe like Jim McPherson has said, that maybe by 2022, there will be many countries like Singapore which can recognize a settlement agreement under the Singapore Mediation Convention. You go to the court, you register it, and it becomes a judgment order. And that will bring the confidence into the shipping industry. So a place is the key factor in bringing around the change, a game changer. So I would say, yes, we should have a place in mind, which should be inside the charter party, not to be decided after the dispute. It should be part of the contract.
Thank you. Thank you. James, quickly. Having referred to your presentation to the number of countries that have ratified the convention, why would you say that so many of the countries generally perceived to be at the forefront of dispute resolution expertise, being also economic powers, have to date not signed the Singapore Convention, i.e. Australia, Canada, the entire European Union, Japan, New Zealand, Pakistan, etc.? Quickly.
Thank you. Well, the jurisdictions you've mentioned are, in fact, among the most ADR friendly in the world. And that partly explains their delayed response, because they already have highly developed, and supportive judiciaries for their domestic and even international mediation sectors. But in the interest of competitiveness and inclusivity, I think alongside what it will be increasingly activist chambers of commerce, bar councils, judiciaries, they will be increasingly motivating these states to take these measures. And remember that as yet non-signatory states, they have compelling reasons to join, because obviously with the health crisis, they're going to be looking for ways to ensure better access and speed in terms of justice. They're going to be looking for more efficient mechanisms. They're also going to want to attract foreign direct investment. And I think that the Singapore Convention is going to increasingly be viewed as essential legal infrastructure for those wanting to have the right frameworks and the right structures in place to attract that. So I think it's going to be, I agree with Judith, the uptake is going to be considerable and it will be ramped up over the coming year.
So it's just a matter of time, basically, yeah?
Yes, I think that there's a couple that have more complicated adoptions. I mean, some countries, they're a little slow on this, but as I said, dire times call for emergency measures. So I think that people will even impress us with their speed.
Thank you. Thank you to all, again, Judith, James, and James, for a very interesting discussion. Obviously, there are a lot more questions than answers right now, and we could have gone on for longer. I apologize and thank all the other participants and panelists for their patience while we've held them up. Briefly, I understand that Nordia and the organizers need to make a statement, so I'll end this panel session now, and thanks again to everyone, yeah? Bye-bye.
Thank you. Bye-bye.
Nordia. Well, if Nordia is not there, then the next session is moderated by Carolyn Hay.
Thank you, Sean.
Hi, Carolyn. You're going to be bringing up innovation and going online. Nordia had indicated to me that she wanted to make a few words.
I saw the same message. Thanks. Okay, Nordia, I'll stop speaking so you can have your 30 seconds.
Thank you.
Bye.
I'd just like to say thanks to our sponsors.
You have a live instrument open, that's your feedback.
I don't have anything on. Caroline, go ahead.
All right, ladies and gentlemen, good afternoon. Welcome to our session, which, as far as we're concerned, having engaged with each other in preparation, it's going to be the most exciting of all the presentations. Sorry, Sean, but we just think we're far more dramatic as participants than I'm sure everybody has been to this point. So welcome to the session that deals with innovation and going online. And I have some very interesting speakers who combine a lot of experience in the area of just innovation, as well as the skills required to do effective mediation. And they're very aware of the issues that are emerging now with the health concerns that we all have, but also the cost, the historic cost of managing the service and making the platform broad and more accessible. So I'm very excited by what's going to come. So what I'm going to do is I'm going to introduce the three panelists to you now, and we're going to tell you how we've agreed to approach this. So I'll give you the introductions, which are really set out in full online. If you click on the link, you will already see the profiles for our speakers. And then each gentleman has agreed to present for about 8 to 10 minutes because we really value question and answers as part of our presentation. So we want to encourage you to start thinking about, as they develop their topics, what questions you have for us. And then for each speaker, I'm going to open with just a summary line to tell you what they're going to talk to you about. So we're going to jump right into it. And our first speaker is Philip Engel. I don't know if I have the pronunciation right, but we call him Wit. And he's an attorney and solicitor, an arbitrator and mediator with domestic and international experience in business law, contracts, intellectual property, protection, energy, regulatory compliance, mergers and acquisitions, dispute resolution, and human resources, and he has extensive peer responsibilities. So from 2001 to the present, he has been providing business consulting and dispute resolution services to business clients in domestic and international arenas in the fields of energy, construction, engineering, facilities management, real property, intellectual property, corporate law, including mergers and acquisitions. And his clients are all over the world, so you need to listen to him. Our second speaker is Jesse Francis. And Jesse is the Director of Consulting and Electronic Presentation of Evidence. Jesse can tell you about his experience when which is spanned 15 years, working at international law firms as a member of the in-house litigation and trial support departments. What's fascinating about his exposure is that he always is able to give real-time in-house support with the selection and preparation of multimedia options most appropriate for presenting evidence in an interesting, concise, efficient, and cost-effective way. Sometimes in our arbitration experience, particularly given when they're extensive and complex, handling many documents, thousands of pages across borders in different countries becomes difficult when you're in one location, but you can be in multiple countries and use the technology that allows you to get through easily your thousands of pages. So Jesse's going to talk to us a bit about those skills and why they're so particularly useful now. And our third speaker, Marlon Hilton, is an innovator himself. His firm is actually called Innovate. And he'll tell you about combining technology to understand culture of law with deep business technology expertise to provide innovative solutions for the legal profession. So those three gentlemen are far more competent and able to talk about this topic than me. I'm an old fogey who tends to go through paper. But we're going to start with Wit. And Wit's presentation, the summary line, he's going to focus today on the why of virtual ADR in the new world. Why are we doing it? Why are we focusing on it? And how it addresses and solves the knotty problems of costs and logistics, and why it will open markets for dispute resolution services globally. Wit, your turn.
Thank you very much, Carolyn. I have to admit that after hearing that presentation, I'm going to have to increase my hourly rate. Okay, so I'm going to try share screen. I have a very short little PowerPoint, but if you don't mind, I will I'll see if I can't put that up. Can you see that? Can you see it?
Not quite yet.
Okay, so the future is here. All right, so when we talk about virtual ADR, that means we're using, a remote platform where people aren't all necessarily in the same place or even close at the time that the hearing goes on. If you think about it, this has been going on for quite a while. In the arbitration world, for example, we've had, preparatory conferences or preliminary hearings by teleconference for years. And more recently, there's been an increase in computer-based, Zoom and others in terms of their platforms and making them available, and making the technology very ubiquitous. But if you think about it, the developments of the last few months have really spurred growth in virtual ADR, and in a way that addresses problems that are invoked by the events of the last few months. So I've listed here no crowds, and that's from a social distancing perspective or from a security perspective. No travel, no visas, no shortage of real estate, and more convenience. So the big takeaway from all of this is reduced cost. It's phenomenally expensive to conduct these, especially the larger international arbitrations, but it's also been prohibitively expensive for small and medium-sized businesses because of the heavy burden of flying people in groups to resolve disputes. No visas. All right, the thing, because no travel's needed, no visas need to be obtained. And in fact, there may be very good reasons why people don't want to get a visa and then don't want to travel, whether or not it will expose them to the jurisdiction of a place that they would really rather not be, for whatever reason they might have. No shortage of real estate. Okay, so shortage of real estate is using the virtual platforms. They have an infinite, almost seemingly infinite ability to set up rooms where people, breakout rooms, coffee rooms, whatever you'd like to call them, which is simply not available in a physical space. And they can be surgically applied and executed against. So I think this is a real benefit. More convenience. This is convenience for neutrals, for advocates and witnesses. The advocates, for example, can spread their paperwork out or their other evidence out in a secure setting such as their office and have it just instantly available at their fingertips for them to be able to prove their case. Witnesses are less inconvenienced because the time and location commitment to their participation is lessened. This is especially helpful for end user community witnesses who have businesses to run. And neutrals were able to focus on the task at hand. Although there's a continuous improvement and refreshment of technology and the management skills needed to most effectively apply this trade, that is virtual ADR. All right, so the new virtual ADR paradigm results in reduced costs, significantly reduced costs. Travel being, a major one of them. It's more efficient, and my colleague Jesse Francis will be talking to this. Geography. A place matters less, and this is a couple of points to be made here. Is that how shall I say it? One does not need to be physically located in a major dispute resolution center in order to be able to effectively engage and resolve disputes. Likewise, one as an advocate, you are now more accessible to the pool of available advocates who can handle these disputes, because obviously you don't need to be physically located in one of the traditional cities where disputes are being resolved. Secondly, dispute resolution can align where the business is conducted. So imagine this. We have the ability to conduct business between players in, let's say, in North America and let's say the Caribbean. And we are able to, we put our deal together virtually in many cases now. Why would we instantly think that, or why would the default mechanism for the dispute, for resolution of any dispute that might arise out of our relationship, why would it automatically be in some faraway city on another continent? Cyberspace is ubiquitous. It shortens the geography. We can still, in other words, bottom line is we can align our business dispute with where the business is being conducted. More access, lower barriers, cost factors. International commercial arbitration as a result of this paradigm shift becomes much more accessible to small and medium-sized businesses who've been confronted with the biggest obstacle has been cost. This makes it much more accessible, much more easy to tap into in terms of resolution of their business. Anyway, bottom line is I envision a bright future for virtual ADR. That's my presentation.
Thank you. And you've certainly kept to our agreed approach, which is to make sure that we don't clog the time with lots of speech and we make a lot of space for questions. I really appreciate that, because one of the things we discussed, just for the benefit of our listeners, is, you know, the fact that to make the services really meaningful as an alternate dispute resolution mechanism, we need to really widen the space. We need to widen the access, and the way the immediate impact of going virtual, it shows itself in cost. So we really appreciate the presentation, inviting you to start with the questions. We'll acknowledge them. I'm going to go straight ahead to Jesse, who's opening one-line punchline. Is his heading, the electronic presentation of evidence and the cutting edge of how. So we started off with the why, and now we're looking at the how, efficiency and effectiveness during the arbitration hearing. And one of the things you might think about is, if you increase your efficiency in going through your material, does that shorten the time that you spend doing your presentation? And can you actually get more briefs because you can actually do more work? Jesse?
Great, thank you very much, Carolyn. Can everyone hear me? Yes. Okay, great. And just one quick note, for those who have your screens in gallery view, if you go up to the top right of your screen and click on gallery view, you'll actually see a speaker view button, and that'll give you a full screen shot of what I'm about to show. So let me go ahead and start my presentation. Can everyone see my my desktop?
Yes.
Okay, great. Let me go ahead and start. Again, thank you for having me. First thing we're going to talk about is, you know, the before. So before, what did we do? We had boxes of exhibits, and then we put those into binders and we took them to an arbitration hearing. Now what do? We have everything loaded onto a database on a laptop, and then we use Zoom like we're using now, monitors and projectors in an arbitration room. So here's a remote hearing room. You can see a large monitor in front of you, probably 29 to 34 inches widescreen. You also see a big screen, projector screen at the top left. I'll come back to all of this. And you see some laptops that are displaying documents. You also see on this screen here, obviously someone on the bottom right, they are testifying via Zoom. And on the left, they're actually showing the document that they're talking about. Here's the remote witness testifying from his office. And here's a little bit more detailed description of what I just mentioned. So let's take a look at a couple of past arbitration hearings that I've worked at and what technology looks like. So this was one, actually the largest one I ever did was down in Bogota, Colombia. There were 40 attorneys, and I did say 40 attorneys, 4 parties, where at the top here, you're looking at the witness testifying and looking at a monitor. That's this section right here. On the top of the stage, we had the 3 arbitrators sitting here. We had the rest of the arbitration panel over here. We had the secretary, and we also had court reporters that were reporting on the case. There's another arbitration down in Panama City. Top left, you see the arbitrators table. To the top left here, the witness was testifying here. This was an English and Spanish arbitration, so there was actually a translation booth. If you look at the top picture here, and also on the right, you see it there. And then the parties, which were probably about, I think, 8 to 10 attorneys that were actually present for this arbitration. Finally, for those of you who've been to BVI, this is one of the BVI arbitration rooms. Here, they did have a projector screen, a large one, I think 100 inches, but also we placed monitors in front of the participants so they could see the actual documents. So now let's talk a little bit about the efficiency of presenting. I talked about taking boxes and binders in. Well, now you have everything loaded into a database. This database has all the documents there. And then on the right, you'll see that you can actually go to certain pages, lines, sections, and call out and highlight that. And at the end of this, I'll actually do a demonstration for you. The presentation software also allows you, for those in the US jurisdiction, if you have a deposition, then you can play deposition designations and also show sections of the document. So what I'm going to talk to you next about is the value of static demonstratives, dynamic demonstratives, and interactive demonstratives as they relate to arbitration. And also, some folks don't think about, but the pre-hearing inclusion of static and dynamic demonstratives. Basically, if you submit an Adobe file, you can hyperlink in static demonstratives and dynamic demonstratives, which are either other PDFs or PowerPoint presentations. So here we have, a railway case involving coal. And this black line in the middle here shows that you have 2 trains, one going from left to right, and the other one going from right to left. Well, they can go or travel on the same rail line until they reach a certain section. Then one of the trains basically has to go to the top and let the other train pass. Well, what happens if you have 2 lines? Let's go ahead and do that dynamically. And then we show, well, you actually triple the capacity, because before you can only have 2 trains going in one direction. Now you have 3 trains going in one, 3 going in another. So now we're going to talk a little bit about damages and also using another dynamic presentation. So it talks about from 2000 to 2005 that the volumes transported were 10 million to 20 million. And actual for 2005 to 2012, it basically flatlined. Well, if we had that second line in place, then one party is claiming that they had at least 40 million volumes that they were able to transport. So basically doubling what they had in the past. So 2005 to 2012 would no longer be a flat line, but actually be a lot higher. So let's talk a little bit about, some of us favorite topic, alcohol. So this was a case involving alcohol going from Scotland down to Dominican Republic. So we were basically teaching a panel, here's how everything works. So we start off, the ship comes in, travels all the way to Dominican Republic, it gets to shore. Then once it gets to shore, it's transported by a truck to the company there. And then it goes to a third, and then the third party, basically, they sell it to key accounts, including PriceWaterhouse, which many folks on here, I'm sure, will recognize. So now let's go to another set of demonstratives where we're talking about a timeline for execution. Obviously, this is in Spanish, but I think that most folks will understand what I'm saying. So we're looking at a timeline from beginning to end. We're talking about, well, there were agreed project reports that were signed. Then we're going to talk a little bit about the actual construction of the roof. And by the way, this is the roof at the new Panama Extension Airport down in Panama City, Panama. So now we're going to talk about, times and delays. So if you look at the bottom left, you'll see that that's November 21st, 2014. We have a picture, we have an engineering drawing. Then we go on to November 27th, 2014. Let's remember that date, November 27th. And we again have a picture and showing that we're with some inscriptions right down here, 2A, basically saying that parts of the beams, were not installed. So now we're going to 2015. Well, we're showing another picture that basically says that installation is not finished. Again, we just spoke about 2014. Now we're in 2015. And to the right, another picture with another time, then another one. So by the end of everything, we came up, we said, look, there were 450 days of delays that caused our client to back out of this project because they were not able to start it on time. Therefore, they will not be able to complete it on time. The last thing I'm going to show you now is the general layout of another construction project. So this shows obviously a diagram. So now we're just going to show you some more static exhibits, which are obviously photos. We go through here, we go through a timeline. This is a static timeline. It just shows different points on here. Later on, I'll actually show you a more dynamic timeline. So now we're going to actually go into demonstrative, because what we're going to show is that what they used to pour in the ground here, was it sand, was it clay? That was the issue in the case. So that happened there. They obviously created a foundation. So now we have a gas station that's built and a housing community. There's groundwater flow, leaking tanks, contamination, well contamination, artesian well contamination, lawsuit. So then we have some experts coming in and talking about, well, they should have used sand versus clay. So now we're talking about the pore water pressure, applied stress. And again, this is an expert testifying to an actual arbitration panel about what should or should not have been used. Now we're going to look a little bit more at a dynamic timeline. So here on the bottom, you see that as I click, it scrolls, and then eventually you'll see that the documents actually move to the top, and then another timeline comes in, and all these documents are filled in that similar matter. So now, let me go to, I'm just making sure that you guys can still see my screen.
Yes.
Great, thank you. So now this is the presentation software that I was talking about. So let's quickly go to page 1. For those of you who work in construction, obviously you will know about design, plan, design, build. So now let's go to page 8 of that document, and we want to zoom in on a certain section. So here's where I can zoom in. I can actually call up or highlight a section, I should say, so that now we can talk about instructions to the engineer. But now we have the case where they want to talk about 2 documents side by side. So now I'm going to put up that page there.
Which is something that I look at and I don't see it either. Okay, this is not showing up.
Jesse, we're still on the screen that says electronic presentation of evidence.
Oh, okay, I'm sorry.
I'm supposed to, my mic supposed to come.
Now, do you see that other screen that I was? Let me.
So now we're in the gallery view.
Okay, there you go. Do you see the screen now? Yes? Okay, great. I'm sorry. So let me go back here. So now we're in the presentation screen. I will go to a certain page. Can you guys see this page here? Yes? Okay, great. So now I'm going to zoom in on this section here, and then I'm going to call out this part here. So what you can do, having thousands of pages in a database, you can actually, with a few, access certain documents literally. So now you don't have to ship binders from to BVI to Panama, et cetera, et cetera. Everyone is able to see everything on this as I'm showing here. Obviously, technology permitting. Okay, so now I'm going to show you, can you guys see this screen here with an apartment building? Oh, no. Let's go back here.
Yes.
You can see it? Great. Okay. So this is an example of an interactive exhibit. So basically, let's take a look at what we have in here. So now the first thing, let's just go straight to damages. So now we're going to show, well, guess what? This is what has happened as a result of poor construction. And again, this is interactive, so I can just click on everything here. Then now we're going to talk about different layers of flooring. We're going to talk about some water going that way, some water going that way. Then we already showed that. And then, talk about, again, layers of flooring. And basically that's it. So we're going to, now the idea is that you can use technology, number one, to be more efficient with the document presentation part, but also when it comes to actually showing demonstrative as far as what took place within that time period that causes the damages, whether it's either claimant or respondent, that you're able to show the arbitration panel and hopefully get a better result for your clients. And that's it. Thank you very much.
Thank you, Jesse. Fascinating. Really, it's easy to talk about something and always more challenging to actually see it. It's actually more interesting, sorry, to actually see it, because you get an idea of how easy, if you have an able manager of the technology, how easily you can tell the story, because it always in presentation of a case, you have to tell an understandable story that the tribunal can determine where does the remedy lie, what happened, can I see and understand what the issue is, how can I assess damages, how can I assess costs. When I see it in this way and you get through a sort of seamless approach of the material, it certainly makes it a lot easier to handle, and it makes the whole process more attractive and less overwhelming. So we have a third speaker who should be Marlon, but I'm gathering that there's some connection issues in relation to getting him on. So in the meantime, I will go to one question that's been posed so far, Jesse. And the question was, just commending you on the presentation, how do you access this software? How do we actually get it?
Right, so there are a number of different companies that actually sell this software, and you basically have to not only buy the software, but it's also the hardware. For example, I'm using a Dell laptop that has over 3 gigabytes of dedicated video memory. The whole thing is this, especially with presentations, you want to have dedicated video memory because most of the time it's all interlaced with the regular processor on the computer. But think of it, if you know anything about cars, as having a supercharger that's specifically attached to your engine to run that. So once you get the software, then you have to get the hardware also. And that's where consultants come into place, because most folks are not able to get the software, get the hardware, get the training and understanding as far as what's happening. For example, there's some folks who do what I do now that refuse to use Zoom because they're like, look, it might be or might not be insecure. We don't know about the latency as far as the ability for it to transmit video. Obviously, I transmitted video just fine. We're transmitting video now, but if you have someone speaking and someone showing a presentation of documents and even the interactive exhibit that I showed, it takes up a lot of memory. So it needs to be a wide bandwidth and also a powerful computer behind it that's running. But for that person who wants to know, I can actually email you a few resources as far as being able to get that software, being able to get trained on it, and then of course that software only allows you the first part that I showed, which was actually putting the documents in and pulling them up, quote unquote, on the fly. The other part, which are demonstratives, those were actually created by folks in my team, where basically a client said that we need this, this, and this, and we went through and created something, through our time going back and forth, and then finally ended up on a presentation. And like I said, the static and dynamic exhibits that were basically the PowerPoint and like basically the screenshots, those can be hyperlinked into an actual Adobe brief. For the one I showed with the apartment building, obviously you don't really want to attach that. Number one, because if they don't click on certain buttons, they will not see the facts that you're trying to show, versus a dynamic where basically it's step by step by step by step. You have to keep on clicking until you get to the end and you will see everything that's being presented or argued.
Okay. There are two things. There's actually a follow-on question from that, and I'm still waiting to just to get the feedback from Marlon, and really looking forward to his contribution, because he's looking at the actual layout, the rollout of this in different countries, and how people, different countries, different jurisdictions have been dealing with the online approaches primarily to arbitration and to mediation, since we were talking about Singapore Convention before. The follow-on question to that was whether it could be delivered as a service instead. So I'd like you to touch on that, but then I wanted to go ask Whit, if there were any, based on something Jesse said, are there any data security issues? We spoke a lot about the convenience of cost and being able to make it more accessible, but should we also be concerned about whether there are particular data security issues, given the fact that if this is the future, how do we protect the data? Traditionally, we just lock the boxes and lock the buildings that the boxes of paper are in. But if we're talking about sharing information across countries and different jurisdictions and time zones, should we have data and protection issues arising out of that? So Jesse, and then Whit.
Well, if you give me a moment of leave before I answer the security question, there is something that Jesse talked about that I thought was very germane, and that is these platforms such as Zoom and WebEx and others that a practitioner, both an advocate and a neutral, probably ought to prepare themselves to be fluent on more than one program or one program only. They need to develop an understanding of how these systems work. So because it may be Zoom on this arbitration, but it may be WebEx, it may be Microsoft Teams on another program. So don't think that if you just are tied into one program that you're good to go, because it's probably not going to be enough. All right, now as to the security issue, absolutely. This has been a concern for a while. We've heard about Zoom bombing in the past. However, I do think, and what's happening are the couple of things. First of all, the platforms themselves are developing protocols that reduce the opportunity to barge in or otherwise hack what is transpiring. However, there can be leakage. For example, what is to stop a participant or a witness from recording something on their phone as the hearing is being conducted over the internet? But these gaps, technology is closing, many of these gaps. Further, the arbitral institutions are developing procedures and protocols, and this is the topic that one of the topics that Marlon was going to address, that reduce the ability that improve the security of the process and thereby the integrity of the process. And these are being developed. The AAA ICDR has come out with a number of them. ICC. There's also been a joint. I guess it's a publication, but it's a joint effort of all the major arbitral institutions, essentially the ones that you hear about mostly, have come together, and they've come out with procedures and protocols that address the security issue as well. So it's an emerging, evolving area, and obviously in the fullness of time, a lot of these factors will be addressed in an increasingly effective manner.
That's appreciated. Jesse, did you want to add something?
Sure, yes. So you asked a question about service. So the answer is yes, that actually, my company and companies like mine offer these services to clients small and large all over the world. And like I showed you, about the project in Panama, Colombia, BVI, etc. So what we do, in the past at least, for example, for Panama, I had a Miami firm contact me, said, look, we have an arbitration down in Panama. I want you to go down there, set everything up. So all those pictures that I showed you with the monitors and all that kind of stuff, that was physically set up by me and a third party, meaning I had to tell them this is where we wanted everything, et cetera, et cetera. And also it then came the presentation part, which is also a service, and then the graphics part, which is also in service. What I'm noticing now that some arbitration bodies are offering the presentation service as the document presentation as an option for both parties to share in that cost. Most times one party might hire one company, another party might hire another company, but now arbitration boards are saying, look, you know what, if we can get both parties to agree, especially with the presentation part, then we will have one company that comes in and does all the presentations for both parties, or each individual party can hire someone to do that. Then of course that's separate and apart from the actual graphics part, because the presentation part, I call it similar to a court reporter or court stenographer. Basically, they come in and they're just taking down notes as far as what's happening in real time, and they don't have a value with the outcome, whether it's for claimant, for respondent, etc. And that's when, if we get brought in by the arbitration body, they say, look, we're just working with the arbitration body presenting evidence. As far as the graphics end, that's something totally separate, that basically then you're working with individual counsel or a team of law firms saying, look, here's what we want to show the arbitrator, and these are the points that we want to show that basically they were supposed to use sand, they used clay, and because of that, the foundation was bad. Then we had leaks underground, et cetera, that led to all the damages, and now we have to spend $30 million or $100 million to fix that problem, and that's why we're here today.
Sorry, getting used to the technology. Let me just say two things. It seems as if Marlon may not be able to join us in this presentation. And this is one of the pitfalls in technology, isn't it? That sometimes you may have all kinds of issues that actually tank the presentation or affect the hearing. But this just seems like one of those things that you just have to learn to live with, because I don't think we can dial back into paper. We have to press forward into technology space. So there's another question, and I'll open this out to any of the presenters. And it's an interesting one. How to keep arbitrators' attention when you have a long virtual hearing? I mean, it's actually one of those issues that, you know, when we're preparing and training arbitrators, we look at, you know, you can't just nod off and fall asleep when the parties are before you. And even that's possible when the physical bodies are in the room. So how do you keep focus and attention on the arbitrators in the handling of the paper when it's all virtual?
Yeah. And the interesting thing is this, I'll say this. We actually had an arbitration here in Miami, and the arbitrator was in his 80s, and he literally fell asleep during the arbitration because we were actually watching video depositions. And of course, you know, for the folks, again, that work in the US, yes, you can show video depositions, you know, of the opponents on the screen, but it's the most boring thing out there. Reading it is also boring, but at the same time, you have to basically mix up, you know, have a mix of presentations as far as some active, some interactive, you know, some just documents, but you just can't go through and for 5 hours straight show document after document after document after document. You have to go from a document presentation to some kind of, you know, dynamic or interactive presentation. And then of course, especially in an arbitration where the arbitrators, they like to ask questions, make sure that you're focusing on what they're asking, because after a while, you know, just like normal people, they get bored. And if they get bored, that's it. And especially for someone in their 80s, it was 2 o'clock in the afternoon after lunch, and he literally fell asleep. I mean, and both parties say, let's take a coffee break. He came back and he apologized, but at the same time, it was like, whoa, you know, that was just not, you know, obviously unheard of, but it happens. And actually, I take it back because it actually happened in Colombia also. And that was with literally a gallery of 40 attorneys sitting there, and up on the stage, one of the arbitrators, you know, he basically was dozing off, actually snoring. I apologize to say that, but he was actually snoring. And one of the other arbitrators had to tap him, and then he was like, yeah, and again, that gentleman was a little bit, you know, senior, you know, 80 years plus. So yeah, so I think just mixing up the actual presentation between documents, demonstratives, etc., definitely helps to keep, you know, someone engaged in the process and understanding your audience too, making sure that you know that they understand what you're telling them. And if they have questions, especially in arbitration where it looks like they have questions, ask them, do you have any follow-up questions? Do we need to explain anything more, especially from an expert perspective, because then experts are talking about such high technical terms, no one might understand it. And then you have to literally use a demonstrator to bring it down to say, look, here's the pore pressure in clay. Here's the pore pressure in sand. And then you can also go into the numbers, but at the same time, just showing that they kind of understand versus, you know,
what is clear from that is that the skill of the advocate will always be necessary. I don't know if Whit has a thought about it, but there's a question here. How early does this system need to be introduced to be effective? And I suppose the question might be focusing at in the process of matter by matter in any particular arbitration. Do you introduce this at the stage of the hearing? Do you introduce this at the preliminary hearing, procedural hearing? How early in the process do you introduce that? And while, you know, Whit or any of you treat with that, I think Dr. Malcolm wants to make a contribution on this point as well.
But thanks, Caroline. And the question, I suppose, is how well the trial media and these sorts of opportunities help us. And having used the services of Jesse and trial media in a matter that I was involved in as arbitrary, as counsel, I can say that what it really does in a very easy way is allow you to bring information together in terms of how you put your arguments together and in terms of how you project it as well. And I certainly think it is an efficiency measure in and out of trial proceedings, in and out of an emergency process that more of us could make use of. And if it is properly used, it could easily have, if not shorten your process even more in terms of what you have to do, particularly when you have a lot of information to deal with. And that is something as we go forward, again, as you were mentioning, even if it is that we get back to being able to rely a lot on paper, there are elements of this innovation that I think we would do very well to get into. And one of the things we speak about in arbitration on ADR is that we very often sell it for its capacity for speed, even if it does not always deliver on speed. And the way we're going to be able to manage and benefit from the capacity for speed benefits is where we're able to use these sorts of technology. Because otherwise we're going to be left going through reams and reams of paper, where I can say, having seen it in practice and having been involved in the process, you can, with an easy click, be able to cross-reference and do all sorts of things on the screen in ways which you would never be able to do with simply taking processes by paper.
Really appreciate that intervention. I think Whit was going to say something. Did I read that right, Whit?
Yeah, sure. As to your question about the sleeping arbitrator, I think Jesse shared the real life experience of a real arbitration in which the one that was sleeping would be sort of nudged awake by one of those that that are still lucid. I think the same procedurally, if you think about it, the same thing would apply in the virtual setting, and I think it's incumbent upon the chair of the tribunal, or if the chair is the one that has fallen asleep, one of the party arbitrators to suggest that we take a brief recess until the sleeper has been revived, and we can proceed with the presentation of evidence. I don't see a huge difference, frankly.
It actually is quite the same, and as much as the question inspires chuckles and giggles, it's a real issue, because if your tribunal falls asleep, some of your critical issues that have to do with understanding the nuts and bolts of your case go into their dreams as well. We have about 6 minutes by my count.
One question, one response, Carolyn. Someone asked about how early in the arbitration can this take place if it's at the hearing. Actually, in the past 6 months, folks submitting briefs, again, arbitration briefs, especially now in the form of PDF files, once you submit them electronically, you can link in images as JPEGs, etc., and also linking other PowerPoint presentations, with that brief. So now, in the past, it would be, oh no, well, once we actually get into the arbitration hearing, let's go ahead and create everything. But what folks are doing, especially for expert witnesses or some actual, fact witnesses, let's put in. So the person says, well, here's a picture of this here. Well, now let's link that to a PowerPoint where it actually shows a video, zooming in on something, et cetera, et cetera. So it can be used almost from the beginning stage. Once you file that initial pleading, you can definitely do that.
Okay. I see an additional question, and I think in the time we have left, I can put it to the panel. And I'm just going to read it as it is. Hi guys, in practice of arbitration, usually the documents are shared by email ahead and evidence known to parties. I then guess there's no need to share screen in sensitive arbitration during video screening, since each party has the evidence before the audience date. The discussion of evidence can be done offline during the audience. So my question is, aren't these security reasons for using Zoom and other video conference softwares exaggerated?
Which you want to go, or do you want me to go?
Go ahead, Jesse.
Yeah, well, the first thing is this though, and I understand what someone's saying that, okay, you get a bundle of 100 documents that maybe might be 1,000 pages in total. Well, the whole thing is this. If you tell someone, go to this page and go to this section, once you're able to show that on the screen, everyone is able to focus on that versus everyone trying to look at something at a different point in time. So, you know, that's one of the reasons for doing it. And you're right, though, as far as using technology, your security is going to be as strong as the technology that you're using as far as what security they have enabled. One of the problems is that if someone intercepts your email and then they're able to go ahead and log in, and then all of a sudden they're logging in as Jesse, and then they're playing music, you know, swearing, et cetera, there's really nothing that the platform can do about that.
Yeah, I don't know if we have a contribution.
No, Jesse, address that one dispositively.
Okay. Well, I think that the session, although we have suffered from missing our colleague's presentation, which from our pre-meetings was promising to be just as exciting, I think that we've had a good talk through of what's really facing us. The present is here. The future is now. So I think that what one of my takeaways from this is not just the potential for the widening of accessibility of this method of dealing with disputes and the reduced cost and the easier delivery of material in complex cases, but also the role of the advocate, the role of the presenter is preserved. Because if you can have all the technology you want, and Jesse can actually be on your team, but if your advocate can't deliver the story, then the technology won't replace that. So the human element seems to always be present. And it's really fascinating to see how it is we improve our knowledge. And in several different countries, the technology, facility with the use of technology is now becoming an ethical standard in practice. So it just becoming aware of what's out there and being able to use it and being able to engage it to bring down cost and increase efficiency as a general international standard is actually making its way into our separate practices in terms of just practice management and practice standards in different countries. So I think the discussion has been fascinating. I will close with one observation by one of our attendees. Unfortunately, this technology appears to be of great advantage to highly technical and fiscally strong participants. However, if there are fiscal or technical handicaps, I fear parties may be disadvantaged for lack of dynamic presentations of their case issues. How to ensure fairness and equity, especially across the Caribbean region. I don't know if Nordia will afford us the time. By my clock, there's 1 minute to see if anybody can make a contribution to that.
I will say this. I've worked on many budgets, high and low, and there's always a way to get an effective presentation done. For example, like Whit said, now that I don't need to physically travel to Barbados or Trinidad or somewhere else to actually do a presentation for a 2-week arbitration, that takes away a lot of the cost that's involved. So then you can focus on actually preparing the electronic part of it. And then of course, still using the available technology, WebEx, Zoom, etc., for me to actually be there and show things. Of course, I've also taught some of my clients what to do as far as, look, here's what you do, this, this, and this. And then if you have a problem, give me a call, we'll try to sort it out. But like I said, I've literally worked on small, medium, large budgets. It just depends on what your case is, and how much assistance you need with technology. And the reality is it can get done, at least in my opinion.
Just to add to what Jesse says, I'm not a model of high-tech knowledge. So, but I've done an arbitration, international arbitration, using virtual technology, and it didn't stretch my brain cells too far out of whack. That said, if I needed anything more than what I had as far as know-how at that time, I believe I'd hire Jesse in a minute.
And with that, let me thank you all. Let me thank the panelists for some really exciting presentations. I promised you, I mean, even if you don't agree with me, you know, we are the most exciting panel. I'm sorry. I mean, Chris, I know you have some really good people coming. You know, I'm looking forward to listening to Carlos and Alexandra and Patterson, but you know, you have a high bar. It's just a high standard to meet. Ladies and gentlemen, thanks for entertaining us. I'm really sorry that I missed the earlier presentations. Court had me, but looking forward to what's coming next. Dr. Chris, over to you. I don't know if it is that Chris is up and about doing most other things and he doesn't realize that the time is calling for him. Send a message over to Dr. Malcolm and see if he's aware that it's his turn now. But I see that his panelists are in place. All right, should I go ahead? I don't know if any of the administrators are present. I see Karen around. Should I go ahead and dip my toe in here so that the presenters can start? You're gonna have to forgive me if I'm unable to do the introductions, but I'm just being a good citizen here. I think the session that is coming up now is according to the should commercial parties purchase in the court. And I think in the meantime, whilst Chris gets it back to screen, unless if the panelists wish, I can go ahead and sit in until your moderator comes. Would you like me to do that?
Why not? Yep.
So the question is whether Carlos, Alex, and Patterson would like me to start you off with your session pending Chris's arrival.
I do not have a.
We're ready. Yes? We're ready. Consensus? Ready to go. All right. So, ladies and gentlemen, here I am floating in the space of not having met these panelists before, but I'm absolutely satisfied that everybody here is entirely prepared and able to deliver the discussion on whether should commercial parties jettison the court. Just from the heading, my feeling is that we're going to be looking at the increasing aging of the slow court process when commercial matters tend to be active and vibrant, expensive. Our courts becoming outdated deal with the emerging issues in commercial matters? And should we really be focusing more on ADR, mediation, using, of course, the technology to get better results, better outcomes for commercial clients? I hope I'm really not off. And I don't know what order you plan to do this, but I see on your on the program that Carlos is probably first, I see Carlos as chair of the Global Arbitration Practice Group, practices in Miami with a group called Shook, Hardy, and Bacon. Carlos?
Yes, good afternoon all. And good afternoon, fellow panelists. We missed Malcolm, but you're doing a fine job. So I think we'll be able to get through without Mr. Malcolm just fine, right? So when I saw this panel and the title of it, the first thing that kind of came to my mind was, what is the proper role of the national courts? And I think, as some of you may know, I have a common law, background. I have a common law perspective, and we've kind of decided to maybe break down some of the panel discussions with respect to the role of national courts between some of my views as a common law lawyer and some of the views of my co-panelists that have perhaps a more civil law perspective. And that's kind of conceptually how we've arranged it. So with that preamble, let me kind of begin by trying to divide, and I know I have 10 minutes and I promise to do my very best not to exceed my 10 minutes. So I've tried to divide this, or at least my part of the presentation, into 3 buckets, right? One is what is or should be the role of the national courts during the pendency of the arbitration, and a lot has been written about that. Of course, we all know about the interim measures, and in the US, more and more of us are becoming familiar with the process of international discovery during the pendency of arbitration. The second category of the role of national courts, at least the way I kind of conceptually break it down in my mind, is what is their role after the arbitration award has been rendered. And although many of us would like to jettison entirely, the courts, we know that we can't do that, right? We can't totally jettison the courts, even if we wanted to, because we have to confirm the awards, and the losing party may want to vacate the awards under the New York Convention in International Arbitration Matters, and surely the Federal Arbitration Act in the US under more domestic matters. So we know that we can't entirely rid ourselves, even if we wanted to, of the judiciary, and especially that is so in the role of the courts after the arbitration award has been rendered. But I wanted to take the time that is allotted to me to kind of talk a bit about what has been happening in the US with respect to the role of the national courts before or prior to the convention. There's Christopher.
We're on the chat.
There is Christopher. We're getting along just fine without you, Christopher. So
I thought as much, Carlos.
we'll just carry on. We'll just carry on, right?
Very well.
So I wanted to focus my remaining time on this preliminary conversation about the role of the courts before, right? Before the arbitration process begins, and I kind of think of it as gatekeeper issues. And I wanted to talk about that. And again, before I delve into that, if I have time, or if we have time, I have some other thoughts about the role of the courts after the award has been rendered, when the hearing has been done entirely virtually or remotely, but that's if we have time. So going back to the role of the courts before the arbitration process commences, I wanted to talk about that because there are 2 very, very recent US Supreme Court decisions, and one that is going to come about at the end, I think, of this year that focus on that. What is the role of the courts before the arbitration begins? And as you'll see from the presentations that we have today, at least in the US, and as a result of these Supreme Court cases, the role of the arbitration tribunal has been greatly expanded. And I think that we are seeing here in the US more and more and more of that, which I think is a good thing. So beginning with the case of General Electric versus Otocompo, and I'm sure I've butchered that name, but we refer to it local here as the General Electric case. That was a case that addressed the role of third parties or non-signatories to an arbitration agreement. And as we all know, or certainly those of us who have a common law tradition, the third parties have historically been bound to arbitration contracts that are domestic in nature under the Federal Arbitration Act, when concepts like estoppel or agency or veil piercing is brought into the conversation, so that the courts find that these third parties that did not sign the agreement are in effect in privity with the signers of the agreement. That's typical, that's expected, that's been the law in the US for a long time, but controversy over the years developed with respect to whether that concept or that legal theory, and we'll call it equitable estoppel for common law lawyers, whether that applies in the International Arbitration Tribunal. A lot was written, a lot was said, a lot of disagreements were had, and eventually, the U.S. Supreme Court, I believe it was just the beginning of this year, ruled in the General Electric case that the concept of equitable estoppel does in fact apply also to international arbitration agreements. So that has greatly expanded the potential participants in international arbitration in this bucket or this role of prior gatekeeper issues before the arbitration agreement begins. That was a seminal case here in the US, and now we know, and it's settled law, that there are conditions similar to those that happen in domestic cases where third parties in international contracts that are governed by the New York Convention can also avail themselves to the doctrine of equitable estoppel and other estoppel-like concepts to avail themselves of arbitration agreements. The other case is an interesting case that's been up and down the courts for several years, and we refer to it here locally as the Henry Schein case, S-C-H-E-I-N. And I have citations to all this, so you all can contact me later, offline, and we can talk more about that. I can send you the materials, but in that case, the issue that the U.S. Supreme Court first addressed in January of 2019 was this concept here of wholly groundless defenses or wholly groundless scenarios. And this is a case where the parties were dental distributors, and the issue there regarded a arbitration clause, and I'll read it briefly and I'll kind of lay out the scenario, and I have a few more minutes. So it's a typical delegation clause, and it says essentially that any dispute arising under this agreement shall be resolved by binding arbitration in accordance with the American Arbitration Association. But then it has a carve out. It has an exception to that, and it says, except for action seeking injunctive relief or disputes relating to trademark, trade secrets, and other intellectual property issues. So in the case at issue that the court is now going to take up, there was a antitrust lawsuit filed by these dental distributors, and the plaintiff sought in the case injunctive relief, but only in passing. So technically, theoretically, that was accepted from arbitration, given the language of the clause. And so we all know that the courts, at least in the US, typically, historically, have been the gatekeeper of what is arbitrable and what is not, except when you have a delegation clause like this one, where the parties have delegated the issue of arbitrability to the arbitration panel under the any disputes language of the clause. So following that rationale, the magistrate judge decided, well, the clause says what it says. The arbitrators decide because the issue has been delegated to the arbitration panel. Well, the district court, upon review of the magistrate's order, and then ultimately the Fifth Circuit on appeal, disagreed and said no. It's the courts that have to decide, not the arbitrators, because the delegation clause was not clear and unmistakable. and it was not clear and unmistakable, said these courts, because it was not clear that the parties entirely agreed to delegate the decisions to the arbitration panel because of the carve-out language applying to injunctions and other remedies. So that issue then went up to the U.S. Supreme Court, and the U.S. Supreme Court very recently held that no, that there is nothing in the Federal Arbitration Act that triggers the wholly groundless argument. And so the U.S. Supreme Court strictly construed the Federal Arbitration Act and said, no, the act does not include any defenses that could be read as wholly groundless defenses. So we reverse, and it is in fact the arbitration panel or tribunal that has to decide. Interestingly, and again, I just have a few minutes, the arbitration panel the U.S. Supreme Court did not decide the issue of whether or not the arbitration clause or the delegation clause triggered the arbitration issues in the case. And that's what is now going to be decided by the U.S. Supreme Court very recently, given the fact that they accepted cert. So we expect that this this issue, whether it's covered by the scope or the arbitration clause, is going to be decided later on this year. So the point that I'm making at the end of the day is that we think here in the U.S., given these two lines of cases, that the role of the arbitration tribunals before the arbitration begins as a gatekeeper issue is expanding tremendously. And so we look forward to that trend continuing. And if I have time during our next hour or so, I'll talk about some of the issues with respect to due process on virtual arbitration and remote arbitration hearings after the panel enters an order, and anticipating the arguments that may be made by the losing side that the award should not be vacated or should be not confirmed, given the fact that it was a virtual or remote hearing. So I hope to have time to talk about that. There's a case that came up pre-pandemic, very recently, that to my knowledge is the only one that's out there. And if we have time, we'll talk about that also during this hour. I think, Alexandra, you're next.
Thank you, Carlos. Yes, good afternoon, everyone, and greetings from Geneva, Switzerland. I hope you can hear me well. I first want to thank Dr. Christopher Malcolm and Jayak for having invited me to take part in this online seminar. I'm really delighted. It's a real pleasure, and in particular because Jamaica holds a special place in my heart since it's where my father was born and raised. Yet it's in my capacity as a civil lawyer that I'm here today and delighted to participate in this panel. So today's conference is aptly titled Dispute Management in a New World. Yes, indeed, it's a whole new world we're living in, all of us, since a few months. A world where we had to adjust a way of thinking, a way of working, a way of doing business, and the way of resolving disputes. And in fact, all dispute resolution processes have suffered some kind of disruption as a result of the pandemic. Some systems have fared better than others, whereas in general, arbitral institutions and arbitrators were quick to adjust to the new circumstances, adapting procedural timetables and holding hearings virtually, as the previous panel discussed. It took more time and efforts for state courts to adjust to this new reality. And here again, some jurisdictions fare better than others. In the UK, for example, according to some statistics, already in early April, about 85% of civil proceedings were continued remotely, with hearings being held either by audio or video link. In Switzerland, courts were slower to adjust, yet they had to, and now they also hold some of the hearings virtually. Now, courts throughout Europe slowly resume their operations, but the backlog and associated delays caused by the pandemic will be long felt on the judicial system. And as Mr. Delroy Chuck, the Minister of Justice of Jamaica, explained this morning, some cases in Jamaica had to be listed as far as 2025, 2026. So faced with these difficulties, should commercial parties turn their back to the courts? As tempting as the proposition to jettison the courts may sound, I submit that it is, even in the present new world, not realistic, nor even desirable. And there are in particular two reasons for this. First, in some instances, commercial parties simply cannot afford to jettison state courts. And second, in other instances, commercial parties would be prevented from jettisoning the courts. Let me briefly explain this further. So first, cases in which commercial parties cannot afford to jettison the courts, they, in my view, fall in two categories. First, cases where commercial parties need the imperium of the state courts. Indeed, there are, and there still will be, situations where commercial parties will need to resort to the imperium of state courts. For example, even if arbitral tribunals have the power to issue interim relief, well, they don't have the authority to enforce them, at least in my jurisdiction. So parties and arbitral tribunals will have to turn to state courts to have their assistance in enforcing these measures. There are, of course, other examples that we're all aware of. For example, the appointment, the removal, challenge of an arbitrator, the certification of an award, or importantly, the judicial review of an award. So these examples show that it's utopian to think that we can simply jettison the courts. In my view, it would be even dangerous for ADR to operate in a vacuum without the high supervision of state courts, in particular with respect to the safeguard of basic procedural guarantees. The other category where parties cannot afford to jettison the courts is literally where they can't afford it, because we know that alternatives to court systems, in particular arbitration, do not come cheap. I mean, contrary to state judges who are paid by the states through taxpayers, arbitrators and mediators are to be paid by the parties. And fees of the arbitrators, combined with the administrative cost of the administering institution, can be prohibitively expensive for parties, even commercial parties, like small businesses, for example. So in such situation, obviously, we can run into a constitutional law problem with respect to access to justice, basic access to justice. And even that can lead to a situation where a party could successfully jettisoning the arbitration agreement that it concluded to nullify it in favor of state courts if it proves that it really prevents it to go and have access to justice. The other category of the cases that I wanted to briefly mention is cases where parties are prevented from jettisoning the courts. And this is mainly concerns arbitration and the issue of arbitrability. As you know, it's the prerogative of each state to determine which sort of disputes can be arbitrated. And it may be that public interest command some exception to arbitrability to ensure that certain types of disputes are settled within the court system and not through private justice. But usually in arbitration-friendly jurisdiction, arbitrability is broad and far-reaching. For example, in Switzerland, all disputes involving a financial interest may be the subject of international arbitration. So commercial parties are in principle safe to submit their dispute to international arbitration, but one must be wary of possible exceptions, such as, for example, in the area of bankruptcy proceedings, such as declaration of bankruptcy, which unfortunately may become particularly relevant in the coming month. Also, in some jurisdiction or in Swiss domestic arbitration, employment disputes are not arbitrable. So although in these areas, parties could still resort to other ADRs such as negotiation or conciliation, they will have no option but to go before state courts if they reach an impasse. So in my view, I believe that instead of seeking to jettison the courts as a matter of principle, one should seize the opportunity created by the present context to entice parties to reflect on the various dispute resolution methods at their disposal and to foster a greater interplay between those various methods themselves and between those methods and the judicial system. And in this view, I see three important focus areas. First, the promotion of hybrid dispute resolution clauses. Second, an increased use of ADR methods by state courts. And third, the training of adjudicators in ADR. Let me briefly take these in turn. So first, the development of hybrid dispute resolution clauses. I submit that now is the best time for parties to make a review of the dispute resolution mechanism in their contract and carefully assess whether it is the best suited dispute resolution mechanism in view of their needs and the changed reality of the new world we're living in. Especially when the contracts do not provide for a specific dispute resolution clause or provide for litigation, now is the time for commercial party to interrogate themselves whether they really should go before state courts or whether they should not devise some more creative, multi-tiered dispute resolution clause that really fit to their needs. An interesting study that was conducted during the Global Pound Conference series has shown that there's a growing interest for the use of mixed modes of dispute resolution, in particular those that combine adjudicative and non-adjudicative processes. And such interest will surely grow in the future. And already several arbitration and mediation institutions have enacted rules providing for various bridges or links between, for example, mediation and arbitration, including JIAC, whose arbitration rules provide that where parties have referred their dispute to mediation under the JIAC mediation rules and have failed to reach a settlement and thereafter proceed to arbitration under the JIAC arbitration rules, then half of the administrative costs paid to JIAC for the mediation shall be credited towards the administrative cost of the arbitration. So arbitral institutions will play a key role in facilitating the possibility for parties to resort to hybrid dispute resolution methods. External counsel, of course, will also play their part and bring awareness to their clients about the possibility to combine these methods with additional benefit and value for them. I personally believe that there's a real alternative to the courts to which the parties could turn to without jettisoning the courts altogether. Second, the use of ADR methods by state courts. In my opinion, courts will not have to be jettisoned if they adapt to the new world we're in. In her recent lecture at Harvard Law School, to which Dr. Christopher Malcolm has referred the panelists, Justice Rosalie Silverman Abella made a forceful and compelling comparison of the North American court system between 1906 and today, concluding that we still resolve civil disputes the way we did a century ago. Generally speaking, a similar conclusion can be reached on this side of the pond. Courts and in the judicial system in general tend to be conservative, and it takes time to change the way things are being done. However, in Europe, things are slowly changing. In fact, in the EU, ADR has been tagged even before the Corona crisis as a political priority, which is promoted together with online dispute resolution. This is reflected in particular in the Green Paper on alternative dispute resolution in civil and commercial law and on various EU directives. In Switzerland, there's also a similar trend and a desire from the legislator to encourage amicable settlement of disputes. So we had a revision of our Code of Civil Procedure in 2011, which introduced a mandatory preliminary conciliation procedure for certain type of proceedings. And in Geneva, this has led to 30% of the case being settled. There's currently another ongoing revision of the Civil Code of Procedure, which envisages an extension of this mandatory preliminary conciliation procedure before the courts. And already before that, there was in some parts of Switzerland a long-standing tradition of state court judges acting as settlement facilitators. This in particular originates from the so-called Referentenaudienz in German, which is a preliminary hearing where the judge from it took place in Zurich before the Zurich Commercial Court, where the judge in charge of the case would give his or her preliminary view to the parties, would give them where he saw the strength and weaknesses of each of the parties' case. And this led quite to an efficient result, because approximately 70% of the cases settled after the so-called Referentenaudienz. Such practice was then imported in domestic arbitration, in the arbitration rules of the Zurich Chamber of Commerce. They no longer exist. They've been replaced by the Swiss rules of international arbitration, which also provide for the possibility of the arbitrator to act as a settlement facilitator, however, only with the agreement of each parties and on the understanding that such agreement by a party will not constitute a waiver of its right to challenge, shall constitute a waiver, sorry, of its right to challenge an arbitrator's impartiality. So the situation has to be clear that if an arbitrator wants to act as a settlement facilitator, it has first to ask the parties and have both parties agreement, who then consent to waive their right to challenge the arbitrator for his or her participation in such a process. Of course, there's a concern that the judge engage in such a settlement facilitation risk to prejudge the issue. And I understand that in some jurisdiction, notably in common law jurisdiction, well, we couldn't really have that system because there would be such a concern that the arbitrator would be exposed to a challenge. But I believe that this would be also an effective alternative to the court system. And the third and last point I wanted to touch on is the training and awareness, because it seems to me that the greater hybridization of dispute resolution methods calls for really the importance to train judges and to train our arbitrators in ADR methods such as conciliation, arbitration, mediation. These various ADR methods require different skill set, and one cannot improvise oneself a mediator or a conciliator if one has not done that before. Such training requirement is, for example, expressly set out in the European Code of Conduct for mediation providers, and one can even ask the question whether it should not be compulsory for those who want to lead an ADR procedure to show some accreditation of a training before an appropriate professional body. And lastly, awareness is key, as James Macpherson forcefully explained before. Awareness and education will be key to provide also a meaningful alternative to the courts. Thank you, and over to you.
Thank you, Alexandra. Thanks, Alexandra. And you know, it is good to have a team of the world's best as panelists, and they really are. I'm not saying it just because. And we will now, without further ado, ask Pat Cheltenham, who I believe may have already been introduced, to make his presentation.
Thank you very much, Christopher. Greetings from an overcast Barbados, but overcast with African dust. I miss my Jamaica because I miss my Jamaican Blue Mountain coffee and condensed milk. So you should try to get COVID-19 to go away so that we can return to our usual stomping ground. I really do miss it. Now, I have as my topic, well, as the topic, should commercial entities jettison the court system? And I start by positing that there are two unstated assumptions in the question posed. The first one is that the court system represents abysmal failure to business persons. And the second one is that there's in place a dispute resolution system readily available to accept and manage the wholesale transfer of commercial litigation if one were to jettison the courts. Now, in order to explore the unstated assumptions which are implicit in the question, a prior question, in my view, has to be explored. And that question is, who really are the consumers of legal services? And let us start by examining these consumers. The first or principal consumer is the litigant client, who is seeking access to the court system to resolve his issue in hopefully a speedy and satisfying manner. And the second consumer is the lawyer, who renders professional services to the litigant to achieve a resolution of his issues from the designated court. Each party will be keen to enter the system and to exit with minimal delay, armed with a decision that hopefully brings some measure of satisfaction. But the question is, does this really happen? My observations of the court system, and I'm confining myself largely to the region in which I have some familiarity. My observation of the system are that it has very few barriers to entry, but several obstacles to exit. Thus, the question posed, should commercial entities jettison the court, is not as iconoclastic as it would appear at first blush. Generally, there are certain unmistakable features that characterize the courts in the Caribbean, and I do use the word generally. The courts are, for the most part, under-resourced both financially and in terms of personnel. The techniques utilized to resolve disputes frequently leave both parties equally disappointed in the result, and this stemmed invariably from the protracted delay between entry into court and leaving court. And then you have delays of an inexplicable kind, which can take the form of protracted processes before one arrives at trial, 2, delays in completing the trial, and 3, worst of all, inexplicable delays in receiving judgments. Now, these features broadly represent the reality of the court system throughout the Caribbean, but let me hasten to add there are at least 2 jurisdictions, Trinidad and the Organization of East Caribbean States, which have deviated from this trend. And Trinidad in particular has brought on many modern techniques of management to its court system. And even a few years ago, when we had the introduction of new civil procedure rules in almost all, I don't think they're in Bahamas, that has not resulted uniformly in the qualitative improvement which heralded their implementation. So that the 2 consumers above identified would be inclined to jettison the courts and look elsewhere. And the next question I have to consider is, where is elsewhere? The third unstated assumption in the question is that there is a place where the disappointed litigants can proceed to seek redress for their grievances. And on reflection, the system of ADR offers itself as the obvious place to which their grief can turn for assistance. It has useful choices: mediation, arbitration, expert determination, negotiations. And one of the positives of that is that it offers parties a say in the selection of appropriately qualified persons to assist in resolving matters. And they can also participate in the design of the process that underpins the resolution of the dispute. But the next question to be posed is, what must be done to give momentum and credibility to the ADR process? I start with a point which Alexandra touched on: the training of judges, lawyers, court personnel, and the sensitization of the general public. And training means retraining. Then there must be, secondly, a fundamental recast of the rules of court to incorporate such features of ADR as the policymakers may deem necessary and useful. And thirdly, there must be the simultaneous upgrade of all arbitration and mediation statutes and rules to bring them into a modern environment, a la Jamaica, certainly on arbitration, or the BVI. Fourthly, there must be a formulation of the rules to take account of the altered environment in which legal services will now are now being delivered and in the foreseeable future. And then there must be, fifthly, an introduction to the court process of a well-defined legal business model, such as there is in Trinidad, to constitute the platform for the delivery of legal services. So in summary, these dispute resolution methods on their own or conjointly cannot realistically resolve the huge volume of litigation which may be jettisoned from the court, but structured in a manner that recognizes their valuable role and incorporating them expressly into a repurposed court system, they can be the basis for qualitative and quantitative improvement in the delivery of commercial legal services. Those are my points. Christopher?
Thanks, Pat. And again, thank you, Pat. Now, what we've heard three presentations from three diverse perspectives, really. Carlos with a North American perspective primarily. Alexandra, who, notwithstanding that she's from the civilian background primarily, she's also qualified in the common law tradition and can speak to that as well. And Pat, who is speaking primarily from a Caribbean perspective. And we see that jurisdictions differ and approaches clearly differ with that as well. But I think what we have coming through is that there is some merit in at least considering the question of whether we should jettison the court. But more importantly, a recognition, I think, that we heard with all three presentations having been made, that speaks more to the value of complementarity. One in which the court is recognized as having a significant function that cannot and perhaps should not be easily, if at all, jettisoned, but a recognition as well that there are other systems and other available options that could well assist in making the process more seamless and more beneficial for litigants. We see, for example, in recent times in the UK and elsewhere, that their cabinet there has recently, for example, determined that parties should make better use of alternative methods of renegotiation, mediation, and so on, particularly at this time, to resolve their disputes. And we see coming out of their UK Supreme Court an indication that they want some breathing space for the court, particularly now when a lot of matters have been heaping up on them. And it is in that context why we throw it out to us all to determine not so much that we should get rid of courts, but how it is that we may better repurpose them, particularly bearing in mind their overwhelming importance having regard to public law issues, which are not at all feasible to be dealt with in ADR usually, and even if they go there with significant limitations anyway. And I think it is in that context why we will throw out the questions to the floor, as well as between the parties. And perhaps I could start with you, Pat, even before I see any other questions coming through. Based on what you have seen over your last many years of practice in the Caribbean, and I know your recent conversion, I would want to put it, your Damascus Road experience into ADR, what do you now think of your erstwhile legal practice experience, primarily at the bar in litigation, and what you now see as the approach going forward that ADR could help with for the benefit of litigants or disputants?
Well, let us start way back in 1978, Chris, when I started. We had a very small judiciary in Barbados. In fact, it was a bit of a laughing stock. We had 4 judges, and they constituted both the First Instance Court and the Court of Appeal. And that wasn't altered until the early 90s. And small as it was, it delivered. So that I became, in my early career and for quite a while thereafter, an early convert to the court system. It worked sufficiently well that my brother and I, with whom I practice, we would target 5 matters every year to get them fully into the system for trial and get them out of the system. And you could actually have an income stream called high court litigation. Sometime in the 90s, after the courts, a separate court of appeal was created, one started to notice some rather unhealthy trends, which culminated into you start to see delays, inexplicable delays, not necessarily from the Court of Appeal, but from high court judges and disgruntled clients and lawyers recognizing that if this trend were not halted, it was going to be difficult to continue to make a worthwhile living at the bar, which is precisely where we have reached in Barbados now. And there is dissatisfaction with the bar, with the pace of matters in the court, but you cannot get out. And we haven't yet, unfortunately, made the full transition over to ADR. They're still tentative. We are very tentative in our movement there. We have tried mediation with some measure of success, but I think the problem there is the bar. A lot of lawyers see it as a threat to their livelihood. They don't see how it can assist in the resolution of disputes in which they're part of. And indeed, in one matter in which I was involved, which was, let's say, 2 steps away from resolution, the lawyer recognized the client was having a significant say and that his role had been minimized. And typically, he just responded and broke up the entire process, and the matter is now dragging its way through the courts to the satisfaction of no one. So we have still to come a long way over into the ADR. I would say, thanks to you and the others, we have an impressive cohort of lawyers who have been trained in arbitration, less so in mediation. So we have to increase those who are being exposed to a mediation. And hopefully in another year or so, we may just have on board enough qualified persons to offer a high quality service. But the court system of itself has almost come to a screeching halt in several areas, which is very, very sad, because it means you have highly disgruntled litigants out there, and hence my point that they would not be reluctant at all to jettison the court system. But we all know that in reality, you're going to still have to rely on it. So that's my
And I suppose that's a good point of departure almost when we're looking at what is happening in the Caribbean, and perhaps from another perspective where Alexandra is from, where she's at least in a system which appears to be working much better than ours, with delays and so on not being as much of a problem. Perhaps there may be lessons there that Alexandra could point to speak to more pointedly, that we could ourselves look at in a common law context, whether or not, for example, the question is whether the civilian tradition by its very nature makes it easier for, the move into greater use of ADR and better use of that for the movement of matters through the process. And perhaps Alexandra could comment upon that and her own experience, primarily because she has experience in both traditions.
Thank you, Christopher. Let me perhaps first just go back to an important point that Pat has mentioned, which I also witnessed in my jurisdiction, is the resistance of the lawyers to move to ADR. And I must say that this is not only that I've witnessed that among lawyers that do litigation before state courts, but also from arbitration petitioners that tend to sometimes dismiss mediation and other form of ADR, thinking it's maybe a waste of time or it's not lucrative enough. And I think we should really work on also going against this resistance, but I think we'll be forced to, because there's going to be a huge push in that direction, also by in-house counsels and users that are just, want other forms of dispute resolution than litigation and arbitration. And I was speaking to an in-house lawyer recently who had conducted a survey amongst in-house lawyers in the Geneva area, And they were unanimous in saying that they had more better results in direct negotiation with their counterpart than in going in arbitration or even mediation. And in the current context, this is a trend that we'll get to see more and more. But coming back to your question, Chris, I believe that, yes, some examples can also be taken from the civil law system. As I explained in my presentation, the culture in the civil jurisdiction is a bit different, where, as you know, we have an inquisitorial system where the judge takes a more sort of proactive stance than in common law system, which is adversarial, and the judge, I'm exaggerating, but sits there and let the parties fight and just come out with the judgment at the end. And I think, and that's also the beauty of arbitration, where there's a mix of cultures, where actors and lawyers and arbitrators come from different culture, and we can learn from one another, and perhaps through this means common law lawyers hopefully could also go a bit in that direction of providing adjudicators, be it state court judges or their arbitrators, with the courage of taking a more proactive roles in facilitating settlements among the parties. So perhaps I would say going more into that direction of settlement facilitation. I don't hear you, Chris. Still not.
You're on mute, Chris.
Sorry, are you hearing me? I suspect you are. There is a comment I see here coming from Elaine, that in the context of Jamaica, there appears to be some level of resistance from lawyers to the use of ADR in its more expansive vein. And I suppose the question coming out of that, and perhaps Carlos, you could look at that, bearing in mind your own experience in Florida and elsewhere, what it is that can be done to get more lawyers on board and more supportive of the process. And I particularly mentioned that to you, Carlos, knowing that Justice Silverman, for example, who has made significant comments, he's a great pusher, as you know, of mediation in the context of Florida, about how helpful and useful it has been in dealing with backlog and related issues in Florida. What is it that can be done to get lawyers more on board? And how can they be incentivized, if that is the right word, into understanding the benefits that could accrue to them from greater use of dispute management and ADR in its broadest sense?
Well, thank you, Chris. In Florida, I think as many of you know, about 7 or 8 years ago, maybe more, maybe 10 years already, we developed a division of our complex commercial litigation division that focuses only on arbitration cases. So we have 3 or 4 trained judges, and have been trained by various institutions to hear arbitration cases. So all the arbitration related cases, interim measures, these gatekeeper issues that are referred to earlier, confirmations of awards, all types of cases that have to do with ADR get referred to these particular judges in our judicial system. And as a consequence of that, not only are the judges trained, but the lawyers who have to appear before them feel the need to be trained also. So I think training is one critical component, both for the judges and for the lawyers. But I think as Pat mentioned in one of our preliminary sessions, we have to also convince the judiciary and the lawyers that they can make a living out of this, that getting involved in ADR, getting involved in mediation, getting involved in arbitration cases doesn't mean that they're going to be out of a job. There's a role for them to play also in that context. So those are important categories that I think are responsive to your question, Chris. If I have just another minute, I wanted to just briefly talk about the arbitration process in general and the remote mediation, remote arbitration process, whether you call it virtual or not. And just simply point out also that, as we know, under the New York Convention, inappropriate or unusual or problematic procedural process can lead to the setting aside of an arbitration award. And that's under Article 5, 1B and 1D. The point is, however, that very, very few cases have been heard that challenge the arbitration award or the finality of it based on the fact that it has happened through a remote or virtual session. There's only one case that I know of where that issue was addressed, and that was about 6 months before the pandemic hit. And in that case, the court held that the fact that parts of the hearing were held remotely was not a problem, and that was not a basis for setting aside the arbitration award. So that goes into the training part also, and the fact that the judges and the lawyers need to understand that what we're doing now here and what we have done before already, I'm sure many of us have, in hearings and in mediations via remote proceedings, is an appropriate way, provided that the basics of due process are observed. So that's, I guess, part of the answer that I have for your question, Chris. It's training and convincing the lawyers that they can make a living out of this, and that the virtual and remote world, many of us think is here to stay.
Still on mute, but there are two things, Carlos, in relation to the last point you made, which I'd like to bring to the fore and to have your thoughts on. One is that there's a recent decision coming out of the Turks and Caicos Islands, where their court has effectively indicated that while you may have virtual, even if virtual is possible, let me put it that way, virtual still requires that your judge be in the Turks and Caicos Islands. And that if you're outside of it and virtual, then you're not, effectively what you're doing is not in keeping with what is required. But more importantly, from an arbitration perspective, under the LCIA, London Court of International Arbitration Rules, for example, if you look at Articles 14 and 16 and others, there's specific reference and requirement that the hearing, even though there's some latitude given to the arbitrators in terms of venue, there's specific reference indicating that the venue shall be at a geographical location. That is a language use, a geographical place is the language actually used under those rules. How do you then, where you have one party who may not want the process to go on and is insisting that I'm not going with anything virtual, how do you then deal with those difficulties in the context of the current situation that we're in? And is this a matter that an arbitrator could then proceed and find that there's a significant procedural defect in any decision that has been made?
I think, Chris, that notwithstanding, that rule, LCI Rule 14 in particular, the ICC rule has, ICC Rule 22 has a provision similar to that one. The UNCITRAL rules, I think UNCITRAL Article 15 also has a similar provision. I think that at the end of the day, those rules will be read in the context of due process as that concept is defined in the seat of arbitration, or where it is that the arbitration is going to be confirmed, or vacation of the award is going to be sought. So as long as the judiciary at the end of the day looks at the virtual proceedings or remote proceedings and applies a due process lens to it, I think those rules will be adapted to fit the due process conclusions that the judiciary makes. And in my opinion, I think it's going to be hard for most courts to set aside an arbitration award, provided that the arbitration hearing, virtual remote, is conducted with a modicum of due process and fairness and an opportunity for the parties to present their case. And I think in part that's going to be because of the fact that the courts themselves right now, certainly in the US and in many, many countries, I think perhaps most countries, are having hearings remotely. So it would be a bit hypocritical for the courts to say, We can do virtual hearings, but you, the arbitrators, cannot. So I think that, in answer, Chris, I think at the end of the day, we're going to see a broader acceptance to the role of the arbitration tribunals in a remote or virtual setting.
I mean, in the last minute that we have, I mean, just in response to that, Carlos, and there's a comment, and you could all three think about it in the interim, that has been asked about commenting on the enforceability of online arbitral decisions or virtual arbitral decisions. But there's something, though, in relation to what you just said about the hypocritical nature of the courts, in and out of the courts, because we have always operated on the basis that while the courts are constitutionally able to make all sorts of decisions because they have a constitutional right of access and all the things related to that, the courts have traditionally operated on the basis, and we've seen enough decisions at appellate and other levels indicating that while there may have been procedural defects, if the substantive decision is good, then you can overlook the procedural defects to get there. But we've always in arbitration operated, however, on the basis that where parties have given up their constitutional rights of access and so on, then the least they are entitled to is due process and a recognition that whatever they have contractually agreed to must be adhered to strictly or be itself a basis on which a decision could be challenged. So I think that is a struggle I suspect that the courts will have to look at, notwithstanding what they are themselves doing. It is a question of where arbitration or mediation or whatever else is accessed simply because it's a contractual right that persons have agreed to. How do you then, as a court, do anything except enforce the contract as has been strictly agreed to? And of course, if people have agreed to rules, those rules are by extension accepted as part and parcel of the terms of their contracts.
Yes, Chris. I suspect that as we sit here today in our respective offices or homes, there are probably very, very few arbitration clauses that contemplate or specifically address whether hearings can be held remotely or virtually. I suspect that most of the clauses that trigger arbitration are silent on that issue. So given the fact that they are probably silent on that issue, it's going to be left up to the arbitration panel to conduct the hearing in a way that it determines to be efficient, effective, and consistent with the principles of due process, especially when the alternative is to not have a hearing or to delay it to such an extent that, well, why even have it eventually, right? So you've got to balance the interest of delaying justice to the point that it becomes ineffectual with the other point of trying to advance it in an efficient, cost-effective manner. So I think that as long as the contract clause doesn't specifically address whether you can have a hearing remotely or not, and if it's silent on the issue, I think that the arbitration panel is going to have very broad discretion to do it in a manner that's fair, appropriate, and consistent with the norms of due process in the local jurisdictions.
Okay, it is for me now, and I know there are quite a few other questions that I'm seeing in the chat box, but unfortunately we have run completely out of time. Again, my apologies for having lost power and with it my Wi-Fi service at the beginning, but I must thank the panelists for what I think was a very well presented session, and thank you in particular for having taken it in stride and dealt with what we had promised that we would do, which is to continue the show going on with or without the moderator in place. And we thank you again, Pat, Carlos, and Alexandra, for what I think was a very, very good panel. And on behalf of all the participants and persons looking on, I want to thank you again for that. Now, prior to going into handing over to Derek, who will chair our closing session, I think there are some important people being our sponsors that we really need to highlight, and this will be done while Derek gets his team together for the closing session. Thank you again for a very good session.
Thank you all.
Thank you, Chris.
Colleagues, I'm not sure how to get the team together.
Well, Derek, you simply call them as you will because everybody's on. It's literally. Sharing. It says sharing, but nothing is coming up. No. Anyway, proceed. Do it afterwards. Stop it. It's gonna have very good. Afterwards, we do it. Yeah, but
Will you tell me when you're ready, Chris?
we're ready, Derek. You may
begin.
Yes, you may.
Or you will begin. I'm not sure where we are.
No, we're at the very end. It's for you now to take over your speaking session.
Thanks very much. Good afternoon, colleagues. We are at the end. I'm not sure how many of you realize you have been sitting here for what, 7 hours? You know, one chair. But it has been a remarkable experience, a wonderful experience, very, very informative. And of course, you know, we see that Chris and his team has actually done a great job bringing together this information for us. But all good things must come to an end. And as we used to say in the olden days, that we'll save the best wine for last. So we're about to close the session. What is the replacement for arbitration week? And we have a number of persons who will be joining us and helping us through it. We have Ms. Diane Edwards, Mr. Maurice Stoppy, and Ms. Dance Penn, and I'll introduce them in a few minutes. Of course, after they have spoken, we'll have the vote of thanks by Mr. Dean Barrows, and before he speaks, I'll introduce Dean for those who do not already know him. So in a few minutes, we'll hear from Diane Edwards, the president of JAMPRO, our principal face, if you wish, on promotions, investment promotions in Jamaica. She is the face, and perhaps the representative. We can't, if we think of local investment and export promotion, her name comes first to Jamaicans. And it's not unlike that many of you from overseas would have in fact known of her as well. She's a phenomenal manager and leader. She has come to JAMPRO from Jerry and Nephew, and I'm not sure if my heart is broken because JAMPRO's gain is Jerry and Nephew's loss, and I have a very special place in my heart for Jerry and Nephew. But it's the experience I think she brings, the knowledge of industry, the knowledge, of course, of what it means to work in these difficult times, and of course the recognition that as she performs her work and as she encourages others to do what they should be doing, invest in exporting, there will be disputes and we need ways of reconciling them and managing them. So in a few minutes, I'll call upon her to lead us to say what she should say to bring these proceedings to an end. After Dan speaks, we'll call upon Mr. Maurice Stoppy, who is, without any question, the Dean of ADR in Jamaica, both as a practitioner and as a mentor and as a scholar, and as an innovator. I mean, some of the things that Maurice has done, is simply remarkable, and we trust that the broader industry, the broader practice is picking up on it. The promotion, for example, of using adjudication as an essential mode of settling small disputes in complex contracts is something that is promoted, that is written on, is taught, is encouraged, and is pretty much the authority on. Maurice has had, as you would expect, a whole host of national honors in Jamaica and abroad. He holds the Order of the Holy Cross from His Holiness, Pope John Paul II. He's a centenary medalist of the Institute of Jamaica. He is a commander of the Order of Distinction from Jamaica, and the list goes on and on. I think his greatest honor, however, must be the great affection in which he is held in the hearts of most arbitration practitioners in Jamaica. And we'll call upon Maurice in a little while. Maurice's experience, of course, principally is that of a chartered surveyor, but he has been at the forefront of dispute resolution for the longest while. And of course, after Maurice, we will call upon my dear friend, Mrs. Dancia Penn, who is remarkable in every way. I don't know how I could effectively communicate it. She's taught every aspect of her profession. She has been a Court of Appeal judge. She has been an Attorney General. She's an acting and deputy governor. She has been a minister. The list goes on and on and on. You know, but of course, from our perspective, that she has been a stalwart in not only in litigation and dispute resolution, but in promoting arbitration, especially for the last several years. And many of us owe her a great deal of gratitude for what she has done and is in fact doing. My own part, of course, I bask a little bit in the glory, because Dance and I were at university and law school together. So that's my claim to fame. But of course, we will ask her to help to close these proceedings. Now, after our colleagues have spoken, I'll come back, of course, introduce you later to Dean. So I'll start now by asking Dan, if Dan will come on, please.
Yes, I'm on, Derek. Thank you very much. Thank you very much for those kind words. Very kind of you, and Ray and Neville, of course, and all its expressions in the Appleton Estate Range have a very, very close relationship to my heart and my throat. I feel like I am standing here really with at a disadvantage, speaking to all these experts in global and international law. And I just wanted to say good afternoon to all of you. I hope you've had a very rewarding day. I've been looking at the chat, and from the comments that I've seen, people have really found this a very rich and rewarding experience. We at JAMPRO know that ADR is really something that we have to embrace as a country and as a region, because I think for us, any kind of business that we attract to Jamaica wants to know that resolution of disputes is high on the agenda, that we are a modern region in terms of the way we approach disputes, and we respect resolution of disputes, and we are modern in our approach to it. And that really means that in this period of post-COVID, which I'll come back to in a minute, you know, we have got to embrace the virtual world. I'll come back to that in a minute, but I just wanted, first of all, to applaud the efforts of the Jamaica International Arbitration Center, because I think Dr. Malcolm has done a fantastic job, he and his team. This is the third year that we have been involved in this conference, and we continue to be really impressed with the development, the professionalism, and the number of global thinkers that JIAC has been able to assemble for this event. We think it's really taken the whole ADR conversation to a higher level in the Caribbean. We also feel that what Dr. Malcolm has been able to do in pivoting to a one-day virtual conference has shown really his response to the challenges of the times, because we are all in a challenging time and we have got to embrace change. And I think, to be very honest, to my Caribbean colleagues, not those here represented, but the broader Caribbean colleagues, we don't see a quick and eager adoption of modern practices. And I think that that really is what is holding us back as a region from really embracing the potential that we have. The brain power we have in this region is phenomenal and equal to any region of the world. But we need to embrace modern technology and modern approaches to doing business. So in offering these few closing remarks, I wanted to say that in terms of the virtual world, you know, our new best friends at JAMPRO are Zoom, Microsoft Teams, and GoToMeetings. We have no way, and maybe Skype, we have no way to operate without that. Without that, our whole operation from work at home experience would have been a disaster. Because of those platforms and the one we're on now, Zoom, we have been able to maintain work from home, maintain a level of productivity that I think anybody would envy. What COVID-19 has done is really forced us all to rethink our business models and to reevaluate which services we can offer digitally. I think the whole question of arbitration and mediation that WIPO has been developing online is critical to this. And the session on innovation this afternoon was particularly apropos to that. And the last session in pointing the way ahead. One of the most interesting studies we have seen recently, done by Fortune magazine of global CEOs, revealed that the opinion of 51.1% of the CEOs surveyed said that business travel will never, never return to its former levels. What that means is that for all our professions, for investment promotion, for the legal profession, for arbitrators, for any kind of professional, we are going to see a massive reduction in face-to-face interaction and people getting on planes to do business. They will do it for tourism, but business means that we are all going to have to embrace online opportunities. And what's great for the Caribbean is that we have the opportunity to work with North America in the same time zone and to deliver services in a way that they also culturally accept, and that shows cultural affinity with the way North America does business. So we have a fantastic nearshore opportunity in the Caribbean, and this is what I expect us and JIAC to embrace. And I'm very proud to see that JIAC has embraced this and is working towards developing. What we have to do in terms of the government is to really reinforce the telecommunications because the vulnerabilities of that backbone, and I think Chris was a victim of it today, the vulnerabilities have been revealed. So we really have to focus on how can we develop our value-added services and our bandwidth to broadcast those services and to serve the world. There's a huge opportunity to both our SMEs, our exporters, and our investors of having a robust ADR mechanism which people can access online at any point in time of day or night. So this is where we think the transformation has to go. In Jamaica, we have embarked on a huge transformation program, which we call the Business Environment Reform Agenda. And we are projecting to get into the top 10 ranking in the Doing Business report. And one of the critical elements of that is the whole question of resolving disputes. So we really congratulate JIAC. We think that this has been a tremendous success today. And I know that you've had over 500 people subscribed, which is phenomenal. We think this is a very exciting area for us to use our Caribbean expertise and leverage our expertise to become a true hub for international arbitration. So we really wish you continued success in this endeavor, and we pledge the continued partnership of JAMPRO in building new dispute resolution business for Jamaica and for the Caribbean. So thank you very much for inviting us, and we will continue to be an ardent supporter of JIAC. Thank you.
Thank you very much. Now, colleagues, I will call upon the person who would call our dear leader in the ADR environment. Maurice, will you come and give the close remarks, please?
Yes. Can I be heard now?
Yes, yes, we're hearing you. Go ahead.
Well, that's good. Good. Well, thank you very much, Derek, for those very kind words of introduction, none of which I really deserve, but I thank you nevertheless. The concept of having such a conference is to the great credit of the Institute, the Jamaican Institute of International Arbitration, and it will serve as a template, as Diane Edwards was saying just now. I think it will serve as a template for future activities, not just here, but in the wider range of the Caribbean. Regrettably, the technology did not extend today to satisfy Pat Cheltenham's desire for a cup of Blue Mountain coffee. If we could have sent that by virtue through the computer, we would have done so, but we were prevented from doing that. We've had a wonderful session, wonderful meeting. I've learned an enormous amount from just listening to some of the best brains and the most agile, active practitioners in the process of arbitration. Before I go too far, I would like to express some personal thanks, if I may, to our friends from Malaysia who are with us today. The JIAC, in its beginnings, when we were thinking about putting things together on a formalized basis in Jamaica, which was one of my dreams from perhaps 20 or 30 years ago, we received a great deal of support from our friends Sandra and his cohorts from the Republic of Malaysia. And for that, we are really very grateful. And we hope that cooperation will continue. And hopefully we can eventually make it into a two-way system of mutual support. The other thing that I was absolutely fascinated by was the discussion on force majeure, because as a practicing arbitrator over quite a long time, this force majeure thing comes up, and it's to my great amusement to listen to jurists trying to persuade me or whoever they're pleading their case in front of the exact meaning of the force majeure concept. We have a rough idea what it means. I think most people do, including lawyers, of course. And perhaps one day there will be an international agreement on the precise meaning of that term. But I really have to congratulate also John Rooney, who was able to conduct his section with probably the foremost practitioners of the law, such as Edgardo and Rose Ramo, who I thought were absolutely wonderful presenters. Now, the next thing I wish to say, without taking up too much of the time of the conference, because I know we're almost at the end, is this question of adjudication. And again, I'm very, very happy to see it, first of all, as an item on our agenda, and secondly, that there's so much interest in the concept of adjudication, because it really goes to, well, first of all, let me say that it's something that I've been personally pushing, and I hate to use that word, it sounds madly commercial, but I have been trying to promote the concept of adjudication for many, many years. And when I first started in thinking about how people react in terms of disputes and why do we have disputes, I then turned my thoughts to dispute avoidance, which I think is a very, very important aspect of arbitration, mediation, and ADR in general. I believe that the avoidance of a dispute is almost, if not just as important as the settlement of the dispute itself. But perhaps that could be left for another discussion, another debate. But what I did find was years ago when, as I said before, I first started in this activity, I found that adjudication, or the reliance on a third-party neutral to provide instant decisions which were upheld by a more authoritative body, was really what the people wanted. That's what they're looking for. They were not looking for esoteric debates on the meaning of strange legal expressions or precedents of that kind. What they wanted was a quick decision, because time is money, to quote a cliche, and because in some cases, one had, certainly in the third world context of Jamaica, in which we practice here, I found quite often that in all matters of disputes, whether it's litigation or ADR, the question of who has the deepest pocket usually has the greatest chance of success, which to my ethical upbringing and background is totally foreign. I reject that concept. And so where the industry itself, this is a dispute resolution industry, where it itself can produce a system of equity in terms of providing solutions to people's problems and people's disputes, that is to be preferred rather than a system of whoever has the strength, perhaps one might call it, to appeal a decision or delay, as they used to have in the United Kingdom. If you remember, under the old Arbitration Act, there was a clause about stating a special case. Some arbitrators may remember that, they practiced in the UK. And what was inserted in the English law as a method of solving a problem turned into a mechanism for those who could afford it to delay the proceedings. And so every time a case was referred to, perhaps the House of Lords, for them to state a special or give their decision on a special case meant perhaps one of the parties has gone bankrupt in the meantime. So I'm very, very fascinated by the quality of debate and everything else in terms of the participants in that discussion on adjudication. Mediation comes into the same category, really, I think, and we had some excellent contributions under Sean Henriquez's guidance to do with the use of mediation as a part of ADR. And on the question of should commercial parties jettison the court, as a non-lawyer, as most people do know, I'm not a lawyer, even though it's one of my great regrets that I never had the opportunity to study that particular esoteric branch of human culture. Should commercial parties jettison the court? I wondered to myself, why is this an issue? I mean, how can it be possible to talk about living in a well-regulated ethical society without, as was practiced by our ancient forebearers, the ancient Greeks, who established the concept of democracy and also a system to support that? Surely the removal of the court itself from the process would be detrimental, in fact, undermining the system of democracy that we subscribe to. And so without delaying the issue too far, I just want to thank all of the participants. I know that Professor Burrows is going to do the job much better than I could possibly think of, but I do wish to express my personal thanks to all the participants. I've learned an enormous amount, and thanks, of course, to the organizers. And we hope that this will be the first of many. Thank you.
Thank you, Maurice. Thank you very, very much. Colleagues, I'm not sure if you know, but among members of the armed forces, and I suspect this is so for pretty much all uniform groups, there's a special bond among those who enter together, who enter in the same squad. We speak of them as our squaddies. And so I have the great honor now to call upon the most distinguished of my squad, the Honorable Lancer Penn, to give her closing remarks. Lancer, please.
Derek, good afternoon to you and good afternoon to everyone. Warmest greetings from here in Tortola, in the Virgin Islands, the British Virgin Islands. We date ourselves, Derek, but I'm honored to be part of your squad. And it truly is a pleasure to take part in this very important conference this afternoon. My dear friend, Dr. Christopher Malcolm, has very kindly placed me at this place to have, in effect, the last word. And I'm delighted to be here and to be in this particular position. But I want to begin by thanking Chris and the Jamaica International Arbitration Society and everyone for organizing, and as I've said, for inviting me to be part of it. As is known, I am a great supporter of the ADR processes, all of them, and of their development in the region. And I spend a fair share of my time these days in that cause. And participating in the annual Jamaica Week, Arbitration Week, has been an important part of my program for the last few years. And this year, thanks to COVID, Chris has taken it, Chris and the team have taken it to a higher level virtually. I'm particularly pleased to be part of this panel with, yes, the doyen of arbitration, in, not only in Jamaica, in the Caribbean, Mr. Maurice Stoppy. It's great to see you, Maurice, and Mrs. Diane Edwards. And let me say at the outset that I concur, and I concur unreservedly, with all the comments that Maurice and Diane have made on this closing panel. And I also have to say that so much of what panelists said, this very stellar panel of speakers have said today in the course of this conference, I agree with. The comments that Alexandra Johnson made, Carlos Concepcion, and Pat Cheltenham in the panel prior to this, I agree entirely. And in fact, much of what they said, I was intending to say as I now speak. But Derek, I would really like to couch my closing remarks really as a quick look at the future in this new world, and the future in what I term this new and evolving new world. In short, what I see is positive. What I see is a bright and an increasingly bright future for dispute management in the new world and in the new evolving world. Challenges there are, certainly there are, but challenges are opportunities, I believe, and it is on the opportunities for us in the Caribbean in particular on which I choose to focus as we close. There are many inherent opportunities, to my mind, for us in the Caribbean, in this new and evolving world. And I cite our diversity in our legal systems. We have civil law jurisdictions, we have common law jurisdictions. Diversity in language, English, French, Spanish, Dutch, Papiamiento, and others. Geographic diversity. Some countries are on continents, Guyana, Suriname, Belize. Many of us are islands. And within the islands, we have great diversity in size, in culture, in race, in gender, in ethnicity. We have Cuba, we have Jamaica, we have the smaller islands in the Eastern Caribbean, where I hail from, for example. We also have great diversity in our economies, and that is a factor of great significance. And in fact, much of the theme today picked up that economic diversity that is part of us. We also have a region where I think it's fair to say that women in particular have been very active and have much facilitated, in my view, institutionally in being part of the development of our ADR processes. But specifically now, what I'm going on to say, I really take from what the Honorable Minister of Justice, Mr. Gilroy Chuck of Queen's Counsel, a dear friend of 40 odd years, he tells me, Derek, I take my cue from some of what the minister said today. He spoke and he gave illustrations which Alexandra Johnson picked up in her presentation of the very serious delays in the justice system and with restorative justice in Jamaica. Pat Cheltenham picked that up, and both Minister Chuck and Pat Cheltenham could have been speaking for many jurisdictions in our region. Delays in the justice system, delays in litigation are a reality. And those delays have been exacerbated by the coronavirus and the COVID-19 crises. And for those of us, and none of us is exempt from it in the Caribbean, for those islands which have experienced hurricanes, we know very well about that. In 2017, I lived through 2 Category 5 hurricanes in a short 2-week period. And those factors create a number of legal issues, a number of legal consequences, and heighten the need, in my considered view, for more ADR and for more engagement in the ADR process and processes. But I wish to focus most of what I would say on the area of mediation, because I think in many respects, it is probably the easiest and the most cost-effective of the measures that can be employed by a wide range of users in the Caribbean. Recently, and this is post-COVID, what was referred to as concept note number 2 on the effect of the 2020 pandemic on commercial contracts was published by the British Institute of International and Comparative Law. It is essentially a call by several senior judges in the United Kingdom, former judges primarily, like Lord Neuberger and Lord Phillips. And it is essentially a call for a breathing space in dealing with disputes. The call is rarely for parties and not litigate. It is a call for parties to negotiate solutions to contracts affected by the pandemic, and I would add the hurricanes and natural disasters, and to seek to renegotiate and restructure disputes rather than relying on hard contractual rights and contractual principles. It is a call also to seek to bring contracts to a fair, balanced, and equitable. We can advise and seek to encourage parties to the known and proven benefits of mediation, the saving of time and costs, the relatively fast pace, all of which is now facilitated by virtual proceedings. And Diane spoke so well and so correctly to the importance of the virtual proceedings and the way that we have to improve our capacity to facilitate virtual proceedings. Mediation too, we should and can advise, helps to preserve relationships, which are so very important, both in economic and social terms, especially in our region. The saving of costs. I mentioned already the preservation of relationships. The opportunity that mediation provides for open, safe, confidential airing and expression of points of view and feelings. I was myself yesterday as counsel in a mediation here. Our mediator was not a lawyer. He was a retired professor from the University of the West Indies, actually. And it was very important in that process. It was a matter involving relatives, but each of them was able, in the confines of a room, to sit down and very freely and very openly say what was on their heart and what their issues were. And I believe in terms of the development of our countries and the resolution of building stronger and better societies, it is important that we promote and facilitate such opportunities for people. Mediation too, we ought to advise and seek to promote the fact that mediation helps parties to arrive at solutions that they want and resolutions that they want, instead of resolutions that are imposed by a court or by an arbitral tribunal or some other body. We also should help to convince people of the importance of being able to chart their own agreement, their own resolution to their matter, devoid of having to rely on judicial precedents and tight rules of court, the rules of arbitral institutions, and so on. The freedom to arrive at really a solution that allows them to continue to carry on their relationship, be it business, be it commerce, be it whatever it may be. And I think, Derek, it is incumbent on us to promote mediation as a relationship management exercise, as distinct from a hard contractual management exercise. On a sort of wider level, we all know that the models of truth and reconciliation commissions, the truth and reconciliation process has worked well in some countries. And I believe that in appropriate cases, we ought to also promote the truth and reconciliation process. And I believe that in the Caribbean, we are well placed to do that. I will not repeat what both Alexandra and Pat and Carlos and others have said about the importance of sensitizing lawyers, the legal profession as a whole, judges, the judiciary, and others, because I am of the belief that persons other than lawyers have a critical role to play in promoting ADR in our region. In the nature of our societies and our economies in the region, there are a number of, especially our social and economic structures, there's some particular areas in which effective dispute management will be increasingly required and will be increasingly important. I will not refer to all. I believe I must be nearing the end of my time. But some of these areas include climate change. And climate change is an extremely important matter that we in the Caribbean region, and indeed globally, have to engage in and become more sensitized to, I believe. ESG, environmental, social, and governance issues, all of these are key factors in measuring the sustainability and the social impact of investments. Again, given the nature of our economies, substantially tourism-based, financial services-based, though there are other areas, I want to pay closer attention to ESG. Food and food security and the supply chains. We saw that very actively during COVID, where even medical supplies destined from the United States for here in the Virgin Islands, and I believe for other jurisdictions in the Caribbean, I think Barbados, were intercepted. And as we continue in this new world and in this new and evolving world, I think that whole matter of supply chains for food, for medicine, for other essential goods, because we are a region that imports more than we export. I think we need to pay particular attention to those areas and to create the ADR capacity throughout our region and among peoples to be able to deal with those matters. I can say more, Derek, but I believe that I am at the end of my time. There is the area of energy in which we also have to pay specific attention and build capacity. We know about Guyana, and I've been involved to some extent with that effort and what's happened with oil, the discovery of oil there. Here in the Virgin Islands and jurisdictions like the Cayman Islands, where our economies are very significantly based on financial services. We are highly involved in foreign direct investment to many countries in the world. We need, and I am not speaking xenophobically here, I believe that the world is one place and that it is important that we build the capacity. But within the Caribbean, and Diane said this, within the Caribbean, we have capacity and we need to continue to build that capacity. We cannot be xenophobic. We cannot sit on any laurel. We have to continue to train, to retrain, and to remain current and to be able to perform at the levels and to the requisite standards. So it's been a wonderful day. I commend all the presenters on the very interesting and important range of ideas and thoughts and suggestions that have been presented. Chris, I commend you on your ongoing tireless efforts for ADR in the region. And I commend all of you for what you continue to do. And I certainly am a very happy and committed part of the process. Thank you all very kindly.
Thank you very much, Dancio. Colleagues, you've had the best wine in these capstone discussions that bringing us to the end of the presentation. And I'm sure you would wish for us to say thank you, not only to these closing speakers, but to all who have participated, to those who have made presentations, those who have led discussions, to Chris and his team who have provided administrative support for all of this. And you have selected to represent us in this discussion, Mr. Dean Barrows. For those who do not know, and I can't imagine, well, you're not from Jamaica, you may not know, but for those of us from Jamaica do know Dean as a committed supporter of ADR. He's a chartered quantity surveyor, a project manager, an adjudicator, and an arbitrator. And you'll, of course, seen the trend, of course, that maybe Maurice was the one who started this, of our quality surveyors, chartered quality surveyors becoming adjudicators and arbitrators. Dean has enormous experience, tremendous experience in the built environment, going to almost four decades. He's worked in the public and the private sector, both in Jamaica and the United Kingdom. He's a founding partner of the Jamaican firm Burrows and Wallace, chartered quantity surveyors and building economists. He is highly trained, deeply committed to his profession, and to his institutions that have trained him. He's an examiner at the University of Technology, and he is, as I said, one of our leaders in the arbitration profession in Jamaica. And I think he will represent us very well in conveying our gratitude to all who worked so hard to make today the success it has been. Dean?
Thank you very much, Mr. Chairman. Honorable Minister Delroy Chuck, Minister of Justice.
Dean, we're not hearing you. You need to check your mic or come closer.
Okay, I will check my mic. No, my mic.
Are you hearing me now?
We are indeed hearing you now. Go ahead, please.
Okay, thank you. Yes. Honorable Minister Delroy Chuck, Minister of Justice, Madam Justice Ingrid Mankatel, Mr. Jose Entrada Faria, who represented the Secretary of Tati UNCITRAL, Professor Velma Newton, Mr. Derek McCoy, Mr. Dan Edwards, Mr. Maurice Stoppy, Ms. Dacia Penn, and all the distinguished persons who brought greetings. It's my privilege to be asked to give the vote of thanks at the first Jamaica International Arbitration Center online conference, which I must say has been a resounding success. The topic, dispute management in a new world, could not have been more aptly chosen at this time. We can attest that we are experiencing the emergence of a new world, possibly hastened by the advent of the COVID-19 pandemic, but nevertheless, we must admit this singular event has altered the way in which we'll be going about our business from now on. Today, we wanted to know Jamaica is as active as ever. The moderators, Mr. Milton Samuda, John Rooney, Karen Goff, Sean Henriquez, Caroline Hay, and Christopher Malcolm, and panelists, which have been drawn from right across the world. They are all well informed and kept us riveted throughout the presentations. We all benefited immensely from their thought and what they had to say. We learned from the experiences of presenters practicing in some very interesting and far-flung places, and we really appreciate it, especially those who had to give up some of their sleep this morning. We received valuable insight into alternate dispute resolution methods, looking at the rules that are currently being worked on, especially those out of UNCITRAL. We were brought up to date with the latest advances and presentation methods in use. And in the end, we're encouraged to implement training for professionals entering this field. We're grateful to our sponsors who have supported this conference, and special thanks to the Jamaica International Arbitration Center, the Jamaica Chamber of Commerce, and our reliable and resounding organizing committee, especially to Dr. Christopher Malcolm, who is at the helm of the ship. To most of our attendees, to all of our attendees, to have contributed to make this event a success. It has been a pleasure seeing you in your interactions with our panelists and in our interactions with each other. And we hope you'll join us in our future events. Thank you very much.
Thank you very much. Thank you very much, Dean. Colleagues, I'm pretty sure the last word can't be mine. So is Chris around? Could you?
I am Derek, but I did expect the last word to be yours.
I think we need to acknowledge how really impressed we are indeed how satisfied we are in what you have achieved and what you and your team have achieved. We recognize, of course, that we were faced with the worst possible challenge. You know, the COVID-19 pandemic and what it meant, and your plans for months and months, from last year, in fact, to get Arbitration Week, you know, running. I had it in my diary, as I'm sure we all had. And then the realization, of course, that it would not happen, the deep disappointment. And to see you come from what must be the absolute depth of despair to get us this one-day workshop, which has kept us riveted. As I said, I've been at my chair now going almost 8 hours, literally. We have, as we speak, 2/3 of our maximum attendees. And recognizing, of course, a large number of them came from jurisdictions where at this point they should be in bed or waking up for work. You know, we've done very well indeed. And this success must be clearly and unambiguously laid at your feet. I'm very happy with the proceedings. I'm very proud of your accomplishment. I wish you and the Institute every success. And I know, in fact, you'll lead us to greater and greater heights. Thank you very much, Chris. And colleagues and friends, thank you very much for your participation. Dancer, my love, my squaddy, so happy to see you.
Thank you, squaddy. Very best.
Goodbye, colleagues.
Bye.
Bye.